Oh, okay. Oh, okay.
Good morning, Acting Chief Justice. All parties are online.
Okay.
May I ask the clerk registrar to call the case?
Will the clerk please call the case?
Good morning. I am the registrar clerk for this hearing. Acting Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of Electoral Commission of South Africa and Minister of Cooperative Governance and Traditional Affairs and others. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the court. My learned friends, Mr. Budlander, Ms. Kentridge, Mr. Mkiwa, Ms. Poe, and I appear for the Electoral Commission.
Thank you. Thank you, Mr. Trengle.
May it please the court, my learned friends, Mr. Tsetlo and Ms. Dladla appear for the first respondent, the Minister of Cooperative.
Thank you very much, Mr. Manechi.
If it pleases you, Acting Chief Justice, Justices of the Constitutional Court, Ishmael Jamie, appearing with Mashada Adhikari for the member of the Executive Council for Local Government in the Western Cape. Thank you.
Thank you, Mr. Jamie.
Mr. Acting Chief Justice, I think I'm next in line. I'm Mr. Steyn. You asked me to point that out, Mr. Acting Chief Justice, and I appear with Mr. Ramokhale for the ANC, the first intervening party.
Thank you, Mr. Steyn.
Acting Chief Justice and Justices of the Court, I appear for the second intervening party, the IFP, together with my learned friends, Mr. Veerasamy and Ms. Nicol.
Yes, thank you.
Justices, Acting Chief Justices, Acting Chief Justice, I, together with Mr. Bishop and Mr. Tsele and Mr. Cohen, appear on behalf of the Democratic Alliance for what I think is the third intervening party.
Thank you. Thank you, Mr. Du Plessis. Is the next one who is appearing? I didn't think that was all of them.
Yes, Acting Chief Justice, I'm Anton Katz. Yes. I am for the fifth and seventh intervening parties with Mr. Mahambi, Mr. Peramulsamy, and Mr. Matekinka. And I think who's left out is the representative of the fourth intervening party.
Oh, has he been disconnected or that is the
it's Mindy, the fourth intervening party is Mindy, Professor Machinek.
Yes.
Oh, okay. Apologies. I lost count of where I was in the order. I'm present, Professor Mechanic for Mind, self-representing.
Thank you. I think that's all.
Excuse me, Acting Chief Justice.
Oh, it's not all. Yes.
It's Gus Water, and I appear for the Economic Freedom Fighters.
Yes. Thank you. That's Mr. Counsel for EFF, just mention your name so that...
It's Gus Water, Acting Chief Justice, KA-. SIP.
Yes. Thank you very much. Any counsel that hasn't placed themselves on record?
Please, in the court, Acting Chief Justice, my name is Paja Jimingandwe. Together with Madam Lefaladi and Obet Mpofu, we represent the Forum for Service Delivery, that is the 6th intervening party.
Thank you. Thank you.
Acting Chief Justice, Justices, I, together with my learned junior, Mr. Musandiwa, appear for the first amicus curiae, the Council for the Advancement of the South African Constitution. And Acting Chief Justice, if I could just take the moment as well, that we assume that the 4 amici, you imagine we all go at the end of all 8 of the intervening parties. There was just some confusion when we came out of chambers. We assume you want us all at the end of the intervening parties.
The sequence will be the one that I indicated. If you got that right, let's just follow that sequence. I know that it's a little mixed in terms of the amici are not grouped together, but I think let's follow that sequence.
As it pleases the court.
Okay, all right.
Chief Justice for Acting Chief Justice and Justices for Freedom Under Law, Jeremy Gauntlet, appearing with Sarah Puddifin-Jones and Mukululi Stubbs.
Thank you, Mr. Gauntlet.
Acting Chief Justice Mark Oppenheimer on behalf of the South African Institute of Race Relations, which is the 3rd amicus curiae.
Thank you. Thank you.
Honorable Acting Chief Justice, I appear for the 4th amicus curiae together with Mrs. van Schalkwyk and Honorable Justices of the Court.
Thank you. I think we have covered everybody now. Okay, all right. Or is there somebody that hasn't been covered? I think we have covered everybody. Okay, Mr. Trengov. Mr. Trengov?
Acting Chief Justice, I'm here, yes.
Yes. Will you be making use of the 10 minutes or not really?
Yes, I would like to say yes.
Okay, all right. Okay, okay, you may start.
Thank you very much, Acting Chief Justice. May I start by giving a broad outline of our case so that it is made clear where we're going and where we're not going. We submit in the first place that there are 3 core issues in the case. The first is what the Constitution requires of an election. Now, there's no real controversy on that score. The Constitution makes at least 3 demands of an election. The first is that elections be held regularly, and under Section 159 of the Constitution, that it be held every 5 years and 90 days, which in the current circumstances means that it must be held by the 1st of November. The second requirement of the Constitution is that the elections be free and fair. The third requirement is that the elections be safe. That means that they be held with due regard to the rights of life, bodily integrity, and access to healthcare. Now, those 3 constitutional requirements all carry equal weight. There is no hierarchy of constitutional rights, and the 3 of them operate in conjunction and at the same time. The second fundamental proposition is whether it is possible, as we stand here today, whether it is possible to meet all 3 of those demands. And we will submit not. It is simply not possible to have free, fair, and safe municipal elections by the deadline of the 1st of November. And I emphasize that on this second submission, we don't seek to apportion blame. We don't ask whether it might have been possible if things have been done differently. Our proposition is simply, as we stand here today, it is impossible to hold free, fair, and safe elections by the deadline of the 1st of November. The third issue is whether the Commission is to blame for the predicament in which we find ourselves. And we submit not, that the Commission acted reasonably and in good faith at all time, and that it is not to blame for the predicament of an impossibility of meeting the 3 constitutional demands. So what then are the implications of these 3 propositions? The implications we submit in the first place is that the law, including the Constitution, does not demand the impossible. And therefore, if it is not possible to meet all 3 those constitutional demands, then the law, including the Constitution, permits us to do the next best thing, to compromise by striking a balance between those 3 demands. And we submit that the most appropriate balance is to hold free and fair elections as soon as possible, even if we can't do so by the 1st of November. We accept that there may be debate as to what as soon as possible means. Justice Moseneke suggested February. We suggest February, but certainly we are open to any suggestions on that score. But the principal point is this: the Constitution simply does not demand the impossible. And if we are correct in saying that as we stand here today, the free, fair, and safe elections by the 1st of November are impossible, then the Constitution permits the next best thing, which is a balance to be struck between those 3 demands. That's our primary submission. I'm
sorry, Mr. Chengov, I'm sorry. I've just been informed that one of our colleagues, Acting Justice Madondo, is not on, is not...
I'm sorry to interrupt you, Acting Chief Justice. He's on the second screen. I have asked Sunay to see if you can move him to the first screen, please, with all the judges.
Oh, so he has been hearing and everything.
Yes, he has, Acting Chief Justice.
Okay, all right. Okay, all right. Okay, thank you. Sorry, Mr. Chengov, you may proceed then.
Thank you, Deputy Chief Justice. So our primary submission, flowing from those 3 core issues, is that the Constitution permits compliance as soon as possible, even if it cannot be done by the deadline. But our alternative submission, if we are wrong in our primary submission, we might be wrong for, I imagine, one of 2 reasons. Firstly, because you might hold that the Constitution does demand the impossible, even if it's impossible, as some of our colleagues contend. Or you might also find that the Commission is to blame for the predicament in which we find ourselves. But in either of those events, then it would mean that the Commission's failure to organize free, fair, and safe elections by the deadline of the 1st of November is unconstitutional, is in breach of the Constitution. And if that is so, then we would submit that the appropriate response to that breach is to grant just and equitable relief under Section 172. Because the alternative postulates the inevitability of a conclusion of unconstitutionality, and then Section 172 regulates the issue. Some of our colleagues suggest that there is something impermissible about a prospective relief under Section 172. But if they're right, if the Commission should have but failed to organize these elections by the 1st of November, then it is already in breach and qualifies for appropriate response of a declaratory order and relief under Section 172. So Those are our core submissions. Let me just make it quite clear. What we do not submit, we do not contend, as so many have misunderstood us, that we're entitled to defy the Constitution. We also do not contend that you have the power to permit us to defy the Constitution. So those outlandish contentions are based on a misunderstanding of our case, and that is not our contention. We do submit that flaws common to those who oppose the application is that they differ from us on various issues. Some of them argue that the election, free, fair, and safe election by the 1st of November is still possible. Well, that's a factual debate, and we will address that issue. Some of them argue that the Commission is to blame. That is also a factual issue, and we'll address that issue. Some of them argue in an absolutist way that the Constitution demands an election by the deadline of the 1st of November, unconditionally demands. Well, we submit that that is just wrong. The Commission demands three things, and there is no reason why the deadline should trump the requirements of a free and fair election and a safe election. So my learned friend, Mr. Badlander, and I will share the submissions on our behalf. If you have our heads of argument at hand, I might just indicate to you from the table of contents that I will not address the issues of jurisdiction, direct access, and urgency, only because it doesn't seem to be controversial. But if there is any controversy about it, I will certainly come back to it in reply. I will address all the remaining issues, except that my learned friend, Mr. Badlander, will address two issues. That's the issue at page 32, that the Commission was not at fault, and the last issue at page 43, and that is the appropriate remedy. So if I may start then with the first issue, and that is what the Constitution requires of municipal elections. And this part of our submission is uncontroversial, but we do wish to emphasize it because some parties emphasize one requirement over others, and mostly emphasize the deadline of the 1st of November over the other requirements. And that's why we emphasize that the Constitution makes three demands of an election. Firstly, that they must be regular. That's a requirement under the Constitution, Section 1D, Section 19.2, and Section 159. And 159 is the one more particularly which sets the deadline, the 5 years plus 90 days deadline, which translates into the 1st of November. That is an important and unambiguous requirement. It's interesting while we are there, just to note, I'm not suggesting that it makes any big difference, but just to note that Section 159.3 of the Constitution, as well as Section 26.1a of the Municipal Structures Act, do provide for the possibility that elections might not be held in time, because both of them say that the term of office of a municipal council continues until its successor is duly elected and declared. So it does cater for the possibility that the mishaps may happen as a result of which the deadline is not made. So that in this case, in any event, there won't be a gap, there won't be a deadlock if the term of office expires of the current municipal councils, because under those two provisions, 159.3 and 26.1a, the current councils will remain in place and in office. The second requirement is that the elections be free and fair. That's a requirement set by the Constitution in Section 19.1b. Now, it's important because this requirement is negated by many of those who oppose the application. But it is an important requirement, and it is one that can only be achieved by a complex web of related steps, all designed to operate together to ensure free and fair elections. A good idea of the kind of components that make up for a free and fair election can be found in Schedule 3 to the Municipal Electoral Act, which sets out the prescribed timetable. And you will see in that timetable, there are a range of steps that have to be taken, all of them designed to interlock into a web that is designed to ensure free and fair elections. And we emphasize this because some of our opponents, particularly the Democratic Party, engage with the Commission in debates about those steps. And they often negate the importance of every individual step. And we accept that each little component on its own may not be decisive of the whole, but they form the ingredients of a bigger web designed to ensure a free and fair election. And that those ingredients—
You mentioned, Mr. Trengov, that the 10 minutes is up. Actually, it's been up for, I calculated your time from 9:15, so it is up, but you may continue.
Thank you, Acting Chief Justice.
Excuse me, Mr. Trengov.
Thank you.
I would like to, the Commission is accountable to Parliament. Why did it not approach Parliament to seek an extension or an amendment to the Section 159?
Well, I will certainly address that question. You will see in our heads of argument, we address it towards the end. But we will submit with respect that the Constitution doesn't require the subject, if it is unable to satisfy the demands of the Constitution, to seek an amendment of the Constitution itself. Obviously, the Commission cannot amend the Constitution. It has no duty to seek an amendment of the Constitution, and we will submit to you as well that it would not have been an appropriate response to seek to amend the Constitution. It would, on the contrary, set a very undemocratic and undesirable precedent if it were to be established that a majority party may entrench itself in office by amending the Constitution to extend its term of office. So, Justice Mdladla, we accept that that is an argument that's raised by some. I will address it more fully later, but we submit that the Commission was neither required, nor was it competent, nor appropriate for it to seek a constitutional amendment.
Just on this point, the argument goes further to say that the extension that is being sought will result in the extension of the municipal council beyond the 90-day period that is allowed. I know that you said, well, 159.3 seems to make provision for that. But what is your response to that argument by those that are opposing the application?
The response is that that is one of the three requirements that the Constitution sets of an election. But another requirement is that elections be free and fair and that they be safe. And in circumstances where it is impossible to meet all three demands, then it would be wrong to elevate the one demand, the one which has hard content, i.e. the deadline, to elevate and prefer it over all others. Can you imagine if we were to force the IEC to hold elections by the deadline, but it would have to compromise on the free and fairness of the election? The election would not be a credible one. Well, the election would be unconstitutional. The election would be open to challenge, and the election would not have political credibility. because it has not been free and fair. So we accept that the Constitution does set a deadline, but the Constitution also requires the election to be free and fair. It also requires the election to be safe. And when you can't meet all three of those requirements, then you must do the next best thing, and that is to have free and fair elections as soon as you can.
Mr. Trengov.
Mr. Trengov, the Constitution, insofar as it says that councils may continue to function after the end of their term, contemplates, does it not, that they continue to function and the declaration of the results and the new council starting to function would happen within the 90 days. Is that not so?
No, with respect not. It's an unqualified provision. And we submit with respect. Certainly it contemplates.
I'm putting it at the level of contemplation.
Yeah, no doubt.
Yeah.
The Constitution contemplates that those elections will be held within the 5 years and 90 days deadline.
Yeah. Now, at the level of contemplation. I don't know what's happening with our technology. I'm hearing an echo.
There's somebody that is not muted, that wasn't muted, is now muted, Acting Chief Justice.
Yeah, okay, all right.
Yes.
Okay, all right. Can I ask this question, Mr. Trengov? For purposes of your case, do you need to satisfy us that a free and fair election is an impossibility in the sense in which the concept of impossibility is used in law? Or is the position that all you need to show us or to persuade us on is that an election that complies with the Constitution will not happen or cannot happen because certain requirements will simply not be met? Now, in my own mind, there's a difference between those two. Because impossibility gives the impression of something that is very practical, whereas in the end, the question is whether the election would be free and fair. And whether an election is free and fair, as I see it, and you'll make your submission, is a value judgment that must be made. Obviously, that value judgment must be made on certain facts and the circumstances as they exist at the relevant time. So my question is really, does the IEC need to show anything more than that when one has regard to what needs to happen in order for it to discharge its constitutional obligation properly, that's not going to happen, or that there are no reasonable grounds to believe that it will succeed in bringing about free and fair elections?
No, yes, Acting Chief Justice, you're quite right. The Commission doesn't need to show a physical impossibility of organizing municipal elections by the 1st of November. It can do so. It has said so. It can organize those elections and they will take place. But there won't be time for a registration weekend. There will not be proper opportunity for the parties to compile their nominations in good time. I'll get to those issues later. It will be an unsafe election. The parties, and particularly the less well-endowed parties, will not have proper opportunity to campaign for the election. So, yes, an election by the 1st of November is physically possible, but it won't be a free and fair election. So when we say impossibility in this context, what we mean, not that it's physically impossible, but what we mean is that it is impossible to meet all three constitutional demands. And there is no reason why the deadline should win the day over the requirement of free, fair, and safe elections. So it is a relative impossibility. It is a value judgment, but it is one of the Constitution's own making. It sets those three requirements, and the conduct of the Commission must accommodate all three of those requirements and not merely one of them.
Now, assume that one were to be persuaded that the election, if the IEC were to continue to organize it and the election is held on the 27th of October, will not be constitutionally compliant. Does the IEC have an obligation to nevertheless organize an election that is not constitutionally compliant?
No, with respect not, and that is why it's here today.
Yes.
It found itself in the dilemma due to the circumstances that I will come back to. But it finds itself in the dilemma that it cannot organize a constitutionally compliant elections. It can either do an election by the deadline, but it won't be free and fair and safe. Or it can do a free and fair and safe election, but it can't do so by the constitutional deadline. So the predicament in which it finds itself is that it is unable to organize an election which satisfies the constitutional demands. And that is why it is here. It submits that the answer to its dilemma is that the law does not require the impossible. If you find yourself in a situation where it is impossible to meet all three constitutional demands, then the Constitution itself does not demand more than that you do the best you can to organize free, fair elections as soon as possible. But if we're wrong, well, then the Commission is in breach of the Constitution, and then it seeks relief under Section 172.
If the applicant, the IEC, didn't approach the court prior to the election for the relief that it seeks, and it went ahead and tried to do the best it can to ensure that there's an election, and the election did happen, but there were complaints that it was not free and fair. Of course, one or other party who feels aggrieved would be able to approach a court, ultimately this court, whether first via a high court and ultimately to this court or direct to this court. Ultimately, an aggrieved party would be able to approach the court and ask that the election be held to have been not to have been free and fair, and to invalidate it, declare it invalid, and if that happened, that party would be entitled to ask that the court should order that the election be rerun, isn't it?
Yes, no, absolutely. And
that
either way,
would not be that, and that could that would not necessarily need to be within the 90 days that we're talking about. It could be after that. Could there be anybody who could say, well, because the Constitution doesn't contemplate in a certain way an election beyond the 90 days, the court that declares that the election that has been held after was not free and fair would not have the power to say the election must be rerun, even if it is after 90 days.
Yeah, no, the risk of organizing elections before the deadline, but at the expense of free and fair and safe elections. In other words, an election which is not constitutional because it is not free and fair and safe, but it makes the deadline, will introduce two risks, the one legal and the other one political. The first risk is that the elections will be vulnerable to being overturned. And in fact, if the elections were not free and fair, then they are unconstitutional and must be overturned. But it would also, the consequences would not be limited to the legal, it would also have social and political consequences. If the elections are shown to be not free and fair, then they would also not have political credibility. Society will not respect the outcome. Let me give a small example, and I'll get back to it in more detail later. But in an election in these circumstances, if it were to be forced by the deadline, some parties will be better able to cope with it than others. Some parties, like the DA, is richly endowed with very sophisticated database of members and electronic means of communicating with its supporters. Other parties, on the other hand, do not have that facility and depend on door-to-door canvassing, on branch meetings, on community meetings, on rallies, which will now not be possible. So that not only will the election be legally vulnerable, it will also be seen to have been an unfair election, which gave undue advantage to some at the expense of others. So you'll pay both a legal and a political price for organizing elections in time, but which are not free and fair.
And if the court does have the power after the election has been held to order that the election be rerun, even outside of the 90 days, if it finds that the election was not free and fair, is your argument that there is no reason why it can't, in effect, postpone the election before the election happens and a lot of money is wasted, if after the event, it can actually still say, this election was not free and fair, therefore it must be rerun even after 90 days has expired?
Absolutely, Acting Chief Justice. And in fact, we start even sooner. We submit with respect that because the law and the Constitution does not require the impossible, we don't even need forgiveness from the court in order to do the best we can to meet all three of those requirements. But if we're wrong, and if it is unconstitutional for the Commission to do as it has done, then it is under exactly the same regime as if it had organized an unconstitutional election. Its failure to organize a constitutional election would be a violation of the Constitution, would trigger Section 172, and this court's all-pay jurisdiction on the exercise of its powers under Section 172, which will include the power to order the Commission to rerun the elections well after the 90-day term.
Okay, you may continue.
Mr. Trengrove, You referred to section 159, subsection 3.
Yeah.
And if I understood your submission, it was the possibility of a postponement is envisaged in that section. I'm not sure I agree with you, Mr. Trengrove, and I'll tell you why. The end of sub 3 says they remain in office until it is dissolved or their term expires, or until the newly elected council has been declared elected. Doesn't that envisage a possibility where results of the declaration of results are delayed? Not the actual holding of the elections.
Let me just make it quite clear. If I misstated the proposition, I apologize. I don't suggest for one moment that the section permits postponement. All I'm saying is that the section caters for mishap. If for some reason the new council is not declared within the period of 5 years and 90 days, the section caters for mishap, but it doesn't permit delay beyond the 5 years and 90 days. So my submission is not that it permits postponement or delay. It merely caters for the unforeseen.
Now, on a different question, and this is partly raised by my sister, Justice Mhlantla, the basis of the Commission's case, it seems to me, and I might be wrong, Mr. Trengrove, that there is a contradiction in the Commission's case. If I can refer you to page 694, and that is the Commission's replying affidavit, paragraph 82.
Yes, lady.
It says, I emphasize that any suggestion of a parliamentary solution should not overlook the fact that what is actually being proposed is a constitutional amendment. There would be no other legislative way of resolving the inability of the Commission to hold free and fair local government elections in October 2021. If, in light of that statement in the affidavit, how can the Commission say that they are not asking this court to amend the Constitution?
No, with respect, I would have to check that statement, but it has never been our case that what we seek is a constitutional amendment. And if we created that impression, then I apologize, because it is not our case. Our case is in the first place that we do not even require any dispensation from a court, because the Constitution and the law does not demand the impossible. And therefore, it is lawful for the Commission to do the best it can. But the alternative submission, even if we're wrong on the impossibility doctrine, the alternative submission is that the court grants the Commission a just and equitable remedy under section 172. But for the Commission to contend that it has the power, or that the court has the power to amend the Constitution, is plainly not correct. And if we created that impression, then I apologize for it.
Well, if the Commission is not seeking an amendment to the Constitution, why could this problem that the Commission foresees or alleges exists, why could that problem not have been solved by Parliament passing appropriate legislation to suspend the elections?
Well, I suppose I suppose that Parliament could could amend the Constitution, but there are a range of reasons why the Commission submits that it is not appropriate to require of it to ask Parliament for a constitutional amendment.
No, my question is not why the Commission didn't ask for a constitutional amendment. On the basis that the Commission is not seeking a constitutional amendment, why, in any event, did the Commission not approach Parliament to pass legislation to suspend the elections?
No, because legislation couldn't solve any problem it had. There is no legislation if the Constitution permits. The law, including the Constitution, permits the commission to do the best it can. And it is doing the best it can. And for that reason, it doesn't require any legislative reform at all in the first place. It is merely if it should be wrong in its primary submission that it seeks this court's indulgence under its ordinary remedial powers. So legislation with respect, short of constitutional amendment, would not have been a solution one way or the other.
Now, the Constitution envisages the possibility that elections may not be free and fair, and provides for that eventuality, and provides the opportunity to challenge those elections.
I'm not sure that I stand.
Well, any party after, or any interested party after the election has been held, if they are of the view that the elections are not free and fair, can approach a court.
Yes, that's so. But the Constitution doesn't permit elections which are not free and fair.
It envisages the possibility that elections might not be free and fair.
Now, with respect, my lady, the Constitution, of course, every provision of the Constitution, I suppose, in a way, contemplates the possibility that it might be breached.
Yes.
But it doesn't mean that it permits of a breach or suggests a breach at all.
And it provides for a remedy in the event of a breach.
Yes. But that goes for every provision of the Constitution.
Yes. Thank you, Mr. Tringrove.
Thank you, Justice Tron.
Mr. Tringrove, at this stage, would we need to be satisfied that the elections would not be free and fair, or would it be sufficient if we believe that there are sufficient grounds to think that the elections will not be free and fair if they are proceeded with in October?
Yes, no, we agree with your earlier suggestion that it's a value judgment.
Yeah.
And what's more, not only a value judgment, but a value judgment based on future events.
Mm.
So it is a value judgment in which one just does the best one can with the best projection of what one believes the facts will be. So it is not an absolute requirement. It is a best assessment in the light of the circumstances prevailing.
Mr. Tringrove, one of the grounds that you have raised for the impossibility doctrine is the fact that the commission was unable to conduct the voter registration weekend exercise. Now, do we have to, when we determine this aspect, consider the reasons why there were 2 voter registration weekends that had been scheduled? The first one was cancelled. Do we have to consider the reasons for the cancellation of that of those voter registration weekends, especially the first one? I know the second one was cancelled after the report was released.
Yes.
How far should we go with that, so far as that is concerned?
With respect, it is relevant, but not to the first issue. The first issue is it possible today, as we stand here, to organize free and fair elections by the 1st of November? On that issue, the history is irrelevant, because the question is simply, as we stand here today, is it possible or not? The second question, is the commission to blame? Looks back and asks itself, should the commission be blamed for the predicament we're in? And then that question does come up. But the answer to it will be that the first weekend was under lockdown level 4. It was simply impossible, because no gatherings at all were allowed under lockdown level 4.
And with the proclamation of the date now, it means that quite a number of voters will have been disenfranchised because they are not on the voters' roll.
No, absolutely, my lady. You know the statistics. There are 40 million eligible voters in South Africa. Only 25 million of them have been registered. And even those who have registered Many of those experiences taught us, many of those have moved from the municipalities in which they were registered to new municipalities and would want to change that registration to vote where they now live. So even the 25 million is an overstatement of the people who would be able to vote meaningfully in these elections. And it would be a serious disenfranchisement of millions of people to force ahead simply to make the deadline.
There's a suggestion, I can't recall now by which party, that perhaps some provision could be made. I don't know whether that is possible to allow a voter registration weekend so that we can capture those voters that are not on the voters roll now. Can you deal with that issue, please?
Yes. Everybody agrees that we can't have the elections without a voter registration weekend for the reasons you've mentioned. So that is common cause between everybody. The Commission says, but it is impossible between now and the 27th of October to hold such a weekend for logistical reasons. And it describes all of those logistics, which makes it completely impossible to still organize such a weekend before the 27th, in time for an election on the 27th of October. So that the difference between us and the Democratic Party, who insist that it can be done, is one that comes down to the nuts and bolts and logistics of organizing such an election. One of the main problems with it is, which the Democratic Party overlooks, is that it is not only the question of organizing the election. Remember the weekend. It's a massive logistical operation at 23,000 voting sites and an interaction with 3.5 million people, if the history is anything to go by. So it's a massive operation. But what follows after it, to satisfy this court's requirements of Kammen and Mhlophe, an audit then has to be done of the new registrations to determine that they are regular and proper, and to verify the integrity of the roll. So much logistical exercise is then required thereafter. And then, of course, there is the problem of the nominations of candidates, which can only follow after the roll has been completed. The ANC says it has to nominate 10,000 people, and it's a process of holding branch meetings and community meetings to achieve that nomination. So it is simply a logistical exercise which is impossible to achieve by in time for an election on the 27th of October. Even for the elections in February, they've scheduled voter registration weekends in September, 18 September. But that is an indication of how much time they need between voter registration and election in order to ensure the integrity of the roll that results from the registration.
Thank you.
Mr. Trenghoff, I just want to raise the question of impossibility with you. The IEC quite clearly relies heavily on that doctrine, and I would like to check with you whether there's any authority for importing that common law doctrine into our constitutional realm. I ask you this because it seems to me that the doctrine of supervening impossibility of performance is strongly applicable to contract law. Is there any authority in our law, in this, in our jurisprudence, for importing this doctrine into the constitutional realm, where you can say you are excused from fulfilling, as an organ of state, mind you, from fulfilling a constitutional obligation such as holding free and fair and regular elections based on this doctrine? Yes,
there is, Justice Majidi. In our heads of argument, we mention in paragraph 46 the case of the judgment of the Supreme Court of Appeal in the case of the Judicial Service Commission against the Cape Bar Council. And in that case, the Supreme Court of Appeal applied the impossibility doctrine to the constitutional requirements for a quorum of the Judicial Service Commission. And if I may perhaps just elaborate on that doctrine, because it is important that I...
Before you go on, I read that case, and it seems to me that it's not the ratio decidendi in that case. But secondly, of course, are we not in a different situation here where we have the IEC as a Chapter 9 institution constitutionally charged with holding free and fair and regular elections? So is that case not distinguishable on the law then?
No, with respect not, because it is also a state institution, and the provisions concerned are constitutional provisions which prescribe its quorum. So, and as to whether it was part of the ratio of the court or obiter, I'm not sure. I thought it was part of the ratio, but because they did say that certain absentees can be forgiven and others not, under the doctrine of impossibility. But let me perhaps...
Well, before you elaborate, I want you to focus specifically, I'm sorry to interrupt you, but I'd like you to focus specifically on the following. Part of that doctrine, let's assume for the sake of this debate, part of the doctrine is that it's a doctrine of equity. So if a party relies in contract as a defense for, say, a claim for specific performance on that doctrine, that party must come with clean hands. In other words, it cannot rely on supervening impossibility where it itself is the cause of that impossibility as a general proposition. So if we import that doctrine into constitutional law and constitutional obligations, then surely part and parcel of it must be then the question of whether the IEC is itself the cause of that impossibility. I mean, you say that we are not going to attribute blame, but it does have pertinent relevance in that respect, and that is why I raised this with you.
No, I accept that absolutely, Justice Majid. I accept that entirely, and that's why I submit that there are two different questions. The one is it possible today to organize free and fair elections by the 1st of November? And we submit that it's not. But it's a separate question, and the one that my learned friend, Mr. Badlander, will address, whether the Commission is to blame for that predicament. So we accept entirely that the doctrine of impossibility excuses a failure to perform only if it is not due to the fault of the actor. But we submit that it is not. If you should find that it is the Commission's fault, well, then the Commission has failed to organize free and fair elections as the Constitution requires, and then it will be dealt with under your jurisdiction under Section 172.
I'll raise that with Mr. Badlander later, but it seems to me that the primary relief that you seek would require of this court to exceed the bounds of separation of powers to do Parliament's work, where a supermajority of 75% is required to amend this constitution as far as elections is concerned first. But secondly, it seems to me in any event that your alternative relief would have the same result, albeit indirectly. We would still be postponing elections in the face of a peremptory constitutional provision where the Constitution makes provision for Parliament alone to amend that entrenched provision with a supermajority. So it seems to me that is, and also if I may just add, as far as I could see, we would be the only country in the world in the face of a global pandemic, we're faced with similar elections, presidential elections, provincial elections, national elections. We would be the only country in the world where the judiciary would postpone an election, as opposed to instances such as in France and elsewhere, where Parliament passed legislation, and the UK too, in the face of this coronavirus pandemic, to make provision for this challenge.
Justice Majid, with respect, we do not suggest that the judiciary should postpone anything. What we, if we are correct on our submissions about the impossibility doctrine, then it would have been open to the Commission to take matters in its own hands and to organize the elections free and fair and as soon as it was able to do so. That would have been lawful for it to do so. But because it is a responsible citizen and it appreciates that that would be a controversial route to take. It came to this court for a declaratory order that that is a lawful route. But that is not a decision by the judiciary to postpone. That is merely a decision by the judiciary confirming that it is lawful for the commission to postpone. And it is only if we're wrong in the first submission and you find that we are disqualified from impossibility relief because the commission is to blame, that we then confess to a constitutional violation, which triggers your ordinary remedial powers.
And the last aspect I'd like to take up with you on this question of impossibility is the evidence. The commission self-evidently, for reasons that are obvious, rely heavily on the Moseneke report, which is a very detailed, comprehensive, well-researched report after a wide-ranging inquiry. But am I correct if I say that the commission, like the Moseneke inquiry, takes the following position? It says we cannot have free, fair and fair elections and safe elections by 27 October because of the impact of the pandemic. And therefore, it is safer to hold it, for example, in February, because by then, not because the pandemic would have passed a third or a fourth wave, but solely because we would have achieved a vaccination rate of close to 67% to achieve community immunity. Is that fair to make that assessment?
Yes, just with one emphasis, and that is that it is not the voting day alone that matters.
I understand that. I take that. I take that point, but my difficulty is this. When you look at the commission's proceedings, there was no unanimity amongst the scientists, the epidemiologists, specifically people like Professor Karim, that February would be safer than October. Do you accept that? In fact, Professor Karim was adamant it's better to have the elections in October than in February 22.
Yes, he said that October would be safer than February. Yeah. Other scientists disagreed with him. And the important thing, though, that was decisive for the commission and for Justice Moseneke was that there would be a far greater proportion of vaccinations by February. It is not, so their decision to defer to February is not based on a prediction of how the curves will go. Their prediction is based on the expectation of the Interministerial Committee that by February, 70% of the population will have been vaccinated.
My difficulty with that, and it's a very serious difficulty, Mr. Trengov, is that nobody anywhere in these papers or in the inquiry said anything about the worrying emerging trend of vaccination hesitancy or vaccination skepticism, call it what you want. It worries me tremendously because it's a concern that's spreading throughout the world, but specifically in our country too, where supply now outstrips demand, where it was the other way around. There is a serious problem of vaccination hesitancy, and why I raise it is this: we have no, as we sit here today, we have no reason to believe that is achievable in February 2022. That's 70% in the light of this skepticism, and that leaves the difficulty. Then is if it is in the power of this court to postpone the elections, as you say, and I have grave doubts about that. There's nothing to believe that in February things would be different on the vaccination front.
No, with respect, there is much reason to be hopeful. The best prediction is that of the Interministerial Committee that vaccination would be at the 70% level by then. I accept entirely that in these times with so many moving parts, things don't always work out the way that people planned and predicted. But that is the best evidence we have at the moment. Remember, we stand at 12% vaccinated, of which only 6% have been fully vaccinated. So the target for February is 70%. So there's a massive difference between the two. That things may go wrong, absolutely, we accept that. But when we are dealing with the future, we can only deal with the best available information and acknowledge that things might not work out the way we expect them to be. That is why the Commission has asked for an order that it remains subject to your supervisory jurisdiction, in acknowledgement of the fact that things may work out differently from what had been expected.
Yes, thank you.
Mr. Trengov, let me indicate that you are about 4 minutes away from completing 1 hour, so you would still have 30 minutes, so you are 30.
Yes, let me say
6 minutes to. But what I want to find out is whether your arrangement with Mr. Butlander, how much time between the two of you have you arranged? I want to know when to stop you, because you might be busy answering questions. You might not be able to keep your eye on the time.
I promised him half an hour. He said if in an emergency, I can steal some of his time. So,
okay.
If you would understand that if I have to push on very rapidly, in fact.
Okay, no, that's fine. Continue.
Mr. Trengov, sorry to come in and yes, like Justice Majid, I too am quite concerned with the springboard. More the question whether there is a constitutional basis for it, or is it purely relying on the common law doctrine? Yes, I did see, and in your submissions, and indeed I also heard in response to Justice Majid, your reliance on the JSC v. Cape Bar Council case. You refer to paragraphs 27 and then I think 31 to 33. In paragraph 27, almost in passing and with no reasoning behind it, the Supreme Court of Appeal does indeed refer to the lex non cogit principle. And my point is, and I'm by no means criticizing the Supreme Court of Appeal in this regard, because perhaps in context, it didn't have to go into any detail in that regard. And it is only in paragraph 27, on my reading, I may be wrong altogether, and please correct me. And it is only in paragraph 27 that the Constitution as such is of relevance. When I look at paragraphs 31 to 33, I think what was at issue there was an interpretative exercise around what unavailable means in section 2.2 of the Judicial Service Commission Act. Now, if that be the case, does that not leave us with virtually no constitutional basis for your springboard? Or if we are left with something of it, very little of it. So that,
no, but our case is certainly not pinned on that judgment, and I accept that it's open to interpretation. And in any event, it doesn't bind this court, so it doesn't really matter whether it's arbiter or not. But let me say this, two things. Firstly, this court has adopted and recognized the doctrine of impossibility in Barkhuizen and a minority judgment in Tokonya. But even if this court had not done so, what is the answer to the question? What does the Constitution require when the Constitution itself makes three demands which cannot all be satisfied? In other words, when it makes irreconcilable demands, what is the Constitution's answer to that question? Now, all over the world, the legal systems, not only of ours, but many others, accept that the law does not demand the impossible. And in this case, the law is not, compliance with the law is not impossible because of some extraneous fact. Compliance with the law is impossible here because the law itself, the Constitution itself, makes three incompatible demands. Now, what do we say? What does the Constitution say should happen when it makes three demands which are irreconcilable and cannot all be satisfied. Surely the Constitution itself then says, well, then you must strike a balance between them and do the best you can, because it is irrational for the Constitution to say, I know it's impossible, but you must still do it. But then even if we're wrong, even if that is not the Constitution's answer, and we submit that it is, but even if we're wrong, why elevate the one constitutional requirement, the time bar, over the two others? What is there to suggest that the time bar should trump the free and fairness? I would have thought that free and fair elections are more important, but the jurisprudence teaches us that all constitutional rights are equal and there's no hierarchy between them. Justice Majid confirmed that again the other day. So that what does one do when the Constitution sets three demands, all of which cannot be satisfied? Do you choose one and not the others? Or do you respond in accordance with the doctrine of impossibility that says, well, if you can't satisfy all, you must do the next best thing, and that is to strike a balance between them. Sorry, Justice.
I just wanted to make the point that I am not, and I don't want you to attempt to convince me otherwise. I'm not altogether attracted to the idea of reliance on cases like Barkhuizen and so on, because those were in the context of the common law. I am attracted more to your latter argument, which confronts more frontally the constitutional question. You are confronted by this constitutional reality. As a matter of constitutional principle, what do you then do? So we won't literally then be using the common law. We must answer that constitutional question constitutionally. What comes to mind in this context is the Canadian case. It may not be in point altogether, which you and perhaps your colleagues may be aware of, Manitoba Language Rights, 1985 1 SCR 721, or 1985 Kenley 33 SCC. In that case, for 95 years, the province of Manitoba did not comply with the Canadian constitutional principle of bilingualism and enacted provincial acts in English only for 95 years. That was invalidated by the Supreme Court of Canada. But the problem they had was you'll be left with virtually no law at all in the province of Manitoba if you're talking about legislation spanning 95 years. They do not have an equivalent of Section 172 there. So the question was, we invalidate, and then what happens tomorrow? No law in Manitoba. So they came in with the idea of the laws will be deemed to be valid for the period necessary for the Manitoba Parliament to enact in French and publish. And they did this because, according to them, this was actually a vindication of the rule of law itself. So in a sense, one could argue that they acted in a manner that was unconstitutional so as to actually preserve a constitutional principle, which is the rule of law. But of course, it's wrong for me to say they acted unconstitutionally because, as I understand the Canadian constitutionalism, outside of the written text, they have the foundational principles that are key to the constitutional architecture. And those include the rule of law and democracy. So in a sense, one could say it was not necessarily acting unconstitutionally, but it would be unconstitutional if one wants to insist on the written text. So my question, of course, I'm raising this with you now, you've not given any thought to it, but I wonder whether this would be of any use here. With us, the rule of law is actually written into our text. The idea of a democracy is also written into our text, and both of those are in Section 1 of our Constitution. So does that make our situation different? Of course, there's always a question, the underlying question of the impossibility that you rely on. Will that be established? But that's outside of the constitutional issue or question that I am raising.
Yeah, Justice Madlanga.
I'm sorry for the lengthy.
No. The Manitoba language rights case, as I understand it, was actually the lesson that the Canadians learned that we then incorporated in our Section 172, which they didn't have at the time. Yes. But they have also had to ask themselves, what would the Constitution demand in these circumstances for which it doesn't cater? And we submit that to that extent, this case is analogous. What does the Constitution require should happen when it makes three demands which cannot all three be satisfied? What does the Constitution itself then requires? Now, we suggest that the doctrine of impossibility is the answer. And remember, the doctrine of impossibility is often employed not as a super law, but merely as a mechanism of interpretation. In other words, and the rule says, in the absence of a provision to the contrary, the law is deemed not to require the impossible. So that unless there's a provision to the contrary in the law, you assume it doesn't require the impossible. Now, that same rule of interpretation, presumption of interpretation, applied to the Constitution would say, what does the Constitution prescribe should happen when it sets three requirements and they cannot all three be satisfied? It is nonsensical to say, but all three must be satisfied, because we postulate that it's impossible. And if it is impossible, then why elevate one over the others? There's no justification for then elevating the time bar over the others. And Justice Madlanga, if I may just mention, while we're dealing with the doctrine of impossibility, which we do at page 10 of our heads of argument, we should also add that it's also a well-known principle of international law. And it is, for instance, you will see that if you look at the jurisprudence of the European Court, it often invokes the doctrine of lex non coget ad impossibilia. But in the Vienna Convention, that's the Vienna Convention on the Law of Treaties, Article 61, provide that it is a state subject to a treaty may depart from its requirements where it is impossible for it to comply. So it is also a doctrine recognized in international law. So we're not dealing with a quaint common law rule that may not have survived our constitutional era. We are dealing with a fundamental rule of equity and justice that says that the law must be interpreted not to require the impossible. And there is no reason why that fundamental principle of equity and justice should not also guide us in understanding our Constitution, and where it makes inconsistent demands, why it should assist us to conclude that it does not require the impossible. We submit, and I will now have to do that in very abbreviated form, that an election, a free and fair election before the deadline on the 1st of November is absolutely impossible. We deal with that issue from page 13 of our heads of argument.
ACJ, with your leave, before Mr. Trenproof proceeds, I know that we pressed with time, ACJ.
Yeah.
But I ask your leave to just ask this question because it worries me.
Yes.
The Western Cape MEC, Mr. Trengrove, has responded to your submission that it is not possible to hold the elections by saying in paragraph 90 of their heads that there was a presentation that was made by the commission to the Western Province legislature, setting out specific COVID-19 protocols, and that there was a clear commitment to hold the elections.
Yes.
And the reason why this issue worries me is what happened to those plans.
Well,
because the allegation is that it was that presentation was made with the COVID-19 pandemic in mind.
The MEC's evidence is wrong. It's been contradicted and put right by a further supplementary replying affidavit that was filed yesterday. And you will see that that affidavit makes it quite clear that the accusation, particularly that the Commission had concealed evidence or had failed to disclose evidence, is quite wrong. Everything has been absolutely, frankly disclosed. And the answer is that there was a timetable. There was it's dealt with in reply, and it annexes its original timetable, which is at page 703. It is RA3 to the replying affidavit. And it says, yes, I did have very far advanced plans. There is my timetable. It provided for a registration weekend of the 17th of July. In fact, I also developed a protocol for voting at the time of COVID. So yes, it is true. I was astute to plan to comply with the Constitution. And I have been frustrated in doing so only because the COVID regulations made it impossible for me to do so. But I suggest that that affidavit really puts paid to what was a mischievous and incorrect statement by the MEC. On the impossibility to have an election by October, there is firstly the lockdown regulations. Remember the lockdown regulations as they currently stand. The lockdown regulations for the whole of July, we were under level 4, which made all gatherings illegal. So it made it impossible to have a registration weekend. We are now still under level 4. Even under level 4, gatherings are prohibited for anything more than 50 people. And just listen to the requirements. The regulations 36 is the one that regulates gatherings. Gatherings to a maximum of 50 people, but in a venue, that's indoors, but in a venue which can accommodate 100 people. In other words, you must find a venue which can accommodate 100 people, in which you can have 50 people. Otherwise, you have to have a pro rata reduction. Those people have to wear masks. They have to keep a social distance of 1.5 meters, and they must end the meeting at 9 o'clock in the evening. Now, it is hardly a way for which political parties who depend on branch meetings, community meetings, rallies, to have to canvass in this way. You'll know that there is one of the obstacles in the way of having a weekend, having an election in October, is that there is simply not time for. Sorry, did you want?
Yes, Mr. Trengo. ACJ, may I go ahead?
Oh, you have a question? Yes.
Yes, only two questions for Mr. Trengo. The first one is the IEC certain that by the time it suggests that the election can be held, the circumstances will permit for the election to be conducted?
Justice, no. They merely act on what is the best prediction, particularly of the level of vaccinations by February, but it is not certain.
And the second question which follows, should the COVID-19 pandemic persist until that time, what shall happen?
No, we have little doubt that the pandemic will still be there. The prognosis is that the level of vaccination will be 70%. In fact, we should be going through a trough, according to Professor Karam, in September and October, and there will be time to take a lot of the preparatory steps necessary to be taken for February elections. There might again be a peak around February, if Professor Karam is correct, but at least we will have significantly higher levels of vaccination. So, Justice Madondo, nothing is certain, but the Commission, Justice Mosaneki's best prediction, the Commission's best prediction is that it would be in a better position to hold lawful elections at that time. On impossibility, may I just elaborate on one issue, because it's an issue that the Democratic Party takes on. The question is whether parties have a fair opportunity to electioneer. The IFP says it's impossible. The ANC says it's impossible. The ANC makes the point that it has to nominate more than 10,000 candidates by a process of branch and community meetings. That is just impossible. What the DA then says is that, well, you can limit meetings to 10 to 20 people, and because that would be sufficient. And then it says the most extraordinary thing in paragraph 107 of its heads of argument. That's 107.1. Large, rich parties will always have a campaigning advantage over smaller, poorer parties. That is the nature of our system, which does not limit parties' campaign spending or their ability to raise funds, save they must disclose the source of large donations. Small parties will not be able to record TV and radio adverts or use social media, whether or not there are limits on gatherings. This is not inconsistent with free and fair elections. And they invoke this court's jurisprudence in support. But that, with respect, is a very cynical approach. Nobody begrudges them their affluence and the sophistication of their electioneering. But that is not the point. The question is whether those parties who are not affluent, who do not have an established database, who do not have the electronic communications, who do not have the advertising campaigns, those parties who are reliant on door-to-door canvassing, branch meetings, community meetings, rallies, whether those parties should be, can be fairly deprived of those means of electioneering, simply because there is the theoretical option of the sophisticated means that only some can afford. And we submit with respect that that's precisely the problem. Some parties can afford the luxury of distance electioneering and campaigning. Other parties can't, and it would yield an unfair outcome if the DA were to be left with their luxurious machine for canvassing, while the poorer parties get deprived of all they have. And for that reason, that would be an unfair outcome.
Mr. Trengrove, whilst you're at that, and maybe this has been dealt with at the reply, but from my previous question, you'll realize that I didn't get to the reply. There's an allegation again, and it's, in fact, it's not an allegation, it's a submission by the Western Cape MEC that during, I think, alert level 3, there were elections that were held in 17 wards. And yeah, it was during the 3rd wave. And then during the 3rd wave in June as well, there were elections that were held, I think in 4 wards. I think that the import of that submission is that is to question why the measures that were taken during those elections could not be utilized in these elections to make sure that they are free and fair.
Well, they were, but the mistake the MEC makes is to think that what is decisive is the lockdown level on voting day. And it is not. Remember, we were at level 1 from March to May this year, when all of those preparations could be made, and they were made, and by-elections were held. So you can have elections, you can have an election day under level 3. We're not suggesting you can't. But the problem is that we have had a July of level 4, and we are now in level 3, and they simply don't permit of effective campaigning and of voter registration. So that simply to look at the day on which voting took place in June is, with respect, to miss the point. There is another important feature, and I'm just going to mention it and hope that my learned friends for the other parties emphasize it. All the parties rejected the timetable submitted to them on the 2nd of August, because it had inadequate time for the parties to identify and nominate their candidates. That is still an impossible issue. And that is where the ANC, I hope, will tell you about the massive task of nominating more than 10,000 people. But all of the smaller parties have that problem. And all of the parties unanimously rejected the October timetable on the 2nd of August, precisely because it didn't give them enough time to nominate their candidates.
On IEC's assessment, Mr. Chengov, assuming we were not in COVID-19 situation, how much time would it require to run a free and fair election from, for example, in a situation such as this where it had to come to court? From the time the court gave judgment, how much time would need to be made, how much space would it need in order to run a free and fair election?
Justice Zondo, Deputy Chief Justice, the Minister issued her proclamation on the 2nd of August, and not because she was required by law to do it on that day, but she was required to leave enough time for an election to be held by the 1st of November. And I understand that that is 83 days is the minimum time that is required between proclamation and election day. And that is why it was so proclaimed. But if you require a more precise answer, I can certainly come back to you on that one.
Okay, no, that's all right.
So, as a follow-up, Mr. Trengrove, maybe Mr. Butlander will address it as well. It would appear that the IEC's problems are circumstances beyond its control for these elections not to be held. And my concern is, if we were to craft any supervisory order and without binding the government, how will the IEC be in a position to achieve its objective of the elections?
Well, at the moment, it foresees that by February next year, the level of vaccination will be such that it will be able to hold an election. Well, there are really two factors that will make those elections possible. The first is that the predictions are, Professor Karam and others, are that we are hopeful of a trough in September, October, perhaps November, during which voter registration and a large number of steps can be taken, and canvassing and so on. And then by the time we get to February, although there is a risk of another peak, at least then vaccinations will hopefully achieve a level of around 70%. The combination of those circumstances make it reasonable to conclude, as Justice Moseneke did and as the Commission did, that there are reasons to be optimistic about the prospect of February.
But then my concern is the IEC is not in control of those processes. We're just living in hope.
Well, hope and best prediction it can do. There may come a time, and remember the Commission envisages that it will be subject to this court's supervisory jurisdiction. It hopes that things, it trusts that things will work out the way it predicts they would. But if they don't, there may come a time that the court would say, enough is enough, you simply now have to have elections come what may, because the delay is becoming worse than the absence of free and fair. But that is why it would be subject to the court's supervision. We accept.
But if the IEC does not accept any blame, why should we supervise the IEC if it says it's circumstances beyond its control? And IEC is also going to depend on the government taking appropriate measures to ensure also from its side that circumstances for a free and fair elections will be prevailed within the context of the pandemic.
Yes, because it recognizes that this is an extraordinarily important matter to judge, that it is a matter of judgment, that it is extraordinarily important judgment that has to be brought to bear on it. That is why they in the first place engaged a leading South African of integrity to make that decision, or to help it make that decision. It accepted his recommendation. And it is here on his recommendation, in recognition of the fact that the highest credible voice in the country should take this decision rather than it be taken by the IEC, which is its own considerations, or a political party, a political process which is driven for political reasons.
But then it will also rely on the executive to do its part.
We all have to rely on the executive. Yes, that's true.
Thank you.
Mr. Trengov, we are at 11:15, which is the end of the 1.5 hours. I know that we have been asking you questions, but those questions are important because we need clarification. You had said that Mr. Butlander was going to come in. I will allow him because we have detained you longer. But I think understand that Justice Theron has 1 or 2 questions before I release you.
Yes, I'm ready to hand over to him, but I'll happily
yes.
try and address Justice Tron's difficult questions.
I think she's going to ask you very easy ones now. Justice Theron.
Thank you, Acting Chief Justice, for the indulgence. There's just a few issues I'd like to explore with you, Mr. Trengrove. One deals with the separation of powers. If I can refer you to paragraph 151 of your written submissions on behalf of the Commission.
Yes.
And that is under the subheading, Alternative Proposals, Amendment of the Constitution. And it says at 151, it was improbable that the amendment, this is the amendment of the Constitution, could have secured the necessary support. Then go on to refer to the requirement of the 75% majority. So the Commission is contending that it would not have been feasible for it to approach Parliament to request an amendment to Section 159 because it was unlikely that there would have been sufficient support for such an amendment. And this is my question and this is my concern, Mr. Trengrove. Why should this court be asked to do something which Parliament is expressly empowered to do, but on the Commission's version would probably not have done?
Because we're not asking the court to amend the Constitution. It's as simple as that. An amendment of the Constitution under the present circumstances would be a terrible precedent, terrible precedent, because it would say to governing parties that if you have an excuse to do so, it is legitimate for you to amend the Constitution to extend your term of office and so entrench yourself. It's a terrible suggestion.
My concern is that the Commission is clothing what it wants us to do. And it seems to me, in effect and in substance, the Commission is asking this court to amend the Constitution, but is not doing so directly.
No, Justice Strong, it is not doing so directly or indirectly. It is not asking for a Constitution amendment at all. What it says is take the Constitution as it stands. Interpret the Constitution by asking yourself, what does the current Constitution say should happen when it demands a free and fair election by the 1st of November, and it is impossible to satisfy that demand? What does the Constitution itself say? It doesn't require amendment. The Constitution interpreted with the benefit of the doctrine of impossibility would say you're excused from complying with both those requirements because it's impossible to do so. You must do the next best thing, which is to comply, to hold a free and fair election as soon as you can. But if we're wrong, Justice Tron, we may be wrong. And if we're wrong, then it means that the Commission has been acting unconstitutionally. And then your powers under Section 172 kick in. But on neither scenario do we ask this court or suggest to this court that it should amend the Constitution.
Mr. Trengrove, you've referred now to the doctrine of impossibility. As I understand the applicant's case, there are three bases for the alleged impossibility. One is the effect that such elections will have on people's health. Two, the inability to register voters and to complete other preparatory steps. And three, the fact that the current regulations prohibit gatherings and therefore prohibit parties from meeting and from campaigning. Now, regarding the first basis, that is the effect of the elections on people's health. In order to make a determination of this issue, this court would be required to evaluate the opinions of experts who seemingly do not agree. Is that an exercise within the capacity of this court? Is that not the kind of exercise that should be conducted by Parliament?
No, with respect not. We deal with the medical evidence, as did Justice Moseneke, and the medical evidence is quite clear. Professor Karam himself, on page 15 of our heads of argument, in paragraph 57, we quote Professor Karam, who says that an election in these times will introduce 5 risks of infection and of super spreading. So that the experts are agreed that an election increases the risk to health. What they disagree on is whether it's going to be better or worse in February, but they're otherwise agreed. And the court is a professional evaluator of competing opinions and evidence. It's not as if anybody is better at it than the court is.
So the very risks that may exist in October will still be in existence in February.
No, with respect not. The risk would be significantly reduced if the expectation of the interministerial committee is realized that the level of infection, vaccination is increased to 70%. But Justice John, let me say that the alternative is to have an election by the 1st of November, but that election will not be free and fair. That will manifestly be an unconstitutional election. And nobody can suggest that the Commission must organize an election before the 1st of November, despite the fact that it will certainly be not be free and fair.
If I can go to the second basis alleged by the Commission for the doctrine of impossibility, and that is the inability to register voters. Now, as I understand it from the Commission's reply, this is at paragraphs 54.5 at pages 676 to 677 of the record. Part of the difficulty in arranging the voter registration weekend was due to the fact that PPA procurement was unfunded. And the reply records that such procurement remains unfunded. Do we know whether the funding will be available for February 2022? And in any event, how can the Commission rely on budgetary constraints to allege that it is impossible to fulfill its constitutional obligations?
No, the answer is, Justice Tron, I'm not sure, but I accept that lack of budget doesn't make for impossibility. And remember, I must just emphasize, we distinguish between two things. The first is it possible today to organize a free and fair election by the 1st of November? And we submit not. A second question is the Commission to blame? That's the question that my learned friend, Mr. Badlander, will address if he has a minute.
Now, the Commission also says that it cannot register voters because the minister has proclaimed the election. Is there no other way to get around that, maybe through legislation, than to ask for the postponement of the elections?
There may be an amendment of the particular statutory requirement, may solve that. I accept that. But that is not the main concern. The main concern is that it is simply unable to perform the logistical exercises necessary to not only to have a registration weekend, but then to process the outcomes of that weekend to produce a voter's roll of integrity. And it gives all of the steps that it has to go through in compliance with this court's jurisprudence to certify that role. And there isn't sufficient time to do all of that between now and the elections. And then, Justice John, there is the parties who agree that there is insufficient time for them to nominate their candidates. Everybody has agreed on that score. That's an easy one.
I might be missing something, Mr. Trengrove, but I couldn't find the reason why the voter registration weekend that had been planned for 17 to 18 July. No, I'm sorry, for 31 July to 1 August was postponed. I understand that the voter registration weekend that had been planned for 17 to 18 July was postponed because of the third wave. But it doesn't appear, and this is at paragraph 57 of the replying affidavit on page 679, why the voter registration weekend that was scheduled for the end of July and the 1st of August was postponed.
That was for two reasons, mostly. The first is that by then Justice Moseneke had rendered his report, which recommended the course that they have taken. But they also say in their founding affidavit that—
But Mr. Trengrove, why couldn't the voter registration weekend proceed, despite the report, the recommendation that had been made?
let me come back to this one, but it was dealt with in the founding affidavit at page 51 in paragraph 98.5.7. They said that they also postponed it because the country was still in the third wave. And that was reiterated in the replying affidavit at page 679 in paragraph 58, that they could not have it because the third wave posed too high a risk to those who would participate in such a weekend.
But that reference to the third wave was specifically with regard to the voter registration week that was scheduled on 23 July. And that appears from paragraph 58.
Yeah, Justice Tron, at that time there were two problems. There was a third wave, but there was also lockdown level 4 regulations, which made it impossible. By the end of July, I think from the 28th of July, we moved from level 4 to level 3. But they say, despite the fact that they were now under level 3 and not 4, the third wave was still rampant, and for that reason made it unsafe to have a registration weekend.
Yes. It seems that we are anticipating a fourth wave. If we do, there's a possibility that we might go into stricter lockdown regulations. It's not certain, Mr. Chengrove. So the practical difficulties which the Commission currently faces may still be there in February, and it may even be worse. I know part of your arguments and part of your submissions earlier was that it would be better for smaller parties and parties that don't have as much funds as others if the elections were held in February 2022. Now, if the pandemic is worse, I'm not sure whether it would be better for those parties. This is on your argument.
Justice John, that is because voting day might be the same, but the experts all agree that there's a likelihood of a trough between now and then. Professor Karem says the trough should probably come from September through October. So there is every expectation that we are going to have a period of time in which the COVID and the regulations will allow parties to register, to nominate, and to campaign, even if there is again stricter lockdown by the time the election day itself comes.
We are at 11 o'clock, Justice Ron and colleagues. Justice Ron, did you still have some question?
This is my last question, Acting Chief Justice. Thank you.
Okay, all right.
Mr. Chengrove, if we're going to have most of the difficulties currently in existence, still in existence in February 2022, and the Commission says, yes, we'll be able to conduct elections in 2022, February, isn't there an inference to be drawn that the only difference between the two dates is that October is too close and the Commission realized this too late, and it in fact wants more time?
No, with respect not. It wasn't too late. Its plans were laid. It had a timetable, and that's the timetable at 703, or at page 703, that's the replying affidavit RA3. So at a timetable, it was prepared, but those plans were frustrated by COVID and overtaken by the investigation and recommendation fund of Justice Moseneke.
Thank you, Mr. Chengrove. Thank you, Acting Chief Justice.
Thank you. We'll take the tea break now. It's 11 o'clock, half a minute past 11. We will resume at 11:15. I will give Mr. Badlender a chance then, but because of the time we have taken with Mr. Chengrove, I propose to see whether he can address the issues he addresses within 15 minutes rather than 30 minutes.
Thank you.
Yes. Okay, all right. We adjourn.
Thank you.
Court will adjourn until 11:15. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone and then rejoin with video and sound when the hearing recommences at 11:15. Should you exit, you may use the same link to rejoin the hearing.
Is everybody back? Can we start? Are all colleagues there? Mr. Butlander, you will address us on two aspects only, is that correct?
That's correct, Acting Chief Justice.
Yes, please go ahead. I'm sure you will be able to do that within 15 minutes.
I will certainly do my best, absolutely.
Okay, thank you.
Acting Chief Justice, the first topic that falls to me to be dealt with is the question of assuming that it is impossible to hold the elections in October, constitutionally compliant elections, is it the Commission's fault? Now, I'm going to be brief on this for two reasons. Firstly, because we've already addressed it, and it's sometimes difficult to understand what our learned friends' cavils are, and I'll deal with it further if needs be in reply. But secondly, because I'm mindful of the time and I do need to get to the question of remedy because it's critically important. So let me deal with just two aspects, if I may. The first is a complaint that says the IEC did not properly prepare for the elections. They did not properly prepare for the elections either at all or for the elections in a COVID era. So some of the parties in the amici say that. The MEC for local government in the Western Cape comes and says exactly the opposite. He says, you did prepare for the elections and you did prepare to hold them in the middle of the COVID pandemic, but you just haven't told the court. And so there's a material non-disclosure. Now, with respect, they can't both be right, but as a matter of fact, they're both wrong. Because what actually happened is that the Commission has been preparing assiduously to hold
I guess the MEC for the Western Cape can't be completely wrong, but maybe partly wrong, partly right.
Oh, yes, of course, you're right. He's right on his factual proposition and wrong on his non-disclosure proposition. Of course, you're quite right with respect to Acting Chief Justice.
Yes. Yes.
So the Commission, the papers demonstrate that the Commission has been preparing assiduously from long before Justice Moseneke was appointed, and that they have been preparing at all times to try and run the elections in October. And even today, as we speak, the founding papers make clear that they are trying to straddle both horses, run both trains, as it were, so that if the court refuses the application, then they will have to proceed in October. It won't be constitutionally compliant for the reasons that have been elaborated, but it's not at all that they have given up on October, quite the contrary. Could I just give you a reference to that, because it answers both questions? In the founding affidavit, page 103, paragraph 229 to 30, you will see that it is made clear that the reference is that the Chief Electoral Officer explained to Justice Moseneke the steps that the Commission had taken to hold local government elections in October 21, should it be necessary to do so. And then that's the affidavit of Mr. Mambolo, which is a next...
Sorry, Mr. Butlander, sorry, just one aspect as far as this is concerned.
Yes.
The operative date is not, when did the Minister make the proclamation, 2nd or 3rd of August? The operative date should be 21 April 2021. Do you accept that? The operative date being the date when the President announced the date for the elections. In other words, for your preparation to start in all earnest. Do you accept that?
In fact, it starts before that, Justice Majid,
yes.
but I accept that. Well, the way it works is that the President informally announces a date.
Yes.
It doesn't create legal obligations.
Yes. Formally, it starts with a proclamation in the Gazette. I accept that, but what I'm saying is that I'm being generous to you. I'm saying from 21 April, let's work from that date. On that date, the IEC knew the following facts as objective facts. A, that the pandemic was going to hit another wave, the third wave in winter of 2021. That was clear on the evidence of the predictions of the experts that in May or June, the third wave will start. And secondly, the other objective fact, by April 2021, the IEC had to postpone a number of by-elections, approach the electoral court and ask for a postponement in 4 or 5. I didn't count, but they started in 2020. Yes. So those objective facts were known.
Yes.
And lastly, that there were serious problems with, at that stage, April, we're casting our minds back to April 2021. At that stage, there were serious problems with government procuring adequate vaccinations. So here's the problem that I have. Why did the IEC not, in the light of those objective facts as they pertained in April 2021, either do one of two things, or maybe both in sequence? Get a formal inquiry going, such as the Moseneke inquiry then already, and or approach Parliament to say to them, this is the dilemma that we have, and we are accountable to you in terms of the Constitution as a Chapter 9 institution, and therefore we report our concerns to you already in April.
Yes. Justice Majid, thank you. Can I take my starting point as the same as yours, 21 April 2021? That is when the president informally announces the date. The very next day, the IEC meets with the National Party Liaison Committee meeting. And it's at that meeting that the political parties say that they are very anxious about the elections because of the problems of campaigning under lockdowns. That directly leads to the IEC appointing Justice Moseneke. Now, Justice Moseneke's formal appointment happens less than a month later on 20 May. But of course, we know the way the world works. You first got to go and speak to Justice Moseneke and make sure he can do it and arrange the practicalities. But so with respect, there is no delay between the 21st of April, which is the president, or the 22nd of April, which is the political party speaking, and the appointment of Justice Moseneke. And so they adopt exactly the stance that you suggest. And with respect, at that point, it would have been premature to approach Parliament, because at that point, the very debate which Justice Moseneke was asked to weigh in on and evaluate was whether there could be free and fair elections. So if the IEC had gone to Parliament and said, we don't think there can be free and fair elections in October, they would have been met with exactly the debate that happened before Justice Moseneke and exactly the debate that has happened here. Some parties say yes, some parties say no. So the IEC does exactly what a responsible organ of state would do with respect. And they say, we are not going to ourselves try and resolve this political concern. We're going to appoint an independent person who is probably the most qualified person in the country, having been not just the Deputy Chief Justice, but everyone will recall, the Deputy Chair of the Electoral Commission for the first democratic elections. We're going to appoint him to do it. He did, I think we can all agree, the most extraordinary job in a public-facing and comprehensive submissions and everything available on the website. He took 2 months, which is understandable given what the stake was. He delivers his report on the 20th of July. The IEC immediately makes it public in conformance with Section 14(4) of the Electoral Commission Act, and immediately, I think the next day, has a meeting, decides to approach this court, and gives instructions, and the papers are launched 2 weeks later. So with respect, that sequence, I submit there cannot be criticism of the IEC, but the important point I wish to make is that all the way along, the IEC continues to prepare as best it can for elections in October of this year. And that is the point that I just wish to emphasize. When you read Mr. Mamabolo's supporting affidavit, which appears next to the founding papers at 244 to 245, and you read his submissions to Justice Moseneke, which appear as an annexure, you will see he specifically deals at pages 257 to 271 with the state of readiness of the commission. That's the state of readiness for the October elections. And he specifically deals at 272 to 277 with the anti-COVID measures adopted by the commission. So it's not that the commission is saying we're ignoring COVID, it's quite the contrary. And then when you look at the next annexure, which is FA 2.2, which starts at 280, you will see that he there deals with both the preparation and the anti-COVID measures. And so the suggestion that nothing is done is just plainly wrong with respect. The suggestion that it is willfully withheld from this court is even more wrong. And it's astonishing with respect that the MEC can persist in that contention in the heads in light of what's in the founding affidavit and the annexures. And of course, it's made clear in the replying affidavit. So the complaint of non-preparation is without merit. And let me just say, while I'm there, the complaint of inconsistency, which was raised by, I think it was Justice Chikri with my learned leader, Mr. Trengove, is also without merit, because you will see, if I could just give you a reference, Justice Chikri, the reply to the MEC, which is paginated page 900, you'll see there that the MEC says, by the time the by-elections were held on 11 November 2020 and 9 December 2020 in the Western Cape, the second wave had begun, yet the Commission did not see fit to postpone these 17 wards. And similarly, the third wave was well underway in the Western Cape when the by-elections were held on 30 June 2021. But what's explained in that affidavit is that all of that is either wrong or out of context, because in those 17 wards, it's true that there might have been a beginning of a second wave, but the country was under alert level 1, not 2, not 3, and not 4. So it's perfectly understandable that the 17 elections between November and 9 December went ahead. And when you come to the June ones, which they say were held in the midst of the third wave, that's just wrong. In fact, those were postponed. And you see that from 12.5 on page 901. So the suggestion from the MEC of non-disclosure and inconsistency is just wrong on the facts. And that short affidavit that we filed yesterday, you'll know that the MEC's affidavit, of course, came in late, which is the reason it had to be replied to separately. It is without merit. The only other point I wish to address, and that's the second one, is Justice Theron's question about the registration weekend. We know that there were 2 registration weekends which were scheduled. The first, which was scheduled, was for 17 to 18 July. And Justice Moseneke explains that that was postponed because it was in the midst of the third wave and we were at level 4, which of course meant it was completely impossible. And then comes the second, it was postponed to 31 July to 1 August. And that's the one Justice Theron, with respect, asked about. That is, Justice Theron, explained in the founding affidavit at page 51, paragraph 98.5.7. And you'll see there that what is recorded is that Justice Moseneke recognized that the voter registration weekend had been postponed to 31 July and 1 August, the last possible weekend. However, this registration weekend, that's 31 July, had to be cancelled because various parts of the country were experiencing the peak of the third wave, and the country has been in adjusted alert level 4 up until 25 July, that's 5 days before, and level 3 from the night of 26. And just to complete the picture, but I won't take you there, if you would have regard to the main replying affidavit at page 679, paragraph 58, you'll see again that the Commission explains why it postponed the second attempted registration weekend on 23 July. In other words, 23 July was the decision to postpone the voter registration weekend scheduled for 8 days later. So with respect, Justices, it's become commonplace to try and bash organs of state. But really, there cannot be a suggestion in my respectful submission that the Commission has sat on its hands or done nothing or anything of the sort. They've acted like a responsible organ of state. They've acted diligently. They've done the best. They continue to prepare for 27 October. But the submission is that it is not possible to achieve constitutionally compliant elections for that reason. Acting Chief Justice, could I turn to deal with the remedy topic then, if I may?
Yes.
On the remedy topic, Mr. Batlender,
yes,
please deal with the relief that you seek that is on the alternative prayer. Is
yes.
that we find the Commission that it has failed to hold the forthcoming elections and that the conduct is invalid, but we suspend it for until end of February next year. The effect thereof is basically that the Commission will get the postponement that it seeks. Am I not correct?
Well, in substance, Justice Mhlantla, you're correct that what it means is that the elections will take place in February. But could I just take a step back conceptually and explain why we submit that that's appropriate relief? Can I just take 2 steps back and spend 1 minute on the main relief? Yeah. If the court is with us on the doctrine of impossibility applying, and I don't want to repeat that debate, and if the court is with us that the doctrine of impossibility is satisfied, in other words, that it is impossible and that it's not the Commission's fault, then I submit that the main relief is perfectly appropriate, and nobody really seems to take issue with that in the formulation. Now let me assume against myself that the court is not with us on that for one of two reasons. Either because, as some of the justices have suggested, the doctrine of impossibility doesn't apply to constitutional obligations, or because it finds that the Commission is at fault. For example, the Commission should have held a registration weekend, come what may. Then, Justice Mhlantla, we're then into the alternative relief. And what the alternative relief does is it does what this court does all the time. What it says is, there has been conduct which is inconsistent with the Constitution. Because let's assume that you say that the Commission should have organized the registration weekend and didn't. You say the Commission was meant to organize the registration weekend. It didn't. Its conduct is inconsistent. That has prevented it from having free and fair elections in October. And so then what you do is you do what a court always does, which is it directs an appropriate remedy to vindicate the rights. You don't, with respect, close your eyes and say, well, now you have to go on in October because it was your fault. Or you have to go on in October because the common law doctrine doesn't fit. What you do with respect is you say, there has been a breach of the Constitution. There's been a breach, just like when we have breaches of the Bill of Rights, but we must now grant effective relief. And effective relief is to make sure that compliant elections happen as soon as possible, and that we're going to direct is for February 2022.
What if you make a provision for the voter registration to take place? Is that not a possibility?
I readily accept it would fall within this court's remedial power to direct that effectively the obligation under section 6(1)(a), I think it is, of the Act is suspended, and therefore you can have a voter registration weekend and you can register voters even though the proclamation has happened. I accept, of course, that would be within this court's power, but the trouble is that on the facts, it has simply not been shown to be just and equitable or appropriate. Because what you are going to do is end up with respect with the worst of all worlds. You are going to end up with the problems created by holding an October election in the era of COVID, which are manifold, and we've explained those. But you're going to compound that by, and I don't use this word lightly, by destroying the Commission's electoral timetable. So that electoral timetable, it's explained in the founding affidavit and Justice Moseneke's report. In order to run the elections properly from the date of proclamation, you need essentially 82, 83 days. That's the practicality of it. What you're now going to do with respect is, and that the papers make clear, is already a compressed timetable. You're now going to take that timetable, which already is even more difficult because of COVID, and into the middle of that, you're going to direct the Commission to hold a registration weekend, which is going to imperil the very verification processes that this court's judgments in Kham and Mhlope have effectively required. So let's just remind ourselves with respect. In Kham, this court held that the Commission had failed in its duties to safeguard free and fair elections. In Mhlope, it was about the addresses. Now, the Commission has taken this court's judgments very seriously, and so it's put in place a whole series of verification measures to make sure that those boxes are ticked. But that only works if the election timetable can run as planned. It can't run if in the middle of this, you are proceeding to impose the registration weekend, because the whole system works on the basis that you register first, then the minister calls the election, and then the 82 or 83-day process runs. What the court would be doing is collapsing those processes, and it would, with respect, be a recipe for disaster. But the other point with respect, Justice Mhlantla, is that might solve, well, it wouldn't solve for the reason I've given. That would notionally solve the registration weekend problem, but it doesn't solve the other problems. It doesn't solve the problems of nomination of candidates. And you will recall that all of the parties unanimously rejected the timetable for the October 2021 elections. And that's the first time it's ever happened. I know we see the political parties at war with each other, but from the Commission's point of view, normally there's actually quite good cooperation in trying to agree on those sorts of timetabling issues. It was rejected unanimously because the ANC said, it won't give us time to nominate. Some parties said it won't give us time to campaign. The DA said, what about the registration weekend? They all rejected it. And so what you're going to do is you might theoretically solve the registration weekend problem, but you will not solve the series of other problems around campaigning, around nominations, and all that goes with it. You will not, in essence, be solving the very impossibility that we are here to seek to address. So I accept it falls within your powers. I must make that concession, but it is in my submission not an appropriate order. And so,
Mr. Budlander, can I raise something? I appreciate that you are now addressing remedies which the court itself can provide, and some of my colleagues asked your leader about why the EC didn't approach Parliament to consider an amendment of the Constitution. And one of the answers which the Commission gives in its papers is that it's not sure it would command the requisite special majority. As I read the Constitution, it says that the term of municipal councils cannot be longer than 5 years. It doesn't say that they have to be 5 years, as long as 5 years. Now, that has to be determined by national legislation. Would it not be possible, given that we are uncertain that free and fair elections, as the Commission defines that concept, will be able to be held in February, or we don't know even any time next year either, depending on how the pandemic works out. If one holds the elections as they were planned in October, making the best one can, and then Parliament can amend the Structures Act when it becomes safe to hold free and fair elections by dissolving all the municipal councils and holding fresh elections. Because all that would require is an amendment of Section 24 of the Structures Act, which currently provides that the term is 5 years, but that wouldn't prevent them saying that the councils elected in 2021 will have a shorter term so that we can hold fresh elections. That doesn't require an amendment of the Constitution. It requires an ordinary majority. What would you say to that proposition?
Justice Rogers, I'd like to, obviously none of the parties have raised it. That doesn't mean it's not available to you. Of course it is. I'd like to think about it carefully, but could I just give you my initial answer? My initial answer is that might be technically possible, but you are then in a world where a party who is, I'm not sure it solves the problem for this reason. You hold the elections then in October. Party X comes and complains and says, but I couldn't canvass and nominate my candidates, etc., and I must therefore declare the elections unfree and unfair. It's no answer for this court or the Commission to say, don't worry, we hope Parliament will fix it in due course. In other words, it still raises the spectre of the massive confusion and lack of credibility that would result from the holding of elections that were non-compliant. It still raises the spectre of the loss of life, but more importantly, perhaps, it then leaves the decision about whether the elections should be result in a full term or a short term in the hands of the majority party in Parliament. And that, with respect, raises all the sorts of problems that my learned leader has already suggested around, is it appropriate for national Parliament to be determining those issues? So I understand why the attractiveness with respect, and I'd like to give it, because it avoids the need for the court to grant a remedy. But with respect, it doesn't seem to me that it answers either the impossibility point or the loss of life point or the credibility point. But I'd like to give it some more thought, if I may, because I may be able to give a more reflective answer in reply once I've had a chance to canvass it with my team.
Thank you.
Well, Mr. Budlander, just one question. The IEC said the elections should be in February. The ANC said April. I think the IFP said May. I don't know if there's another party that said something else. And we know that the experts, the scientists, are saying to a very large extent, we have to learn to live with the COVID-19 pandemic. Now, if that is so, shouldn't we approach this whole matter on the basis that if whatever order we give, if we grant some relief to the IEC, shouldn't it be on the basis that the IEC should prepare and organize an election that is free and fair, even within the context of the COVID-19 pandemic? in other words, give them enough time to organize an election that is free and fair, even in the context of COVID-19. Now, I accept that within the context of COVID-19, maybe if we're at level 5 and level 4, maybe it might be very difficult to have a free and fair election there. Or maybe it's a complete impossibility. But the argument about how safe it will be in October, how safe it will be in February, how safe it will be in November or December, shouldn't it be possible to say, here is the amount of time, and within that time, if you are lucky, we are at level 1, that's good. That won't be a problem for you to organize the election. But we might be at level 3. Organize, because the freeness and fairness of an election ultimately depends on the circumstances. It's not an absolute concept. You know, an election that is free and fair today is free and fair today in the light of the prevailing circumstances today. And then an election that is free and fair in March next year is free and fair in the context of the circumstances that prevail at that time.
Yes. Deputy Chief Justice, Acting Chief Justice, it seems to me that your question involves 2 propositions, if I may. The first is that the question of freeness and fairness is not absolute, and that it is context specific. And I accept that, but only with respect up to a point. For example, an election that doesn't allow proper campaigning or proper nomination of candidates, or even more importantly, uneven campaigning and uneven nomination of candidates, or an election which doesn't involve a registration weekend, in my submission, could never be free and fair. That's the problem. And however much leeway you give for COVID, it could never be fair. So I accept the proposition that the standard will be a value judgment, as my learned friend suggested, but it's not infinitely malleable. But your second point with respect, if I might embrace it, and I don't want to put words in your mouth, but if I could say this, we don't think we do not suggest it's appropriate for this court to direct now that the election will be held on the 23rd of February. And that's not the relief we seek. Yeah. What we seek is an order that directs that it must be held within a given time period. And that would allow, and that's how I understand your question, that would allow the commission, coupled with the minister, on the basis of evolving expert advice, to make a call on eventually when to do it. So let me give you this example. Suppose that the court says, look, the IEC says February, the ANC, I've lost track of who says what, but essentially everybody says something between February and April. We've decided that we're going to give 6 months, 6 months, so a 6-month extension. But that doesn't mean you must hold the elections on the last day of the 6th month. What you must do is start making preparatory steps now. You must run your registration weekend now in the trough. And you must take all the steps you can. But we accept that having done that, it might be appropriate for you and the minister to say, actually, we don't want February. We actually, because the latest science, and of course we'll know more science in a month and more in 6 weeks, the latest science says February will be worse than January and March will be better than February. So hold it in March, or April will be better. So what the court could do with respect is it could grant a 6-month order. And once the court's embracing the principle with respect to debate about 4 months or 5 months or 6 months is really not the be all and end all. You'd grant a 6-month order and you direct that the IEC must report on a monthly basis as to what the steps are. And you say you must hold it within that period. And that would allow exactly the flexibility that you give. And if I could just answer Justice Tlaletzi's point, because it was raised and it relates. Justice Tlaletzi, with respect, you're quite right that in doing that, the IEC would be depending on the assistance or the support of the executive, as is always the case. But a supervisory order is not a punishment order. It's not saying the IEC is a useless organization, therefore we must supervise them. it is always there, as I understand it, ever since TAC. It is an order to deal with the consequences of good faith failure, and it's an order to make sure that the reporting obligations enable the court to keep abreast. And so what will happen in practical terms is that if the IEC has to report every month, and of course the minister's a party to this case, if it runs into problems with the executive, the court will immediately be made aware, and it would allow appropriate orders to be made if needs be. So with respect, your question about is this really the IEC's fault was quite right, but that doesn't mean a supervisory order wouldn't be appropriate. We're quite willing to accept a supervisory order in the interest of transparency and enabling the court to be kept abreast. Justice Zondo, I hope I've answered your question.
You have, thank you. You have, thank you.
But I've also run out of time.
Yes, you have run out of time. We did ask you questions. You ended up with 30 minutes. So, well, but it wasn't your fault. We had to ask you questions. Thank you.
If I could just make one last point, and that's this. Justice Madlanga, your question about Manitoba language rights, with respect is, if I can put it this way, is right on the money. Because what Manitoba language rights says is you start by figuring out whether I'm now in my alternative relief. You start by figuring out whether there's a breach of the Constitution. Let's assume there is. But then you must give a practical order that remedies it. It's no good for the court to say, as you said you can't do in Mhlope, well, there's a breach, now we must wash our hands and come what may. Where the court determines there's a breach, even a good faith breach, the court has to fashion the best order it can. And that's really what happened in Manitoba language rights case. But of course, we can do it more easily because, as you point out, we've got 172, the rule of law and everything else. So we embrace that as demonstrating the need for a court to find a practical solution to resolve the constitutional crisis.
And in Mhlope, I do not think it was really an issue what court should do when there's this kind of impossibility.
Yes.
We were just working within the time frame and nobody was saying, but what if you just cannot, and is it not possible to do something about that? I don't think it was an issue in Mhlope.
It wasn't, with respect, because in Mhlope, everybody knew that the solution was actually obvious. The solution was you have to go ahead with the elections, you get rid of the addresses. Elections had been run in this country without addresses for 20 years, that all unlawfully, it turns out, but they'd been run, that's the way it had worked. And so the solution was easy. But so with respect, Mhlope never grappled with the question of what happens if you need to go beyond the cutoff date. This case does raise that. And if our constitution, with its wide remedial powers and its broad and flexible remedial jurisdiction, if we can't create a judicial remedy for an unconstitutionality brought about by impossibility, it would be astonishing, with respect, because it would mean no country would be able to. Whether the court thinks that's the case here is another debate, but that the power must be broad enough, I submit, must be the case. Thank you, Acting Chief Justice.
Thank you, Mr. Patlunda. Then now we'll have counsel for the ANC, Mr. Steyn. He will have 20 minutes. We'll let him, he will have 20 minutes.
Acting Chief Justice, members of the court, can you hear me clearly?
Yes, we can hear you.
I'm extremely mindful of the queue of aeroplanes planning to land at the airport and maybe take off, so I will endeavor to stick to my limit. I'm going to address the court on 3 topics. I'm not going to re-argue the Section 159 issue and the question of impossibility, but there is one legal point that I would like to, observation that I'd like to make about it. That's the first topic. The second one is to address the central question of the possibility of free and fair elections, particularly from the point of view of my client, the ANC, and the obstacles that it has faced and will face that make it impossible from its point of view to conduct a free and fair process in the run-up to the election. And then the third topic I will address is the question of remedy. And particularly in the event that the court makes a finding of unconstitutionality, what the court may do in the exercise of its 172 remedial jurisdiction. So if I may proceed to the first topic, and first a question of law on whether the court has the power to extend beyond 90 days. We emphasize the wording of the Electoral Commissions Act, section 14.4, which in terms of which Justice Moseneke was appointed. And this is just an observation. It says that the commission may, if it deems necessary, publish a report on the likelihood that it will be able to ensure that an election will be free and fair. And the simple point that I want to emphasize in that regard is it's clearly contemplated there. And we emphasize the tense of this provision. It's not confined to publishing a report only once the election has occurred, in the event that there's a belief that the election was unfree and unfair. But the Electoral Commission may look ahead and assess the probability based on things that have already occurred or that may still occur, that the impending election may be free and fair. So we say that this belies the argument that the only relevant time for the assessment of a free and fair election is after it has already happened. There may be factors in the process, individually or cumulatively, early on or when the election is imminent, or indeed on election day, that render the election not free and not fair. And the legislation, and I pointed to one provision, clearly engages the IEC to be cognizant of that. So I make that observation of law to begin. But if I may proceed to the second topic then, and that is on the question of free and fairness. The opponents of this application focus on the election date, and the learned leader for the IEC addressed this to some extent, but I want to expand upon it. The opponents emphasize that they point out that to some extent the experts differ or are non-committal about the state of the pandemic on the October or February dates. And I'm not going to take you to the references, but you've been referred to them already. But in doing so, they operate with an extremely narrow conception in our submission of freeness and fairness, of free and fairness. Free and fairness has an interrelated logic. It is a process rather than an ultimate event when it comes to elections. If one of those links is broken, if one of those links is compromised, then the entire chain is compromised. So it may be true that expert opinions did differ on the trajectory of the virus, and it's a very complex epidemiological question. But what the experts did not squarely consider, and they were not required to consider this, is not a criticism of them, was the effect of the virus, that the virus had on the entire electoral process. And still less could they consider the effect of events subsequent to the evidence that they gave. And we know that there were very key events that occurred subsequent to the evidence before the Moseneke Commission. The ANC in its affidavit that is sworn in these proceedings refers to a number of adverse effects that are fundamental to the ultimate free and fairness of this election. And if I may just give you the general reference to where it begins its evidence in that regard, and that is in ANC, according to the revised index at page 20, paragraph 28.3. And because of my cognizance of time, I would like to emphasize two of these in particular. The first one is the question of the nomination of candidates and the effect that this disruption of the timetable has caused on that. So the process lasts many months and is extremely time consuming in the ordinary course. The ANC needs to select in excess of 10,000 candidates from 257 municipalities and nearly 4,500 wards. The selection process is arduous and it's crucial to protect, and this is a very important point that the ANC makes in its evidence, it's crucial to protect the integrity of that process, as nominations can be heavily contested and it's necessary to prevent conflict in the fallout from that nomination process. The ANC emphasizes that there's a 5-stage process under its constitution. And I pause here for a moment. Each party will have its own constitutional process, but because of the way that events have unfolded, even with the best of will, the ANC has had no opportunity to amend its constitution in order to attempt to make accommodation for the pandemic and the possible impact of abridged timetables and so on. It has to act in accordance with its internal constitution. And the process, and I don't want to dwell on this evidence too long because it is there in the affidavits, but it begins with local branch meetings where a quorum is 100. Under lockdown, quorum could not be met for many of these meetings. Under level 4, from the middle of June to the end of July, the entire process came to a complete standstill. In other words, there could be no advancement of the nomination process whatsoever. And the court will find all of that evidence, as I say, in the affidavit, and in this respect, in particular, at page 30, paragraph 54 of the ANC's intervention application. And then, if I may take the court to the second key factor that impacts heavily in the process on freeness and fairness, and that is the registration issue. The ANC makes the point that in the ordinary course, this usually lasts 2 or 3 weekends. In other words, there are at least 2 or 3 opportunities to have physical voter registration. And the ANC usually spends many months holding meetings, visiting communities, and in particular emphasizes the importance of schools and campuses in this regard, because this is where new voters who have not previously appeared on the voters' roll are. Now, one knows, and it's emphasized, that schools and campus life was heavily disrupted. In other words, for prolonged periods, including mid-June and to the end of July, there was no activity or very limited activity on campuses and schools. In addition to this, the IEC did embark upon an online registration process. But the difficulty with that, of course, is that data is expensive, the process is complicated, and such a process is heavily skewed to those that are technologically literate. It's prejudicial to those that are not, and for whom there are difficult choices to use one's data for that process rather than another. That is not the kind of choice that other voters may have to make, and voters should not be put in a position like that. And if a voter misses the single weekend of registration that is now contemplated or may be contemplated if there's an amendment, then that voter has to go to a municipal office in particular office hours and register there. That is all very well if one has the means and freedom to do that. But if one is in a job where one can't do that, that is an extremely heavy burden to place on a potential voter in order to participate in these elections. Now, the opponents of the application say that really this doesn't matter as long as the situation is the same for everyone. And the DA is one example of that, but others make that point. But we say that this misconstrues the pronouncements of this court in cases like Cum, which held that freeness and fairness entail parties and candidates must be able to compete on equal terms. And you have the references to Cum. I'm not going to take you to them now. The well-established case law of this court on this does not operate on a principle of mere formal equality, but rather on the question of substantive equality. It is fundamental to consider the effect of these apparently equal measures on those that are less resourced and disempowered and that don't have the same access or ability to be flexible in response to last-minute changes to the way that registration may occur. The reality of South Africa is that not everybody can hop into a car and drive to a registration point and spend 5 minutes there and then leave, or jump on their laptop and use their data and follow the online registration process to do so. Those are very serious considerations that have a bearing on the possibility of a free and fair election. We say that such is the way that events have unraveled in this circumstances, for good or bad, that this is now entirely impossible to remedy for an October date. That is not to say that there may not be a date if the IEC acted in a different way, or if they were more forewarned of it, that they couldn't take measures, but the reality is, and this is a brute fact, which unfortunately this court has to contend with, it's a brute fact that they have not done so, and that cannot be fixed at this point.
Your 10 minutes is up, Mr. Steyn, but you still have another 10 minutes.
Yes, thank you, Acting.
The 10 minutes where you are not interrupted, you can expect to be interrupted anytime now.
Yes,
carry on.
I was going to say as well that I was happy to be interrupted at any point.
Yes, okay.
There's a further response to this, and that has been dealt with to some extent, so I'm not going to dwell upon it too long, but the further response of the opponents to the application is that well, the IEC is to blame. They should have woken up earlier. That is the essential force of the challenge. But the issue is not a question of blame in respect of what the court is confronted with here. It's a question of the possibility of the fairness of the election at this stage. And crucial to that is the fact that there's been no opportunity for parties to adapt. If one says that there are alternative arrangements that can be made at this late stage, there aren't creative measures that many parties can undertake to achieve the same impact. In any event, we just say this, that it may be unduly harsh to judge a Chapter 9 institution which has had the formidable task of organizing a large election, a large local government election, when all institutions have been battling to adapt to the difficulties of the circumstances that they find them in. This hearing is an example of that. The court has enabled its doors to be open, but it's a, with respect, much less complex task than the detailed and formidable task that an electoral body, Chapter 9 electoral body, faces under the Constitution. So I end this part of my submission on impossibility that is part of the process leading up to the election by saying that this court has held that there is no election without free and fairness. And that was, for example, in the New National Party versus the government case, which we refer to in our heads of argument. In other words, freeness and fairness is definitive. It's part of the very definition of an election. Without those elements of freeness and fairness, there is no election. What one is arranging then for October the 27th is some sort of charade. It's some sort of pantomime. It is not a democratic election within the meaning of the Constitution. So we say in that regard that the focus, just to wind up my submissions on this point, that the focus on the date of the election is a mistaken focus, and that as the IEC has submitted, it really is fundamental to focus on the water that has flowed under the bridge and whether that can be fixed. And our short submission to you in that regard is that clearly cannot. So now, Acting Chief Justice and members of the court, if I may just address you briefly on the question of remedy.
Yes.
The chief contention in respect of this is that, or one of the chief contentions, that the unconstitutional conduct has not yet occurred. The logic there is that one must wait for the unfair election to occur before the court can exercise power to grant a just and equitable remedy, to exercise a remedial jurisdiction. But this is based on three fundamental and incorrect premises. Firstly, this court has held that Section 172 may be evoked even where there's no finding of unconstitutionality. And many of the parties have referred to it, but I refer again to the Hurst v. Ermelo case at paragraph 97. So the court doesn't even have to make a finding of unconstitutionality. That is the breadth of the remedial jurisdiction. And that also implicates the debate that was being had with my learned friend, Mr. Badlander, on the Manitoba case, and the fact that there was an absence of a constitutional provision of that kind in that case. In our case, that is not the case. That is not so. There is a broad, just and equitable remedial jurisdiction. Secondly, the court always has the power to intervene to stop unconstitutional conduct in advance. And there are, again, many authorities for this, but the one that I refer to is the Glenister 1 case, which is 2009 1 SA at paragraph 33, where the court was clear that it does not have to wait for a a clearly unfair, unconstitutional event to occur before it exercises its remedial jurisdiction. That would be an absurdity. And the court has gone so far, and it did in that Minister case, to say that there may in fact be an obligation to do so. An obligation on the court, that is, to exercise its remedial jurisdiction if there is a threatened constitutional violation. But the third point I want to make about this is that it is also, again, based on a very narrow conception of the conduct involved. The conduct is not just the holding of the election. It's not just the achievement of saying we can get members of the public to a place on the 27th of October and engage in some sort of a communal act in that regard. Rather, it's the meaning of that. It's what has led up to that. And that engages directly the preliminary steps, the process difficulties that I've referred the court to. And the court has to look in respect of the conduct at that entire process when it considers what the conduct is that would be implicated as unconstitutional conduct in this case.
You have I think 3.5 to 4 minutes left on your time. So
I think I'm going to manage to finish within time, because I only wanted to then address the particular point at which we diverge from the relief that is sought by the IEC in the main application, and that in particular is in respect of the timing of the relief. And what we say is that the most appropriate date for the mandatory relief, in the event that this court finds that it is able and is intent on granting the relief, is an outer date of early April rather than February. And we justify this on two grounds. The first important ground is that the greatest convergence of experts, and I can put it no higher than that, is that this is the safest date for the election itself. So I could go through the evidence, but Silal and Moultrie say March is much better. Karim doesn't address this directly, but he does say that more will be vaccinated by then. Mio says that by March, the country will be better protected. And all of them, Sio, Mio, and Moultrie, all say that a March date is a safer date. So we would say that if the court is setting an outer limit in terms of its mandatory remedy, then April is a safer date, the beginning of April than that. But the second reason is that in view of the slightly later date, this gives the IEC the opportunity to correct any mistakes that it has made in its preparation so far. In other words, it can correct these process errors. There is more of an opportunity to focus on them and to say what things do we need to do in light of the pandemic in order to address ourselves to holding a free and fair election. So that addresses Justice Theron's particular concern that maybe the IEC is partially to blame, but that doesn't. But that issue does not affect the need. But the issue there is that the IEC now, even if it is to blame, then has an opportunity to address those questions, to address those issues in a way that it has not done so far, and that would be in respect of the alternative relief. And the second point, and I don't think we in fact diverge from the IEC in this regard, but the second point in which we thought we diverged was that that we hold that it should be left to the minister in consultation with the IEC to actually set the date. In other words, what the court would be doing in its remedial jurisdiction is to set the outer limit. But as I heard counsel for the IEC say, they are in agreement that there should be an allowance made for the minister on the basis of the evidence that he has and in consultation with the Independent Electoral Commission to in fact set the most appropriate date. So, Acting Chief Justice, those are our submissions on remedy, and that is my submission. I've endeavored to go through this quickly because I know there is a
the time constraints. Yeah.
Yes, indeed.
No, I think you did very well. You did not exceed your 20 minutes, so that was quite good. Thank you very much, Mr. Steyn. And now I call upon counsel for the EFF, Mr. Kasiboto, I think.
Thank you, Acting Chief Justice, the Justices of the Constitutional Court. My heads of argument, the EFF's heads of argument are premised on three main topics. The first of which are the preliminary points around urgency, direct access, and so on. I propose to not deal with that. They're properly and fully set out in our heads of argument, unless, of course, I'm invited by the court to deal with them. I'd rather get to the positive matter of the submissions. And the positive matter I'm going to deal with is the question of the remedies we seek from this court. And before I deal with the question of remedies, I'm going to set the premise upon which we build our argument in relation to the remedies that we seek before this court. So without any further ado, let me perhaps start off by introducing the remedy we seek from this court. As a starting point, we are in full support of the IEC's application. Our remedy only becomes relevant to the extent that the remedies sought by the IEC are dismissed or not granted, the first and the second in the alternative. What we propose, should that be the case, is that this court directs that the minister, the president, as well as the National Coronavirus Command Council amends the regulations, in the alternative, pass new regulations that will allow for the process of party nomination lists. And we'll make submissions as to why we feel that is an appropriate remedy. And I restate, it only becomes relevant should the IEC be dismissed on the first or the second remedy they seek. And perhaps as a starting point in dealing with the positive matter that I'll advance to this court, it bears mention that the Constitution is what I would call a living document. It is not a document for its own ends. It is a document that carries the aspirations of the people which it governs. It is a document that must be interpreted and applied within that context. I think it's a fundamental starting off premise to make. In that respect, and more directly, we're talking about the nominations list. That is the real interest of the EFF outside of the remedies being sought by the IEC. We've fully set out in our intervention application the process that the EFF undertakes in nominating candidates. And without restating all those facts, perhaps I'll be quite brief on this point. The EFF has a document called the Victory Manual. It sets out the nomination process. Having regard to that manual, what one sees is the deliberate attempt by the EFF to make the process as democratic as possible. It requires members at each branch to meet, debate, deliberate, and then eventually elect a candidate. Now, why is this process so important? It is a process that is important because of what this very court has said in various decisions, not least my vote counts. It's the ethos of the will of the people, particularly in a context of the will of the people, particularly rather in the context of local government elections. The utility of this process lies in this very idea that the process sees beyond party manifestos. It says to the members of the community that are intimately involved within the communities they find themselves, fully cognizant and knowledgeable of the potential candidates, they say, this is the one person who understands our challenges, and this is the person best placed to advance our cause at a government, or rather at a local government level. It does away with the generic concept of party manifestos, where you say as the EFF, as a matter of policy, this is what we stand for. The nomination list takes it a layer further, where it says the community itself will decide who must represent them. That is the utility of the process. And it is precisely for that reason that the EFF wants to protect that interest. And it is also worth mentioning that the EFF has got branch representation across all provinces of the country. So we're talking quite a sizable number of people that are being involved here. And it is rather quite regrettable, the stance that is taken by the DA in relation to the proposed solutions to the problem. Well, technology is there, but to what extent and whom does it benefit? We're talking about free and fair elections here. And it should be a matter that should be of minimal, if any, contest, that a large constituent of EFF members, not just the EFF, but certainly in the context of the EFF, they've got branch members who are of limited resources. So of what real utility is it to then make that proposition in the context of the EFF, for example? And the difficulty that is faced by society, should it be that this nomination process is not undertaken, is the potential litigation that follows. Perhaps we should invite this court to consider the potential damage to not having this process. The most obvious would obviously be, well, I was not permitted to run for candidacy as a nominee within the branch level as per the constitution of the EFF. And if that happens, hypothetically, the nomination list is created at a high level, at a national level of the EFF. The difficulty with that, any branch member can bring an application to say the process was not fair, it was not done in accordance with the constitution of the EFF. This is not just in the context of the EFF. One can imagine the same challenges which materialize or eventualize in the context of other political parties as well. The second challenge to not having the process run as it ought to is the difficulty with the political climate that we find ourselves in. I mean, we've got examples of the unrest that can come about should it be that parties or members of the community are disgruntled about decisions that they feel are unjust. If this process runs without it being free and fair, as we suggest, it won't. The difficulty we have is the political climate that would eventualize as a result of that. And we're inviting this court to have regard to that real possibility. I will skip through the other arguments which have been properly and well advanced by my learned colleague for the ANC. And I'll skip straight to the remedy we seek and why we seek it. Perhaps as a starting point, before I deal with the question of the remedy itself, we suggest that in light of the opening premise I gave to this court, which is that the Constitution is a living document and it should reflect aspirations and the rights of the people concerned, I make a proposition, or rather a hypothetical scenario to make the point. Suppose the elections, they are ought to be run by the 1st of November. Suppose for a second that they cannot be run on the 1st of November, but they can be on the 2nd of November. Now, strictly speaking, the same debate arises, but one can readily appreciate the absurdity of saying, simply because we're going to miss the elections by one day, the elections themselves are now unconstitutional and they should have been undertaken. The point simply being made is this, that the question of the extension beyond the 90-day period is a value judgment. It cannot, as a matter of fact, follow that any non-compliance with the 90-day period must by definition mean it's unconstitutional. That is the flexibility we propose is provided for in the Constitution. Again, to make the point, if it was one day late, i.e. the elections could only be held on the 2nd of November, one would appreciate readily that it would be absurd to say, notwithstanding the COVID virus, or rather the pandemic we have, it can't be pushed to the 2nd of November if that was the only practical date. Then it becomes a question of to what extent do you then permit such an extension? And I would suggest that is the value judgment this court is seized with. But what cannot be acceptable is a rigid application of Section 159 as proposed by the opposing parties, notwithstanding all the concerns i.e. to safety and to free and fair elections.
Your 10 minutes up of no interruption, your 10 minutes of no interruption address is up, but you may continue. You still have another 10 minutes if you have not covered all your points.
Thank you very much, Acting Chief Justice. I am going through my pages and I'm trying to avoid repeating points that have been made.
Yes, that would be most welcome if you avoid to repeat points that have been made. And there is nothing wrong if you have made your points briefly in saying, well, I'm done.
Yes. Perhaps Acting Chief Justice, the final point I should make is reference to the decision of this court in my vote counts, which I think is the very premise of our submissions.
Mm-hmm.
The point we seek to make, Chief Justice, is simply this, that the question of what political choice means, the idea of what is meaningful political choice, is not just a question that is readily apparent in the Constitution. As much as it may be, it has layers to it. And this court said as much, that the question of political choice, this is at paragraph 27, the question of political choice is a loaded concept. Much more is required as a choice maker if a choice to be made is political in character and affects important national interests. The point we make there is, in light of the remedy that we seek, one must pay due regard to the importance of that process in informing the would-be voter of the information necessary to make a meaningful choice. The criticism to the remedy we seek, particularly by the IEC, is that, well, it's an internal process, and we fully accept that. But there's a second layer to that proposition. The second layer is that the internal process itself finds expression in legislative framework, not least the Electoral Act itself, which suggests that these nominations lists must be submitted before the elections are to take place. So it's not an entirely internal matter in a sense that it finds no expression in law. And if you have regard to the importance of the nomination process in informing the voter to make an informed decision, then you can readily appreciate why it's such an important remedy that we seek. It is a remedy we seek in conclusion in the event that the prayers that are being sought by the IEC are not granted by the court. And if the court has no questions, as the court pleases, Acting Chief Justice.
Mr. Possible.
Is a colleague with a question?
Yes, thank you, Acting Chief Justice. I don't understand this alternative remedy that you are motivating for in the event that the IEC's main relief and alternative relief is not granted. Can you just state very briefly what it is, Mr. Kasiboto?
Thank you, Justice Theron. The alternative relief we seek, as I've said, is triggered should the IEC's relief not be granted. What we're seeking is in essence twofold. The first is that, and one must happen after the other in the sequence I present the remedies. The first is that the president, along with the minister and the National Coronavirus Command Council, are directed to either amend the regulations such that political parties are allowed to gather and to nominate their candidates. So it's directory, it instructs that step to be undertaken. And linked to that directive would be the second part of our remedy, which is to say the IEC itself must be directed to extend the date for the nominations list submission, which is currently the 23rd of August. And we've given various reasons as to why we seek that remedy.
Thank you. I understand. I think I missed some of it in your first submissions. Thank you very much.
Can I just ask, why is that in the alternative to the IEC succeeding? Because even if the IEC succeeds in having the elections postponed, the DMA regulations may still restrict your nomination processes as per the EFF victory document, even if the elections take place in February next year?
Thank you, Justice Rogers. We have crafted our remedy the way we have simply because we want to attain a specific goal. And the specific goal is simply that the nomination list process must be undertaken. So in other words, assuming for a second that the IEC is granted the relief it seeks, either the primary one or the alternative, the end result of that, at least as we understand the IEC papers, is that then the alternative timetable, the proposed timetable kicks in. And the proposed timetable allows for that process. So in a sense there—
But does it allow for the process even if the DMA regulations, for example, don't permit sufficient people to gather in order for you to have your branch assemblies?
No, I accept the point, Justice Rogers, and I suppose then it is well then that we have in our notice of motion further alternative prayers. That will be at the discretion of this court as to whether how they would deal with that practicality. We're just dealing with the issues at a principal level, and the issues at the principal level are that process must be undertaken. We also take comfort in the submissions made by the minister in front of Justice Musenega's inquiry. The undertaking being such steps will be undertaken to ensure that parties are allowed, one, to contest for the elections, secondly, to undertake all the processes that they ought to undertake, including but not limited to the nominations list submissions. So we take comfort in those submissions by the IEC.
Thank you very much, Mr. Kasboto. I take it that there are no further questions from colleagues. I commend you for having been able to make your points without exhausting the 20 minutes. Thank you, Mr. Kasboto. I'm now going to give the opportunity to counsel for the IFP. That will be Mr. Shapiro.
Thank you, Acting Chief Justice. Acting Chief Justice and Justices, I'm in the happy position of agreeing with most of these submissions, virtually all of the submissions made by our learned friends for the Commission and for the ANC and the EFF, a rare moment of political unity. But whilst there's been a necessary focus on the obligations contained in Section 19, the obligation to present the elections and to do them in a proper way, we submit the focus instead should be on the rights in respect of which those obligations exist and the people who seek to exercise them. So the Commission is certainly obliged to provide elections, but they're obliged to do so that citizens can exercise their hard-won right to vote in a free and fair election and in a safe election. Where they can't do so, where it's unsafe for them to vote, the election shouldn't run and should be postponed. Because as much as one can say times are difficult, it may or may not be safer to run the election at a different time. Let the chips fall where they may. We can't forget that every one of those chips is a South African citizen with interests, with a family, with dependents. And whether the Commission is to blame, whether the Minister acted hastily, neither the Commission nor the Minister are going to bear the consequences of this decision. It's us, it's the people, it's the South African citizenry who will. And we're the ones who will be forced to make what we say is an impossible choice between our health and the right or obligation to vote. We submit on this basis, over and above everything that the court has heard from our learned friends, renders the election unfair. There are three effective bull points that I'd like to get through, and I will do it briefly. I don't anticipate using much or all of the 20 minutes at all, Acting Chief Justice.
That's most welcome.
If I did, as it please you. The first is that it will be significantly safer to run the elections next year. And I'll explain why I say so. The second point is that it's not safe to run the elections. For the voters, it's not safe. to run the elections in October of this year. The third, a point that Mr. Trengove has already canvassed, is that the elections are already not free and fair because a sizable chunk of South African voting population has been disenfranchised by not being able to register. And then fourth, very briefly, to explain why the IFP proposed the alternative date of May 2022 as the outer date by which the elections should run. The first point, that it will be safer to run the elections in 2022. As we appear before you, Justices, today, 10 million South Africans have been vaccinated. Justice Majid's concern about vaccine hesitancy is certainly well made, but where all of the experts agree is that by February, by March next year, there will be millions more who have been vaccinated. The hope is that we will reach approximately 40 million South Africans. That's an increase of 30 million people. And what's important, whether that is 30 million who are vaccinated by February next year or 20 million, is every single one of these people is an eligible voter. It's 18 years and above. That's who's eligible for the vaccine. So by postponing the election, we allow millions more to be protected from the virus that is wreaking havoc.
Mr. Shapiro, may I just ask this? I should have perhaps asked Mr. Trengove, but I didn't have the opportunity. The Moseneke inquiry and the IEC speaks about aiming at community immunity with a figure of 67% by February 2022. Would it be a fair summary of the state of the science that community immunity is actually something of a myth? Because with the vaccines that are being applied in this country, they don't stop people getting infected or transmitting the disease, they prevent serious illness. I raise this in the context of your point, which is not that we will have community immunity by a certain time, but simply that we'll have many million more people protected against serious illness. It doesn't, to say that 67%, for example, may be vaccinated by February 2022, assuming we can overcome vaccine hesitation, just tells us that, well, 67% of the population will have protection against serious illness. It doesn't tell us that the other 33% may not be still subject to serious illness and death.
Quite so, Justice Rogers, quite so.
I'm sorry, Mr. Shapiro. Justice Rogers asked you a question just as I was about to announce that your 10 minutes of address without interruption had just expired. So
thank you,
it was premature, but it was about the right time.
I'm sorry, ACG. I'd overlooked that there was that protection
okay,
time.
But he can go ahead and respond.
We're here to help. Justice Rogers, it is right that there might not necessarily be community immunity, but what there will be is many, many millions more people who are less at risk of dying. And that then means that it's proportionately, or I would say exponentially safer for them to exercise their vote. Whether we get to that mythical point, as you put it, frankly, is neither here nor there, because it's a question of number.
But of course, every later date will be a better date on that theory.
And that's one of the reasons we go for May, we propose May. It gives far more time.
But June would also be better.
June would be better. And I accept it becomes a slippery slope. But the point is this, as we say in our heads, this is a once in a century exceptional event. And it requires an exceptional response. And yes, one has to pick a date. I accept that the court is in a difficult position there in determining what that date should be. But certainly by February, more people will be vaccinated than now. By March, there'll be more than February, and by April, May, as the ANC and we suggest, there will be certainly more than March. That then makes, from the point of the departure point of my submissions to you, Justices, the election correspondingly or increasingly more free and fair, because fewer and fewer people are being called upon to make this choice, this Hobson's choice between their lives and their right to vote. So that's the first point, is that time here is life. And the more time that the court can give, the more chance there is that people can exercise their votes safely. The flip side of that is that it's not safe to run the elections now or in October. Now, our learned friends for the Democratic Alliance in their heads refer to the restrictions on gatherings of not more than 100 people outdoors. And they make the salutary point that these restrictions are constitutional and are a reasonable and proportionate means to prevent the spread of COVID-19. But forgetting the DMA and forgetting that they're regulations, let's pause for a moment and ask about the science. Why is there a limit on 100 people outdoors, socially distant and wearing masks? Because more than that is not safe. Yet what the opponents of the application want to see happen is thousands of people outdoors, standing in a line on one day. If we can't have 100 people socially distant in a stadium, how can it be safe to expose millions in one day over only 23,000 voting spots, voting stations, to the same risk? And that's where we focus, that in getting wrapped up in the principle, which is obviously important, we cannot lose sight of who is going to be placed literally in the firing line if an election proceeds on these terms.
Mr. Shapiro?
Yes, Justice.
Wouldn't the risk be mitigated if appropriate protocols are put in place and the number of voting stations increased?
Justice, I would say no, without being unduly cynical, because South Africans, as Justice Moseneke mentioned in his report, are suffering from COVID-19 fatigue. And even if the protocols are in place, you still have people who do not respect the protocols, who do not socially distance, who don't wear masks. And it begs the question then, what happens to those who are not respecting the protocols who are in the line? Are they removed from the line? Are they denied their right to vote that they seek to exercise? And this is why we say the key point is the vaccines, because that mitigates against the risk. That allows for less risk to obtain, for less risk for not only for those people, but the people around them, to proceed in an election some months from now as opposed to in October.
But Mr. Shapiro, surely we should be encouraging people to obey the law. And if the law says you must wear masks, people must be expected to wear masks. And we shouldn't make arrangements around that and with the knowledge that people will not obey the law.
Justice, it's a very difficult choice, but I think what it recognizes that even with social distancing, if more than 100 people are not safe with social distancing, then 1,000 people can't be. It comes back to the question really of the science there, is that even with those protocols in place, the best science tells us that it's just not safe to expose people to that added risk. And that risk is mitigated if more of them are vaccinated.
There is 3 minutes left of your 20 minutes.
Thank you, Justice. Acting Chief Justice. Finally, on remedy, we propose May 2022. The reason we do that is because it gives a buffer. It allows more time for more people to be vaccinated. It avoids the risk of an election being postponed if, heaven forbid, we're in the midst of a fourth wave in early February or in March. And we also suggest, or as a reasonable step forward, that the election be staggered over a period of 3 days, so that the intensity of the voters who attend at a voting station is reduced, proportionately then mitigating the risk to those voters. But apart from all of that, Acting Chief Justice, we make common cause with the submissions that the court has heard earlier today.
Thank you very much. Thank you very much, Mr. Shapiro. Thank you. I will now give an opportunity to counsel for the Minister of COCTA, that will be Mr. Maineji.
Acting Chief Justice, Justice and Justices of the Court, Like Mr. Shapiro, I'm in a happy position that on most of the issues that have been addressed by my learned friends, there isn't much to be said, and there is no need for repetition. And as the court is aware, the minister abides the outcome of the application, and had said in her answering affidavit, as well as in the heads of argument, that she would, counsel would make comments, submissions to the court to assist in respect of the appropriate remedy and any questions that the court may raise in respect of her role in the organizing of the local government elections. On the question of appropriate relief, there isn't anything that I wish to add, because both our learned friends, Mr. Trengove and Mr. Badlander, and the representatives of the political parties have made submissions which are in line with what we would have submitted to the court. There are only two issues that I would like to address, and I address them because they impact directly on the minister. The first is a submission made by the DA, which criticizes the minister for, as they say, acting prematurely to proclaim the election date, and thereby resulting in the closure of the voters' roll in terms of Section 6(1) capital A of the Municipal Electoral Act. And the suggestion is made almost that the minister somehow connived with the IEC so that when the IEC comes to court today, it can say, if the elections take place on the 27th of October, in circumstances where a further voting registration day is not available or possible, millions of South Africans would be disenfranchised, and that is not a position that the court can countenance under the Constitution. So they say the minister did this together with the IEC to create facts on the ground which justify the IEC making the submission that it has made. We submit that that is not correct on the facts, because, and I make the submission to defend the good faith manner in which the minister acted in the discharge of what she believed were her constitutional and statutory duties. So as my learned friends, Mr. Trengove and Mr. Badlander repeated, the IEC in terms of Schedule 3 is required to put up a timetable for the elections. That timetable must allow for all the preparatory steps to be undertaken that will allow for a free and fair elections. You heard from the political parties about how exhaustive those steps are and how time consuming they are. And Mr. Badlander made it clear that in terms of the timetable, the compressed timetable that the IEC devised in order to meet the deadline for elections by the cutoff date, it needs at least 82 to 83 days. And when the minister made the proclamation on the 3rd of August, she allowed for a period of about 90 days, which caters for that timetable for the IEC. The minister had to do that because she couldn't assume that the IEC's application to this court will succeed and the elections would be postponed to next year. If she did that, she would face criticism by the same political parties, because they would say, by her inaction, she has created facts on the ground on which the IEC will say it is no longer possible because the minister has failed to trigger the preparatory steps under the Municipal Electoral Act by not proclaiming the date for elections. So she is damned if she does, and she would be damned if she didn't. And in good faith, and she explains, justices, at page 632, paragraph 12 of her affidavit, that she believed that she needed to proclaim the date of the election timeously to allow for the election to take place by the 1st of November. And that means that it will allow for enough time for the preparatory steps. That's the first point on the facts. The second point is the IEC has attached to their founding affidavit a letter by the minister at page 572, which is Annexure FA 11, in which the minister makes it clear that in her discussions with the IEC and from the information she received from the legal advisors, she was advised that the IEC did not require her to proclaim the date of the election in order for the IEC to approach the court. Now, once one accepts that, it's impossible to postulate that she proclaimed the date to allow the IEC to come and make the case it is making. The reality is, as the IEC has said, the voter registration weekends did not take place. If you have to have a free and fair election before the 1st or by the 1st of November, you require another voter registration weekend, but that it would be not possible to hold it. And I say no more than simply to allude to what my learned friends for the IEC have said. There's nothing more that I can say about that. So, and in any event, on the DA's own submissions, the fact that the minister has proclaimed the date of election and section 6(1)(a) has taken effect is not at the be-all and end-all. One of the justices, and I can't recall, raised the possibility that that section could even be amended to allow for the voter registration to take place. In other words, to reopen the voters' roll again. But the DA specifically asks that this court should, instead of upholding the IEC application, should allow for section 1(6)(a)'s consequences to be reversed, to be open again. So that is a ready solution in the event that the IEC's application doesn't succeed and the DA succeeds in the contention that it makes. But all I'm submitting to the court is the criticism of the minister is unfounded and it is unfair. The second point I want to address is the questions that were raised by the court about the support the IEC depends upon from the executive. And here I simply want to emphasize what the minister has said on oath, both in a letter attached to the IEC's application and in her own affidavit, that she stands prepared first to comply with any order of this court, and secondly, to provide support to the IEC in ensuring that a constitutionally compliant local government election takes place as per any order this court may make. And in that regard, my learned friend, Mr. Steyn for the ANC said, the court should provide for the minister, after consulting the IEC, to set the actual date of elections and merely provide for the parameters of when that election must take place in its order. And I can assure the court that the minister will comply with such an order. She will consult the IEC. In fact, the correspondence the IEC attaches to the affidavit, it arises from the consultations that were taking place between the minister and the IEC. And in its own correspondence, the IEC acknowledged, and does so in the founding affidavit, acknowledges that the minister was in effect caught between a rock and a hard place because of the constitutional obligations she had to fulfill, as much as they are caught between a rock and a hard place because of a pandemic which is beyond their control. So we submit that there is nothing on bona fide and genuine that can be raised on by any of the parties by way of a blame on the minister's conduct in this case. And that is all, happily, that I needed to address. And thank you, Acting Chief Justice and Justices. Unless there are questions, those will be our submissions.
Just one aspect.
Thank you very much, Mr. Thank you very much, Mr. Munechi. We have allocated you 15 minutes, but there is, I'm sorry, Ms. Justice Majid. I was just saying.
Just one aspect.
Hang on, Justice Majid. Hang on, Justice Majid.
Sorry.
I was saying to Mr. Munechi, thank you to him, but we had allocated him 15 minutes. There is still 5 minutes. So if colleagues have got questions, there is time for some questions.
Thank you. I'll be shorter than that.
Yeah.
Mr. Munechi, just one aspect. Anything to say about the submissions of the EFF regarding the amendment of the disaster regulations in the event that neither the main nor the alternative relief of the IEC as applicant succeeds in this court? Anything about that as from the minister's side? I know that's primarily a question for the IEC, just from your side. Thank you.
Yes, from our side, as you would know, and I think it's reported in many of the judgments in the court since the lockdown was declared, that the disaster regulations are regularly reviewed with the input of the medical scientists. So as a matter of regularity, the regulations will be reviewed by the minister in light of the medical science. What, of course, the minister can't do is to fetter that discretion in relation to the amendments or otherwise of regulations ahead of the circumstances that might exist when that becomes necessary. But what I can say, and the minister has said this on affidavit on countless occasions to courts in this country, that those regulations are regularly reviewed by the executive, by her, in light of scientific evidence. So that's what I can say, Justice Majid.
Yes, thank you, ACJ.
Thank you, Justice Majid. I think there are no further questions from colleagues. Thank you, Mr. Maneji. I think
Thank you, Acting Chief Justice.
Thank you very much. I think we will start with Mr. Jamie, who appears for the MEC for local government in the Western Cape. He will be able to present his argument and use the 10 minutes before we take the lunch break. Mr. Jamie?
As the court pleases, Acting Chief Justice, Justices of the Constitutional Court. This application and the relief sought poses, we submit, two existential challenges to our constitutional democracy. And we say that without without exaggeration or hyperbole. The first existential challenge is the following. The applicant's application seeks to have this court intrude in the most egregious manner imaginable on the strictly controlled constitutional environment of the legislature, Parliament. And it does so on two bases, as you know, the one impossibility and the other the court's just and equitable remedy. As we're going to demonstrate, those two paths that they suggest lead to the same conclusion. This court's ignoring what the Constitution provides in express terms, namely that only Parliament may amend the Constitution. Now, up front, I want to deal with the true nature of the relief that is sought and why we say it poses an existential threat to the very foundation of constitutional democracy in this country. Although Mr. Trengo, for the applicant, denied vehemently that they sought and had ever sought a constitutional amendment, in truth, they do. And whether you use the word amendment, abrogation, suspension, or ignore, it amounts to the same thing. One of the justices put, as I recall, to Mr. Trengo, that in effect, what was being sought was a constitutional amendment, and put to him a passage in their own replying affidavit where that is referred to. And Mr. Trengo said that if they had given that impression, that he apologized. I think it was Justice Tron. But the point with respect, Justices, is it is an elementary proposition of law and logic that you look, especially courts, look at the substance and not the form of what is being sought. And the substance here, however my learned friend, Mr. Trengo, tries to dress it up, is the effect of an order as sought on either basis would amount to this court. So let me use precise language to state to the court what is being sought. Obviously, the notice of motion of the commission does not ask for this court to amend the Constitution. They wouldn't get out of the starting blocks if they did that. So they haven't done that. They've couched it differently. But no matter how you couch it, Justices, the point is that what this court is being asked to do at the end of the day is to ignore, abrogate, suspend, or indeed amend a provision of the Constitution when the solution lay not in the Commission seeking to amend the Constitution itself, but reporting to Parliament its concerns and having Parliament then exercise its constitutional duties and obligations and amend the Constitution if it so desired, in order to allow elections to take place after the constitutionally required period. So that is the first existential threat that this application poses. And we submit it is an insoluble one from the applicant's point of view. This court has over and over again upheld the principle of the separation of powers. This, I say, and I repeat, without, we believe, hyperbole or exaggeration, is possibly the most egregious attempt to ignore that foundational principle of the rule of law. But having said that, Justices, the second existential threat that this application poses is even worse. And the second existential threat is this. All the parties who oppose, I believe, make the point that this court simply has no constitutional power to make the order, and I emphasize this, on either basis, and I will explain this in due course. This court, despite being the highest court of the land, simply has no constitutional power or authority to grant the relief, any form of relief, except one specific form of relief, which I'll get to. But except for that, this court has no power to grant the relief that the applicant seeks. And we say this for the following reason. Section 2 of the Constitution is the supremacy clause. It could not be clearer, Justices. The Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is
Mr. Jamie is
sorry, Justice.
Are you back, Mr. Jamie?
You're on mute, Mr. Jamie.
Well, maybe.
I'm terribly sorry. My device went. I have 5 minutes. I'm happy to carry on and just make, perhaps I can complete my preliminary remarks before I go into
okay. Okay, complete. Yeah.
I won't be long.
Yeah, you can continue and complete that portion. Yeah.
As the court
you may continue.
The second existential. Can you hear me, Acting Chief Justice? Thank you.
Yes, I can hear you. I say you may continue and finish your portion that you have without interruption. Yeah.
I intend to. Thank you, Acting Chief Justice. The second existential threat that this application and the relief sought on either basis poses is this. And I've just read to you section 2. That section, Justices, binds everyone in this country, including this court. The court is not immune. The court is not, as one of the parties who opposes says pithily in their heads of argument, the Constitution is supreme, not this court. And with great respect to the members of this court, that is correct. The members of this court, as has every lawyer in this case, and indeed throughout the country, has sworn an oath to uphold the Constitution and the law upon your appointment. The members of this court, with the greatest of respect to you, have absolutely no power to do what is being asked of you. And we will explain why. But this is the existential part of what we say is being asked and being sought. If this court were to grant the relief sought by the Commission, in this case, it would set a precedent which will stand for as long as this country operates under this Constitution. And there is nothing to say, in fact, you can't say that in 10 or 20 or 50 years' time, in fact, let me rephrase that. In 10 or 20 or 50 years' time, this court's decision, if you grant the commission the relief it seeks, will stand as a precedent. And there is nothing to say that a court in the future, for the best of reasons or the worst of reasons, under the best of governments or the worst of governments, will not be asked by such government and will not grant relief which may abrogate justices any of the rights under our constitution. We know that section 37, for instance, has a list of rights which may be derogated from under a state of emergency, but two of them may not, under any circumstances, be derogated from: life and dignity. Now, what is to stop with respect in 10, 20, or 50 years' time on the basis of a precedent that has been sought? And if you grant the relief, you will set that precedent. Another court, at a different time, different circumstances, facing whatever challenge has been faced by our democracy, saying, well, in this case, Electoral Commission versus Minister of Cooperative Governments, the Constitutional Court did precisely that. And that gives us the green light to do it. With the greatest of respect, and I don't intend to be sensationalist, you dare not do that. You should not do it. You have no power to do it. And to open that Pandora's box would be a devastating blow to the Constitution that we all are sworn to uphold and protect. To paraphrase and in fact turn on its head what Winston Churchill said at the end of the first phase of the Second World War, the Battle of Britain, he said, well, to turn his phrase around, to do what is being asked of you, justices, might not be the end of the beginning, but it will be, with respect, the beginning of the end. I will address my principal submissions after lunch, if you would allow me.
Okay, thank you, Mr. Jamie. We are going to take the lunch break as indicated. It will be 30 minutes. It's now about 2 minutes past, so maybe we stick to 1:30. We'll resume at 1:30. We adjourn.
Court will adjourn until 1:30. Please, 1:30. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 1:30. Should you exit, you may use the same link to rejoin the hearing.
Recording in progress.
Are we all ready? Yes, thank you. I take it that all my colleagues are in. Okay.
Acting Chief Justice.
Yes.
Justice Madondo and Justice Plantler is not yet with us.
Oh, is that so? Okay. Okay, let's wait a bit.
Okay.
Okay. They are still not in, Justice Theron.
Justice Madondo has joined us, Acting Chief Justice. Oh yes, Justice Mplantla has also joined us.
Oh, okay, all right. Okay. Thank you. Let's continue. Mr. Jamie. Thank you. Let me ask this question, which I think goes to your main point. I know you are still going to elaborate on it. You may do so, but let me raise this question. If you accept, as I think you would, that the court would have power to declare the election invalid, unfair, or not free and fair, and invalid after the election has been conducted by the IEC, and if one or more of the parties approached the court and complained that the election did not comply with the Constitution and therefore was unconstitutional, and it did not comply with the Constitution because it was not free and fair. If you accept that after the event, the court can be approached and would have the power to declare the election invalid and set it aside.
Yes.
Would you not accept that even outside of that 90 days, at that stage, the court would be required to grant the aggrieved party effective relief. And that in this context of an election that has been declared invalid, effective relief would be that the election must be rerun, and that this could happen after the 90 days period. And if you accept that that is competent and that the court would have power to do that after the event, after the elections have been run, the question that would arise for me is why can it do that after the event, but it can't do that before the event if it is satisfied that the election would not comply with the Constitution? In other words, is it not necessarily implied that if the court can do that after the event, then it should be able to do that before the event? Because otherwise, if one says it can't do so before the election is conducted, then it would mean that the court would just allow fruitless and wasteful expenditure to happen, and then later there would be a rerun in circumstances where before the election was run, everybody, for example, if that was the case, everybody could see this election will not be free and fair. Now, I'm not at this stage, of course, saying that this election, if conducted in October, will not be free and fair, but I'm simply asking, as a matter of principle, why, if the court were to be satisfied before the election happened, that election would not be free and fair and therefore will not comply with the Constitution, why would the court not have the competence to prevent that election from happening, and of course, grant an order which would allow that election to happen in a manner that complies with the Constitution?
Yes, thank you, Acting Chief Justice. There is a factual answer and there's a legal constitutional answer. Yes. The factual answer first, if I may, is that as you know, Acting Chief Justice, the question of whether or not the elections can be held freely and fairly in October is hotly disputed on the papers.
Yeah.
It's not accepted by any of the parties who oppose.
Yeah.
We say, the opposing parties say that free and fair elections can be held, and that the conundrum that the Commission finds itself in, and from which it seeks release by this court, is one of its own making. Now, that's not to blame it, as some other of the parties do. We don't blame it necessarily, and then seek punishment by denying them a remedy. That's not the constitutional and legal construct within which I make these submissions. But our principal submission, obviously, is this court doesn't have the power and it can't be done. But to answer your question directly, for the court to preemptively prevent or say that elections may not take place, which may or may not be free and fair in October, and that is, therein lies the point. It's not that will not be fair. The highest that it can be said, to then apply the principle, is that at the moment this court may permit or will permit, if the application is refused, elections to proceed in October, which may or may not be fair. We concede that, factually and legally. It may or may not be fair. And none of us are soothsayers and none of us have foresight. So we don't know whether these elections will be free and fair. What we do know is that there will be very different elections to any held in this country since 1994. And that is because of an undeniable fact. They are being held within the context of a dangerous pandemic, the outcome of which and the trajectory of which we don't know. The best scientists in this country on the topic gave evidence before Deputy Justice Moseneke, and these are divergence of views. And therein lies the point that we simply don't. May I proceed?
Yes, proceed. Yes, proceed, yeah.
So we simply don't know, Acting Chief Justice, whether or not these elections will be free, fair, and safe. But the context of that submission must be understood. We, like the rest of the world, are caught in a once in 100 years, maybe longer, pandemic, which none of us could have foreseen. But other countries have held elections generally, safely, and fairly. And there is no bright line which separates us from the rest of the world, and which means that inevitably elections that are held in October will not be free and fair. So that's the first answer I would give you. But the second answer is this, and it's one we make in our heads, I believe, and I think in our affidavit. Relevant to the court's consideration of this matter, and indeed, well, of the present issue as to whether or not you should prevent preemptively these elections, or whether the court may intervene after the elections are held. There's a significant, in fact, fundamental difference between those two propositions. Because if the elections are held, as I've just submitted to you, they may or may not be free and fair and safe. And once the outcome of those elections is known, after election day, obviously, and just to answer that other question that I think was included in your question to me, Chief Justice, Acting Chief Justice, the elections may, or the outcome of the elections may only be announced, will obviously only be announced after election day, 27 October. But 27 October would be the date on which the elections take place and the persons who are elected are elected. So there will be no break in the constitutional order and the constitutional design, because Section 1592 and indeed Section 24 of the Structures Act would have been complied with. Now, if you move to the second scenario that you postulated to me, and that is after the event, someone comes along and complains that the elections were not free and fair. The court would then have facts and not speculation, which you have at the moment, to base your judgment on. You will have facts. Those facts may be disputed, but you will be able to determine whether the elections were free and fair and safe on objectively determinable facts, which is what courts do all the time. That is the appropriate time for this court to consider the freeness, the fairness, and the safety of the elections. It is not, with respect to you, to do so preemptively. And the other point that we make in our submissions, Acting Chief Justice, is that there are
Mr. Jamie, can you hear me? Mr. Jamie? Mr. Jamie? You look frozen on the screen. Can you hear me?
Acting Chief Justice, if I may.
Yes.
Yes, Mr. Jamie did freeze for a minute.
Yes.
Can I also ask for a moment's pause in the proceedings so that we can start recording again? I'll give an indication, or the recorder will give us an indication when it starts recording.
Okay.
Yes, thank you. Thank you, Acting Chief Justice. We may continue.
Okay, all right.
Sorry, am I both audible and visible?
You are audible and visible, but I'm concerned about, I think 2 times you have frozen since you started before lunch. I'm concerned whether in your devices there's anyone that is problematic. Yes, I just want to make sure we don't get interrupted too frequently as you are addressing us.
I think, Chief Justice, I've now changed to my Leonard Jr.'s device.
Yes.
And I hope that's going to be more.
Acting Chief Justice, if I may once again interrupt.
Yes.
Mr. Jamie?
Yes,
please
Justice
make sure that the previous device is switched off. Otherwise, we will have an echo.
No, I've switched it off. I've powered it off.
Thank you, Acting Chief Justice.
Okay, thank you. Yes, you were about to.
I'm terribly sorry for the inconvenience occasioned by my device.
No, that's fine. You were saying you were going to address another part of my question. Yeah.
Yes. Another part of the answer, Acting Chief Justice, is this: the court will have, as I've just submitted, evidence after the event, and that is what courts do all the time. And that would be the appropriate context in which the court will consider what declaration it should make in terms of 172(1)(a). And a myriad of scenarios present themselves. The court could find that certain elections in certain provinces or in certain wards or certain municipalities, etc., were not free and fair and safe, and set aside only those elections. Or the court could, if you find a systemic failure, set aside all of the elections. Or you could, in your discretion, and we know that section 172(1)(b) is wide, although not infinite, of wide import, although not infinite. The court could decide that given either under 172(1)(a) or (b), I'll leave that open for the moment, the court could decide that given the context of the need to hold these elections, and remember, those elections would have taken place in compliance with 1592 of the Constitution and 24 of the Structures Act. And you may then find that the limitation, whatever limitation of fundamental rights in the Bill of Rights, that those elections occasioned is one that was justified and justly limited, rather, in terms of a law of general application vis. Section 24 of the Structures Act. Because that section required those elections, in addition to the Constitution, requires these elections to be held by the end of October. You may well then conclude that the limitation, given that it was held under these once-in-a-lifetime conditions, they do amount to a justifiable limitation of the triad of rights, which would be affected, Section 19, and the right to life, bodily integrity, and access to, or the quartet, access to healthcare. I don't know whether that answers your question.
Well, let me follow up. If the court is approached after the election has been held, and it is asked to declare that the election was not free and fair and therefore did not comply with the Constitution,
yes,
do you accept that if approached after the election, even if it's after the 90-day period, do you accept that in that scenario, the court would be competent, would have the competence to order that the election be rerun?
Yes, absolutely.
You accept that?
Unequivocally.
Now, yes. Now, I may have misunderstood your written submissions and maybe what you said during the first 10 minutes before the lunch break. If prior to the election being run, evidence is placed before the court which satisfies the court that, for argument's sake, I know that in regard to this election, there may be different contentions, but let us say, for argument's sake, on the evidence placed before the court prior to the election, the court is satisfied that the election that is intended to be run on a specific date will not be free and fair, and therefore will not comply with the Constitution. Do you accept that the court would be able, under Section 172, to make whatever order, but that order would enable the election to be rerun because the court was satisfied that the election did not comply with the Constitution, even if the rerunning were to happen outside the 90 days.
When you say, can I just make sure I understand your postulation to me, Acting Chief Justice? Are you saying that the court could preemptively make an order that there must be a rerun of an election that takes place within the prescribed period of the Constitution? Or are you saying the court can ignore the requirement to hold the election and simply say the election should be run, not rerun?
Well, maybe. well, if it was before, we shouldn't be talking about rerun.
I just want to understand.
But let us say the IEC planned to have an election 2 days before the expiry of the 90 days. Okay? And about 5 days before the expiry of the 90 days, the court is approached and evidence is placed before it that satisfies the court that the election that is to be run in 5 days' time will not be free and fair, and therefore will not comply with the Constitution. I'm asking the question whether you are saying in that scenario, the court would not have the competence to say the election must happen, but it can happen after the 90 days because the one planned for 2 days before the expiry of the 90 days will simply not comply with the Constitution. Are you saying it can make such an order?
Yes, Chief Justice, it can't. And it's,
what order would you say it can make in that situation?
It can make no order.
Can it declare that the election will not comply with the Constitution if it is satisfied on the evidence placed before it 5 days before the election that the election will not comply with the Constitution? Can it make a declaratory order?
Chief Justice, I understand why you put the question to me, but the old adage about hard cases making bad law applies. So you're putting to me a postulation which I must just emphasize is not based on the facts of this case. But I know that you're testing our approach and our submissions. So on that basis, I will deal with it.
Yes, please deal with it because the argument that you and some of the parties are raising about whether this court is being asked to, in effect, amend the Constitution is an argument that I'm looking at, but I'm looking at other arguments as well. So and I'm saying, what would the court do? Does it mean that if the argument that is being advanced that this court is being asked to amend the Constitution, how does that argument square up with the argument that might say this court has the power to declare an election to be unconstitutional if it is satisfied that it will be unconstitutional, and depending on what it is that renders it unconstitutional, it may well come to that conclusion even before the election takes place. It can say if this feature, which is an essential feature of a free and fair election, if I'm told 5 days before the day of the election that this feature will not be there in this election, then as a court, I would be satisfied that then an election that takes place without this feature will not, under our Constitution, be free and fair. And therefore, I should make some order. And I would expect that the court would certainly, or would be able to declare that that election will be invalid, will not be free and fair. And then if I'm correct in that it could do that even before the election takes place because of the essentiality of the feature that will not be there, then the next question is, would it be able to just leave it there, just make a declaratory order, or would it be entitled to say this election must be rerun? But if it is a rerun, then it might mean that it would be rerun outside the 90 days period. So this question is part of weighing up the validity of different arguments, including the argument that the court is being asked to amend the constitution. It's being tested against what courts normally do. Sometimes courts are approached to interdict an election before it happens. Sometimes they are approached after it has happened, and they are asked to set it aside.
Acting Chief Justice, in light of the provisions of Section 2 and Section 1592 of the Constitution, my answer must remain that this court does not have that power. And the reason we submit that is because you would be sacrificing, in order to do what you are putting to me, you would have to ignore the clear wording of 1592. And that goes to the core of the our submissions about 172, the 172 remedy that is being sought by the applicant as the alternative basis for its relief. If the court were to grant the relief that it seeks in the alternative, you would not be addressing the breach that would have been found in the 172(1)(a) part of the reasoning. You would be, in fact, reinforcing and supporting that breach, because the elections would not have complied with 1592. 1592 would not have been complied with. And that this court can't do. That is our submission.
But are you, when you say the court can't do that, are you including that it can't make a declaratory order that this election that's going to happen in 2, 3, or 5 days' time will be invalid because it doesn't comply with the Constitution, because there is this feature of a free and fair election that the Constitution requires, which I have been told as the court will not be there? Are you saying it can't even make a declaratory order?
Acting Chief Justice, I've just been conferring while listening to you with my learned junior. I may want to reformulate my response. The court may well be able to make a declaratory order to that effect. But with respect, the court would not be able to countenance the ignoring of a constitutional provision, 1592. And that goes,
yes.
I'm sorry.
No, continue.
That goes to the heart of one of the other submissions that we are going to make, and that is my learned friend, Mr. Trengove, at the commencement of his address this morning, stated the position as being that this is a case of balancing of rights. And why, he asked, should the one right, the right to regular elections, have to trump the other rights to life, bodily integrity, etc.? But with the greatest of respect, that is an incorrect analogy and puts the debate in the wrong paradigm. This is not a question of, I'm sorry, Chief Justice.
No, continue.
This is not a case of the balancing of rights. This case is not about balancing Section 19, the right to regular, free and fair elections, with the rights to bodily integrity, life, etc. That balancing must happen. That is absolutely correct. And we've already submitted to you that balancing should happen after the event. And now we're back to the facts of this case.
Okay. Before you go to the facts of this case, I just want to clear the point of law. So am I correct in understanding that what you are saying is where the court is approached after the election has happened, the court may declare the election not free and fair and invalid because it doesn't comply with it did not comply with the Constitution. And two, the court may order that the election be rerun, even if it is going to be rerun after the 90-day period. You accept that? Is my understanding correct?
That is entirely correct, Acting Chief
Yes.
Justice.
But your point is that there is a difference if the court is approached prior to the election happening.
That is my point in my submission, and we submit that must be the case if you are going to be faithful to the Constitution. Because the conundrum that you face and we all face and the Commission faces is one that arises primarily because of inaction on its part. And we're going to demonstrate that with reference to the facts. But in summary, and we're now on the facts of this matter, not the
principle, not the law.
Well, I hope we're still on the law, but with application to the facts of this case.
I will give you a chance to deal with the facts. For me, the law is quite important if you maintain the submission as I understood it in your written submissions. To the extent that you say, if the court is approached before the election happens, it may make a declaratory order that the election that is going to be held or conducted in like a few days' time will not comply with the Constitution and therefore will be invalid in a particular case. To the extent that you might be accepting that, are you saying it can't direct that order that the election be run later than the intended date, even if later means outside the 90 days, provided or not provided, if the essential feature that would be missing for a free and fair election, if the election was conducted in 5 days' time, would be included if it was to be conducted after the 90 days. Is that your position?
It is the position that I conveyed to you earlier, Acting Chief Justice. I'm thinking about it and potentially reconsidering my submission to you.
Yes,
because
yes.
I can see the point that if it was a few days before the election and if the position was crystal clear that an unconstitutional result would ensue, the court may well have the broad remedial powers that are sought to be invoked here and might be able to grant appropriate relief under those hypothetical circumstances. I can see the sense in that, and with respect, Acting Chief Justice, I then will withdraw my earlier submission of incontrovertible inability for this court to do so, because there the court would be vindicating the Constitution and achieving a constitutional result, and it would, with respect, accord with the constitutional order.
Yes. Okay. No, thank you. You may proceed.
As the court pleases. Now, to get to the facts of this case, Acting Chief Justice, the facts are, and we've said about the heads, the other parties have also made submissions, and no doubt you'll hear them. So I'm not going to traverse the facts to any extent. But the point, but there are some facts I do want to bring to the court's attention. The first fact is that the timeline that was available to the Electoral Commission is not years or months. They've known since the end of the last election. So they've known for more than 5 years, Acting Chief Justice, when these elections had to be held. They've known since March of last year that there was this pandemic that had erupted in the world and had reached our shores. They knew at the end of last year that they had 10 months to organize these elections. We know on the papers that the president announced the date, albeit not formally proclaimed, in April. Now, all of those are milestones which the Electoral Commission was well aware of. The other series of facts that is relevant is the changing lockdown levels in the country. Now that is set out in the Commission's heads at paras 76 to 80. But we've also just drawn up a list, and it is the following. It was level 1 on the 15th of December last year. It changed to level 3 on the 29th of December last year. It then went down to level 1 again on the 1st of March until the 15th of June. It then went up to level 4, or sorry, it then went to level 3 on the 15th of June, but 2 weeks later, on the 28th of June, it went up to level 4, and that was till the 25th of July. And we are now, since the 26th of July to the present, we are in adjusted level 3. And we know that if you have that list of dates, if you've made a note of them, you might want to add next to them or below them the following, that the Moseneke Commission, or inquiry, sorry, was commissioned, it would appear in May of this year. It provided its first version of the report, or its report, on the 20th of July, and a revised version on the 27th of July. And the decision to postpone the elections and to approach this court was taken on the 23rd of July by the Commission. So those are the relevant dates. But the point, Justices, is that the Commission always knew that it would have to conduct elections, and by the beginning of this year and through the course of the year, they knew that they were dealing. Of course, the knowledge came incrementally, but by then, beginning of this year and from in the first few months of the year, they knew that the levels of lockdown were changing, were going up and down. They could have had no certainty and no ability to predict where the lockdown level would be in October. They would have known at some point in the year, once it became common knowledge, that these variants were around and that there were problems both with vaccination in this country. At the commencement of the year, there was a lot of, not controversy, but just the wealthier countries were hoarding vaccines. The poorer countries, such as us, had to struggle to get sufficient vaccines. Africa remains the least vaccinated continent. And we are ramping up, but we're nowhere near where we should be or would want to be. So the EC, along with everyone else, would have known all of that. And the question, Joseph, is why did they wait so long? Why only appoint the commission in May? I mean, not the commission, my apologies. Why only appoint Deputy Chief Justice Moseneke in May? And no criticism is meant to Deputy Chief Justice Moseneke. But this entire process took a luxurious 2 months to play out, from 20 May, when I think he was appointed, to 20 July, when he delivered his report. That's 2 months, during which the commission could, we submit, and should have done the only thing that was available to it to do, and that is report to Parliament. And had it commissioned the Moseneke report earlier, it would have had a report earlier, or had it put strict time frames on the report, it could have lessened the period. A 2-month period at that critical juncture was simply luxurious in the circumstances.
Excuse me, Mr. Jamie.
Yes, Justice.
Mr. Trengrove submitted that had the commission gone to Parliament, it would have created a very bad precedent. And he says in his words that what the commission is seeking to do here is not so much to amend the constitution, but to deal with a crisis situation. And if it were to, for argument's sake, the commission succeeds or the 75% is obtained, that would create a very bad precedent. What are your submissions to that?
Our submissions, Justice, is that that is a bad argument. And it's an argument that misconceives, his argument, with respect, is one that misconceives the constitutional and statutory obligations of the Commission. The first reason that it's wrong is because the 14.4, and we've made this argument, we've developed this argument in our heads, is clearly there for the Commission to obtain a report on the likelihood or otherwise that the elections will be free and fair, and then do something about it. That's its purpose. It's not just to get a report and then keep it in-house and not do anything about it. Now the question is, what must it do with that report? What it must do with that report, we submit in our heads of argument, and we persist with that submission, is they must get it to Parliament as soon as possible. And the reason for that is clear. They do not report, the Electoral Commission doesn't report to court. It doesn't report to government. It reports to Parliament in terms of section 181.5. There can thus be no argument that it would in some other way have been inappropriate for it to approach Parliament, because the Commission is the servant of Parliament, and it was behoven to go to Parliament and say, this is our conclusion. But that's the first part of my answer, but there's a more fundamental part of the answer, and that is this. It simply is beyond the statutory and constitutional powers of the Commission to decide whether there should be elections or not, and when is the best time to hold elections. They are a servant of Parliament, and they are a servant of the Constitution. Their Chapter 9 obligation, Justice, is only to conduct elections that have already been declared by the executive, and they must do that within the confines of the Constitution. And if one looks at section 190 of the Constitution, it says the Electoral Commission must A, manage elections, B, ensure that they are free and fair, C, declare the results, and 2, the Electoral Commission has additional powers and functions prescribed by national legislation. Now, among its powers, none of those provisions permit it or allow it to have a part in the decision as to when elections take place. That decision is firstly provided, or the answer as to when they take place, or rather, as Justice Rogers, with respect, correctly put it, not when they take place, but within the time period they must take place, is provided in the first instance by the Constitution. But the second answer, or the second part of the timing, is a decision taken not by the Electoral Commission, but by, and not by Parliament, but by the executive through the minister. The minister decides, obviously not on her own, in cabinet, which is why the president in this case could announce the date informally beforehand. But the person who fixes the date of elections is the minister. So when the Commission went on this, I won't call it a wild goose chase, but when it followed this route of deciding to come to court and then expressing the view, which we found quite extraordinary, that it thought it inappropriate and dangerous to go to court, quite frankly, the short answer to that submission is it doesn't matter what they thought. It's of no relevance to the determination of this case. And it's a constitutionally offensive argument to put up to say that we thought it was a bad idea to go to Parliament, and then they compound the offensiveness of their position by saying, we also did a head count and we knew we wouldn't get the numbers, thus we didn't go to Parliament. That argument is constitutionally offensive, Justices, because they had no choice in the matter. They are the servant, not the master. They could not. And if I could just, as part of my answer, point you to the following. They were given a clear choice in the Moseneke report as to what they had to do. If one has regard to the papers at page 220, the application papers 220 at para 253 of the Moseneke report. After dealing with whether elections could be free and fair, Deputy Justice Moseneke says the following. It seems to us there are two ways to approach the fixed term set by the Constitution and other law for municipal council. The first option that suggests itself is to seek to amend the Constitution and the applicable legislation. The provisions concerned are Section 1D and Section 1592. And then the learned Deputy Chief Justice, former Deputy Chief Justice, goes on to then criticize or express a view that doing so, an amendment, would undermine Section 1D and may not be done without a supermajority. It may also be said that it is an undesirable democratic practice to amend the Constitution on an ad hoc basis or to solve a short-term challenge. Now, those are the genuinely held views of Justice Moseneke, but with great respect, his views as to whether that is a good idea or not are also legally irrelevant, because in the way that the Commission is set up, its powers, its functions, it has no power, with respect, to take it upon itself to seek to resolve a problem that it sees. Its powers are strictly limited in terms of 14.4 to obtaining a report as to whether the elections will be free and fair. And we say on a purposive, proper interpretation of that provision, once they have that information, they must convey it to their masters, Parliament. And it is for Parliament to decide whether to attempt to, whether Parliament's prepared to amend the Constitution or not. And had they done that timelessly, had they set the entire train of events in motion earlier, they could have done that. They would have had enough time to do that. They could have approached Parliament. What is not permitted is for the servant to say, I looked at the makeup of the master and I decided that I will not go there because I'm not going to get the desired outcome. Then I'll go to court. The second option given in Justice Moseneke's report was the second option, and they chose that option. So they had two options given to them. They chose the one, and they now sit with the problem that they have. The second option, para 254, 221, says the following. Then the question must follow. May a court of competent jurisdiction grant or permit the extension or relaxation of a fixed term, and I emphasize the word, deliberately set by the Constitution. And then he goes on, happily, our current assignment does not require us to answer that difficult question, which we respectfully leave for the courts to decide. And that is what we are doing today. And while Justice Moseneke may be happy not to be having to decide this, unfortunately, you justices, who are the incumbent justices, will have to decide it. But it by no means was a dead cert for the Commission when they received this report that they could just go to court and get an order for the asking. Justice Moseneke himself indicates it's a difficult question. So the answer to what you put to me, Justice Fiki, is that there is nothing wrong. And sorry, there's one last part of the answer that I must give you, and that is this. In their heads of argument, and I think in their papers, they say it would be undemocratic to allow, and they use the word in both the heads and the papers, it would be undemocratic and undesirable to allow a government to extend its own term of office, and this would lead to greater constitutional violence. That, with respect, is an incorrectly articulated and phrased submission, because allowing Parliament, which requires a supermajority of either 75% or 2/3, in this case, I believe it is 2/3, a 2/3 majority, to amend the Constitution is not allowing a government to do so. It requires a supermajority, which would require other parties to come on board. It's Parliament, but even if it was only a single party that could do so, it still isn't within our constitutional architecture allowing the government to do so. It's allowing Parliament, the elected representatives, to do so. And my final answer to the question, Justice, is this. If an amendment of the Constitution is constitutionally impermissible, which it is, then that is the architecture that our framers thought appropriate for our country. And this is the Constitution that we have. It allows itself to be amended, but only by certain majorities depending on the nature of the amendment. And that is the constitutional order. And for the servant to go to the master, Parliament, and say, we believe that you should, or rather, this is the problem. We leave it to you because you are the party that must decide what to do about it. We have no decision-making powers in this regard. We can make recommendations, but we can't decide the question. We leave it to you, our oversight body, to make that decision. And that is the way the Constitution works. So there's absolutely nothing impermissible or inappropriate in allowing and in fact requiring the Commission under these circumstances to have gone to Parliament. I don't know whether I've answered you.
Thanks, Mr. Jamie. Thanks, ACJ.
Thank you, Mr. Jamie. That answer that you just gave to Justice Chikri, is it meant to say that the IEC was precluded or barred from coming to court as it has done without first going to Parliament to tell Parliament about the Mosenega report and letting Parliament decide what to do? Or is the argument meant to say, no, you are not saying they were barred or precluded from approaching the court. You are simply saying the sequence, they should have started in Parliament before coming to court.
Absolutely, Acting Chief Justice. I don't need to go so far as saying they're barred as a matter of jurisdiction or locus from coming to this court. No one has taken the locus point. And I'm not raising a locus point before you this afternoon, but I am saying that that report should have gone to Parliament without a doubt. That's its purpose in terms of 181.5. Just briefly still on the facts, I just want to point out that upon rereading the Mosenega report, Justices, it seems that, and I make the submission, just for proper, or there are two related submissions I want to make to you for proper context of understanding what the Commission's what the report said. You'll find it at para 256 of the report at 221 of the papers. And in 255, the report says, and that coincides with the evidence of I think it's Mr. Mabo Lolo, the Chief Electoral Officer. But Justice Mosenega says, what our current assignment requires us to answer is whether the local government elections set for October 2021 are likely to be free and fair. And then he goes on, having considered all the submissions of stakeholders, applicable law, research on electoral practices during the COVID-19 pandemic and the related science, we conclude, and these are the words that are important, that it is not reasonably possible or likely that the local government election scheduled for the month of October 2021 will be held in a free and fair manner as required by the peremptory provisions of the Constitution and related legislation. And we go further to find the scheduled elections are likely to be free and fair if they were to be held not later than the end of the month of February 2022. So that's an additional thing which quite clearly is not within the remit of what he was asked to report on. it goes beyond it. It's a second step. So to get back to your question of locus, we do submit that the Commission had and has no authority to ask this court to set another date for these elections, such as February, because the report, Acting Chief Justice, was commissioned in terms of Section 14.4, it says so. And that simply permits the Commission, if it deems it necessary, to publish a report on the likelihood otherwise that it will be able to ensure that any pending election will be free and fair. In other words, the election already scheduled by the executive, not by it, but by the executive. It's the sole power that it has, and obviously it can only act within the confines of legislation. It has no other powers. It's a creature of statute. Its sole power, Acting Chief Justice and Justices, is to obtain a report.
Remember, it's a Chapter 9 institution.
Yes.
Not a creature of statute in the normal sense. It's a creature of the Constitution.
Creature of the Constitution. I'm sorry. It's a creature of the Constitution. But it's made a creature of statute by Section 192, which I read out earlier, which gives it the additional powers prescribed by national legislation. So in that sense, and that's the act that we're dealing with, the Electoral Act. In relation to the Electoral Act, it is a creature of statute with respect. And it only has the powers that either the Constitution in Section 190 or this Act gives it. Among those powers is not any power to decide what is the most appropriate time to hold an election. That is not within its powers. It must carry out elections that are scheduled by the executive.
But the point that you now advance, I thought earlier on you were saying that's not your point. You have used the words interchangeably, locus standi and authority.
Yes.
Was that a point that was taken in the papers?
It's not a point. I will fairly admit it's not a point taken in the papers. It's a point that occurred while preparing the matter. I want to expressly make it clear that we don't ask this court to consider the locus of. It's not a locus argument, but it is a legal argument, which, in analysing the proper nature of the powers of the Commission, which this court will have to do, I would imagine, in its judgment, I raise it from that point of view.
Yes, but of course, if you say somebody or a litigant doesn't have authority or a body doesn't have authority to do something, that's a point that you should take so that they can respond to it, isn't it?
Absolutely, Acting Chief Justice. This is why I don't take it as an authority point, because it did not occur to us. It didn't occur to us till last night. It didn't occur to me till last night.
Okay, you are left with 2 minutes in terms of your hour, but I had given you 1.5 hours. But I think it may well be that the most important point that you may have, or points that you may have wanted to deal with, it may be that you feel you have dealt with. I just want to indicate you have gone up to 2 minutes before the expiry of 1 hour. You would still have 30 minutes if you want, if you still have points, but if you feel that you have covered the points you wanted, the important points you wanted to cover, that would be fine as well.
Mr. Jamie, just one question.
Of course.
You say that we don't have the power to grant the order sought or the relief sought. Now, what should we make of the fact that political parties have been unable to campaign, and the fact that some voters who would have been able to register to vote have been rendered, they won't be able to do so now that the date has been proclaimed? How should we deal with that problem?
In our heads of argument, thank you, Justice. In our heads of argument, we associate ourselves with the alternative or the relief sought by the DA. And we submit with respect that were the court, so on the alternative relief, which we, or the alternative basis for the relief, which we oppose, the Commission's relief, you will recall that they say, well, in terms of 172.1a, if you are not with them on the principal relief, then in terms of 172(1)(a), you must declare their conduct unconstitutional. And as I understand it, it's not a debate that we engaged in on the papers. As I understand, the principal reason for saying, well, we already are then in breach, is the failure to hold a voter registration weekend. Now, if that is the case, that they are saying they're inviting the court on the alternative basis to find that they've breached the Constitution, it would appear it's in that regard. And they then say, well, the solution to that is to commit and fortify the constitutional breach that you found and permit us to violate the Constitution and countenance the violation of the Constitution in an even worse manner by saying the elections need not take place. Now, in principle, and as a matter of constitutional law, we say that is impossible. We then associate ourselves, in that instance, were you to be against them on the principle basis, but with them on the fact that their conduct must be declared unconstitutional at present, even before the elections, because of the violation in respect of voter registration, then the solution, it seems to us, with respect, Justice, is that proposed by the DA. And that is that you then, I don't have it to hand, but I think they've got an alternative. They've got two alternatives they put up. The one is that this court may, under its very wide remedial powers, under 172(1)(b), suspend the operation of Section 6(1)(a) of the Structures Act to allow voter registration to proceed and to hold a voter registration weekend. And I haven't applied my mind to the facts of this. I haven't applied my mind to the facts of this, but they suggest or they propose a voter registration weekend in September. And we would submit that that would be appropriate, just and equitable relief in relation to that finding of constitutional breach.
Well, I suppose one can take it further with the counsel for the DA as to the logistics, because the concern was once that is done, it's going to affect the timeline and the schedule, basically. Yes. But I suppose the DA can give us more details in that regard.
Certainly. And the only other point I want to make, really of substance, we've obviously prepared the heads of argument, the justices have read it. Yeah. If there is nothing in particular further that you want to ask me or that you want me to address you on, then I'm not going to simply occupy the crease for the sake of occupying the crease. I'm then happy to cede the rest of my time to the DA. In order for them to make more effective use of the time. But my then final submission would be, because we have no submission to make in respect of remedy, we haven't proposed any, because we say that application should be dismissed. But the final then submission I want to make just relates to the context in which these elections will happen if they go ahead. No one under the present circumstances, justices, can expect a pre-pandemic election or even a perfect election. There are no such things as perfect elections. On the papers, I think it's the Commission's papers or the Commission's, one of their reports or something, they say that voter turnout is generally less in municipal elections than there are in general elections. And that seems, I mean, that's what their own reports or one of their documents says that. I can't recall. Oh, sorry, it was their my junior reminds me, it was their presentation to the Western Cape Provincial Legislature. They said as much. And you'll find that in our affidavit. But the point being, Justice, is that it is highly likely, if not inevitable, that certain rights will be affected negatively by the fact that we're in a pandemic. But those rights are affected whether or not we vote or not. Those rights are being affected every day. We can't go to places of worship. We can't gather. We can't go to stadiums. We can't act in the normal fashion we would conduct our lives. None of us can because of this. And we don't know how long it's going to last. But we all have to adapt to it. And one of the things that has to adapt to it is our democratic system. You don't abrogate our democracy. Even under a state of emergency, I've made the point and sorry, this is one point I do want to make, which is also not made in our heads, but it also occurred during preparation, and that simply is this. Well, sorry, there actually are two points. Well, they're the same points, so I'll make them together. And it goes to Mr. Trengrove's, and I did refer to it, but then I think I got diverted from it. So this is my final legal submission to you. Mr. Trengrove puts the paradigm and the construct within which we must have this debate. He says, why should the right to regular elections trump the other rights? They have to be balanced, and it's all about balance. And he criticizes us for being absolutist about our position. With respect, that is because it's the wrong analysis. Those rights, the right to regular elections, all those rights in the Bill of Rights can be limited. But
I think, Mr. Jamie, I think you mischaracterize Mr. Trengrove's argument. Maybe I misunderstood it, I do not know. But I did not think his argument was about the rights only. I thought he placed the rights in the Bill of Rights on the one side and then placed section 159 of the Constitution on the other. And his point was more that why do you, or rather your client, and any other client that is against the relief sought by the IEC, why do they want 159 to trump the rights in the Bill of Rights? So it wasn't about some of the rights within the Bill of Rights trumping each other. That's how I understood the argument.
No, but if that is what he submitted, then I misunderstood his argument. But I'm happy to deal with it on the basis you just put to me, because that is the answer that I had to the supposed conundrum. It lies precisely there in that 1592 is not a provision, Joseph Madlanga, that deals with rights. It is a constitutional obligation, and it's an imperative constitutional provision. And that cannot be balanced against, it's not a question of balancing that as against rights. The regular right to vote doesn't come from section 1592. It comes from section 19, which is in the Bill of Rights. And that's why I said those rights may be balanced.
Still, I think you missed the point. The point is more that in section 19, in the right to life, access to health care, all of those are provisions in the Constitution. Section 159 is also a provision in the Constitution. So the substance of the argument is more about one provision in the Constitution trumping other provisions in the Constitution. So it's not about others being rights and the other not being a right. No, that's not the point. Constitution trumping other provisions in the Constitution, that's the substance of the argument.
I was going to deal.
So far as I understood it.
I was going to deal with the substance of the argument, Justice Madlanga. Our answer to the argument is it's a false dichotomy, it's a false analogy to say 1592 as opposed to the rights in the Bill of Rights, because 1592 cannot be derogated from. The rights in the Bill of Rights may be derogated from in two instances, section 36 and section 37. And I've already made the submission to you that section 24 of the Structures Act, which requires regular elections and 5 years as the maximum and 90 days, in other words, it mirrors 1592, is a law of general application. So if that law is given effect to, which these elections will do, they have been promulgated in terms of that act, then any consequent election which is found by this court to not have been free and fair, the court will consider whether that limitation in terms of a section 36 analysis was justified or not, given that these elections were held within the context of a COVID pandemic. Non-constat that this court
No, Mr. Jamie. Section 36(1) applies to the law of general application itself, not what would in essence be the conduct of the IEC in going ahead with the holding of elections that, according to it, would not comply with constitutional prescripts. So that would more be about the conduct of the IEC, not so much a law of general applications. I think you are missing it altogether.
I've made the submission and I'll stand by it, Justice Malanga, that in doing so, it would be acting compliantly with Section 24, and it would, the imposition of Section 24 is what would be limiting the rights, and as well as the conduct, obviously pursuant thereto, but it's the invocation of the section. But that is a subsidiary argument, but the principal argument is that this court does not have the power, unlike in the case of rights in the Bill of Rights, to authorize countenance or indeed allow the ignoring of an express provision of the Constitution.
May I take you up? Oh, sorry, you may continue.
No, sorry, that was the submission.
May I take you up on the point that you made in the end when the acting Chief Justice was engaging you, which was to step back from your initial absolutist attitude or approach. In terms of constitutional principle, the position that I understood you to be taking when you stepped back from the absolutist position, in terms of constitutional principle, what would be the underlying basis for the non-absolutist approach?
Justice Madlanga, it would be, I would submit, the fact that the facts in that situation would be absolutely clear, and the court could, I submit, make an order of invalidity, constitutional invalidity in terms of 172(1)A, and then make an appropriate order in terms of B, which would then permit the elections to take place subsequently. It would be the concatenation of facts that would then impel the court, because quite clearly, but the other possibility, given these those unusual facts, would be to direct or to request. The court would have to think. I'm quite sure it would be a situation where the court would have to think out of the box, as it were. And it might involve having to approach on an urgent basis Parliament to remedy the situation with an overnight sitting to amend the Constitution. I'm sorry, I can't answer it more.
I guess, Mr. Jamie, the reference to overnight sitting must be an indication that you are done.
I have done, unless there are any other questions.
Justice Madlanga, were you done? Okay. Thank you, Mr. Jamie. I think there's no further question from my colleagues.
I have.
Oh, Justice
Madlanga, I have a question.
Yes, put your question.
Mr. Jamie.
Yes, Justice.
Are there any alternative measures which can be placed, put in place to ensure that the elections, the October elections, are held free and fair, as Section 19, Subsection 2 provides?
Well, you'll recall the submission that I made earlier, which was to the effect, Justice Madondo, that there had been, and in fact, that is the evidence that we put up in our affidavit, there'd been extensive, and we were told by the IEC, the Western Cape Provincial Legislature was told in terms of the IEC that these elections, about the arrangements that had been made and that elections could be safely held. But even before that, on, I think it was, oh, sorry. What was it that? Oh, sorry, that was May. So I'm sorry. After the presentation to the Western Cape Legislature, the Chief Electoral Officer prepared a submission to the Moseneke Commission. You find that at page 247 of the papers. And not only did she deal with the fact that those elections were being prepared for, and the document runs from 247 to 280, and it's a detailed document showing a range of interventions and steps taken. But in a number of passages in that document, for instance, at page 258, she says that the elections that they're organizing, in her view, would be free and fair. She says it at page 258. She says it at page 258, and then she says it, sorry, at page, in fact, can I just read to you what she says at page 276? Taking into consideration the measures to be applied during the LGE, Local Government Elections 2021, as detailed above, I submit that all the reasonable measures have been taken ensuring not only that a free and fair election will be held, but that they will be held in a manner that safeguards the health of all voters and personnel who will be in attendance, as long as they too are willing to participate to adhere to the measures in place. And yes, so that was her conclusion in June, Justice. And yeah. I've got no doubt, you heard Mr. Budlander say that they are continuing, as I understood his argument, with the preparation for the elections should this case go against them. So I'm sure that in the wisdom of the Commission, they will be able to, together with the parties, they will be able to devise further measures to make the elections more safe. But I reiterate, no one can expect a perfect election or pre-pandemic election in the circumstances that we face.
Yeah, but they have indicated that certain things have not been done. They indicated that only 25% of the population is registered for vote. And furthermore, the registration voter weekend has not taken place, which even other parties, they regard it as very important. So looking at that, would you say that the elections of October 27 will be free and fair?
Happily, as Justice Moseneke was, I don't have to say that, Justice. My opinion as to whether they can be free and fair is irrelevant. But what is important is that a number of parties who are actually the people at the coalface, they believe, such as the DA, and the other parties who oppose the application believe that free and fair elections can be held. They are not, as I understand their position, motivating it on the basis of come what may, let us have elections even if we know that they're not going to be free and fair. I think, I don't pretend to speak for any of them, but speaking for my client, our position is that these elections must take place in terms of the Constitution. And although we acknowledge that there's a difference of view, we think on balance, our client believes on balance, that fair elections and safe elections can be held. And in this province, as I understand it, certainly they will do everything in their power to achieve that result.
Will you agree with me if I say the present situation threatens compliance with the Constitution, and therefore it is appropriate for the IEC to approach the court to salvage this situation?
No, with respect, they should have gone to Parliament, Justice Madondo. They should have got moving earlier with the Moseneke process. They should have been alive from the beginning of the year to the changing landscape of the disease. And they should have taken measures that did not put them and now the court in this conundrum of saying there is nothing else. It's almost a scorched earth approach that we'll create facts on the ground and then ask the court to dig us out from the hole we've created. So they can still go to Parliament. There's no reason why they shouldn't go to Parliament and get Parliament to do what they're asking the court effectively to do for them.
Within the time we have now, that will be possible.
Justice, I think one of the parties makes this point in their heads pertinently. We haven't made the point. But Parliament was, it appears, a necessary party in this matter. Then Parliament could have told you whether it's possible to obtain a constitutional amendment and how long that would take. I think there's some references in some parties' heads of argument. I know there's a 30-day period at least for comments.
Thank you, Mr. Chairman. Thank you, SCJ.
Thank you, Justice Matondo. Thank you, Mr. Jamie. Thank you very much. I will now give the opportunity to Mr. du Plessis, who appears for the DA. And unfortunately for you, Mr. du Plessis, although Mr. Jamie had sought to give you a portion of his time, that portion has been exhausted now, so you will have 20 minutes. Mr. du Plessis, are you there?
Thank you, ACJ. I am here. Yes. You like the Grinch that stole Christmas, ACJ, so I didn't get that extra time. But ACJ will attempt to keep to the 20 minutes.
Yes.
I'm going to have to cut my cloth accordingly. We want to say three things. Firstly, we say that the court should bristle at being asked to assert this competence. Secondly, we say that even if the court could be asked to do so, there's no clear case for the awesome power to be used on these facts. And we stress that this case has come to you very quickly. You've had to convene very urgently. You don't have the benefit of any other court's views. And we say in those circumstances, you would be particularly hesitant to assert any such awesome power or try and explicate a jurisprudential basis for it. We've been trying to debate it, but we would say that you'd be very careful in such a case. And then thirdly, we say that whatever the court does, it should not postpone the elections and it should dismiss the application, because we say there's an easy option open to it, again, on the facts. That's hold the commission to its promise. It's repeatedly made that promise before Justice Moseneke. It's made it now in this case. It's made it in reply, and it's made it through both of its counsel, Mr. Trengrove and Mr. Budlander, who repeatedly have told you that October is possible. They've made all the positions and steps. They've taken everything that they needed to do to make that election possible. They're just worried about whether it will be safe and whether it will be free and fair. But assuming we can clear out the hurdles of it being safe, free and fair, they've made it clear to you that October is possible. And so we'd wish to ask the court to hold them to their promise. And in that regard, to the extent that the court needs to clear out any blockages, well, it can do so. The DA has proposed relief, and my learned friend, Mr. Bishop, will deal with those issues on relief, the timetable for registration, and why a timetable would certainly work still for an October election. So I will deal with the first 2 points, and I'll leave to him the issue of relief and remedy. So let me deal very briefly, if I might.
I'm sorry, Mr. du Plessis. I just missed the part that you say you will leave some points to who?
To Mr. Bishop, to my junior, Mr. Bishop.
Who's your junior? Oh.
Yes.
Okay, so you'll take 10 minutes and you'll take 10 minutes or what?
I'm going to try and take 12 and a half minutes. I'm going to try and leave him the balance.
Okay, all right. Okay, all right.
ACJ.
You still have about 7 minutes of address without interruption. Okay.
6 minutes and 53 seconds now, ACJ. Okay. ACJ, the Constitution is clear, we say. From the politically neutral amici in this case, there appears to be unanimous alarm at the suggestion that this court could grant the relief asked. Why is there that unanimous alarm? And that's the first issue. We say there are at least 4 issues of cardinal constitutional principle why the court should be very wary of taking on that power. The first, of course, is that the Constitution is clear about this. This court is its guardian. It's not its author or its editor. And we obviously know you've read Section 2 of the Constitution. It makes it clear that the Constitution binds everybody, including this court. And so courts cannot make an order that's contrary to the Constitution, because that would be undermining the supremacy of the Constitution. And once courts are not constrained by the Constitution, then the Constitution is no longer supreme. And really, we say that that's something that we've all perhaps skipped over a little too quickly. That's a constitutional Grundnorm point. We're a constitutional democracy. But once the court accepts that it can grant this type of relief, that's effectively contrary to unambiguous constitutional text, we will have become something else. We'll have become a juristocracy. And not even this court's expansive Section 172 powers, we say, permit this. We know the Commission wants the court to use those powers to trampoline its way past the express provisions of 159. And we've referenced all the case law while we say that there are, in fact, discernible powers on this court's remedial jurisdiction. Yes, 172 is extensive, but those powers do not include an effective constitutional amending power and should not be so construed to exist in this case. We've referenced for you Satchwell. We've explained what it says in our heads. I don't have the time to go through it, but Satchwell makes it very clear. This court can't use Section 172, 1B to introduce via the back door substantive relief which would otherwise be properly for the legislature. And that's why we've referenced Satchwell, because substantive relief which would otherwise be properly for the legislature is not something that this court should overlook. And to grant an order which in substance suspends or alters the clear meaning and operation of Section 159, we say, would plainly intrude on the legislature's express powers under Section 74 of the Constitution, which is why, again, in express terms, the Constitution reserves that power to alter the Constitution in respect of those time limits or any other part of the Constitution for the legislature alone. And it dictates the terms for that amendment. So it's not a just and equitable remedy, we say, to disrupt or override basic structural features of our Constitution. There'd be then no limits to that power. This court will be at large to do anything that it considers just and equitable. And we don't want to be hyperbolic, but we must be realistic. We are in a political climate where, with respect, the court must be realistic. If the Commission's right, then everything in the Constitution, every right, every check, every balance comes with some form of on-off switch. Today, Justices, it's the Commission asking for just a little more time for an election. Tomorrow, it's government reaching for another pliable common law doctrine to shirk its socio-economic right obligations because budgets have run dry. Or there's a political party that starts coming to the court asking for a president's term of office to be extended beyond a second term. Or there's an NGO that comes to this court seeking a change to the JSC's composition. Once the door's opened, it will be pushed against. And with respect, we say the Constitution's clear. This is this court's role. It's to be the guardian of the Constitution, but ultimately subservient to it. It is not above the Constitution with authorial power to rewrite it. The second cardinal constitutional principle, Justices, is that the Constitution's founders are its authors, and they reserve the people's power to rewrite the Constitution to one body only, and that's Parliament. We've had the debate about whether the relief that's being sought by the Commission is really an amendment of the Constitution. We stand by what Mr. Jamie has said. We said, substance, it's clear. This is precisely what the Commission is seeking to do. We've referenced in our heads at paragraph 7 that the Commission itself says the purpose of this application is to approach a competent court in order to defer the local government elections. So that can't happen unless there's been an amendment to an express provision which says that you may not defer, you must have it within 5 years and 90 days. And Justice Turon perceptibly picked up with respect at page 694 of the Commission's replying affidavit, where it really does give the candle away. It says, not just a little bit of it in passing comment, it says, I emphasize that any suggestion of a parliamentary solution should not overlook the fact that what's actually being proposed is a constitutional amendment. Well, that's the very amendment now being asked of this court. But this court has already emphatically rejected the notion that the Constitution can be amended outside the procedure specified for under Section 74. And we've stressed this through Reserve Bank 2. We've referenced the case. This court critically stressed that not even this court, these were the words, not even this court with all its extensive powers may effectively direct Parliament to amend the Constitution, because any endeavor to that end may rightly be criticized and dismissed as bereft of seriousness. Why? Given the nature or intricacies of lawmaking or constitutional amendment and Parliament's functional independence. That leads us, Justices, then to the third cardinal constitutional principle, and it's related. the court will tread, we say, with respect to it, with very delicate care, where there's no evidence that the proper route under Section 74 was followed, or even properly considered by the correct constitutional actors. This court can't overcome that fact. There's no clear evidence from the executive or parliament about their attitude to amendment. And that would, we say, be a fundamental violation of separation of powers. Not only that, it would be a preemptive intervention by this court. And that would, we say, be a violation of separation of powers of the most egregious kind, particularly because of the lack of evidence, justices. I know you know the principles of separation of powers, but just to be reminded of the evidential problems. There's a lack of evidence before the court. Parliament and the executive haven't even been joined, so we don't have their views on any encroachment into their exclusive constitutional domain. None of the other parties represented in Parliament who publicly supported postponement introduced a bill in Parliament. The Commission provides no evidence of any attempt to engage with the executive or Parliament to seek the introduction of a constitutional amendment. And there's no evidence of the executive or Parliament seeking to do so either. The only evidence we have of this incredibly delicate separation of powers issue is the Commission in its replying affidavit notice. And with respect, its evidence is woeful. It's a woeful arrogation of power to itself. It says it took the view that it wouldn't seek to encourage a constitutional amendment because it thought it would create a dangerous precedent. Well, with respect, it's never a dangerous precedent to follow the Constitution's path. Then, if an amendment was required, the Constitution set the standard.
I think, Mr. du Plessis, your 10 minutes is up, but I may be wrong. Maybe you still have 1 minute of address without interruption. But if you don't mind me coming in now, even if there might be still a minute, then I would like to. Yeah.
Of course, SJ.
Yes. You said you stood by the submissions made by Mr. Jamie, but it may be that you stand by some and not others. You remember he and I had an engagement, and he revised his position in the light of that engagement. Do you want to tell me where you stand with regard to his revised engagement? Is that one of those you stand by, or that's not one of those you stand by?
ACJ, I'm coming to it, if I may. It's lying ahead. I promise you I'm coming to it. But before I get to it, if I might just say a little bit more about what I was saying. About the evidence around separation of powers. We've said it's never a dangerous precedent to follow the Constitution's path. And the Commission's come back to say, well, it might have been a tough job getting a 75% supermajority for the amendment. But exactly, that's why these amendments are not to be taken lightly. And it's frankly alarming with respect that the Commission thinks that it might have got an easier road to constitutional amendment by approaching the court. Also, and this is critical, had it gone to Parliament, Parliament could have got advice about other solutions that don't require constitutional amendments. For example, the proposition that Justice Rogers raised with my learned friend, Mr. Budlander. There may have been the time and the approach to ensure that none of this difficult question and jurisprudential quagmire now faced by the court had been something reached, because Parliament would have been approached. So with respect, it's a simple point. The executive and Parliament have the power to amend the Constitution. There's no debate about that. They've got a responsibility aligned with that to exercise that power properly if the need arose. There's simply no evidence before this court of their views here. The fourth, and now I'm coming to your question, ACJ. The fourth and the final reason of constitutional principle we say to refuse the relief is that, as it turns out, we say the Constitution is absolute. The Commission, we've heard, has said that that absolutist position is problematic. And they've labeled us as absolutists. But
I thought you were conceding that you are absolutist.
Well, exactly. We quite proudly embrace the label. And we do so because it's the Constitution's time limit, firstly. If anything has been set, it's been set by the Constitution, and it has been set absolutely by the Constitution without any exception to the express language at all. And any effective amendments to that provision of the Constitution has been set again expressly by the Constitution in absolute terms through 74 of the Constitution, which prescribes the conditions for its own amendment. So our learned friend says there's no constitutional basis. I think these were his words. I try to write them down. He said there's no constitutional basis for the absolutist contention that the time bar should trump the competing constitutional requirements. But we say with respect, and obviously when one says that Mr. Trengrove is wrong, then you do say it with great respect. We say he's wrong for 3 reasons. Firstly, the constitutional basis that we invoke arises from bedrock constitutional principles, the regularity requirement in the Constitution, separation of powers. Sorry, turns out that my computer's running flat. Let me just plug it in again. Sorry, Justices.
Okay, all right.
So the constitutional basis, we say, arises from the regularity requirements set by the Constitution, separation of powers, rule of law, and the supremacy clause. We've set those reasons out comprehensively. I'm not going to go over them again, but tellingly, it's the regularity feature that's the founding value in Section 1, not free and fair. Why? Because Section 1D in the Constitution tells us we must have regular elections to ensure accountability, responsiveness, and openness. The second reason our learned friend is wrong is that we want to hold the constitutional line, because it's not holding the constitutional line and saying parties don't have a remedy, ACJ. Any party who wants to claim that an election was unfair could come to court to challenge it. The power to do so has been affirmed through the Constitution together with parliamentary statutes that have given parties that power. And in that circumstance, the regularity requirement in the Constitution would have been honored without this court having had to assume this preemptive and very awesome power of effectively amending the Constitution. So then to answer the ACJ's question, the law question, we say there really are 4 answers to it in brief. If the elections, ACJ, can't go ahead, your proposition, there's some natural disaster. If the elections can't go ahead, then they won't. If they can physically go ahead, but there won't be a free and fair election, then that must be dealt with in terms of the legislative process that has been set out through the Constitution together with the statutes that regulate this. Thirdly, so the election must be held, and those who wish to object to it must be, by this court, kept to the statutory process. They, in other words, can come to this court if they're upset after the fact and say, well, they think that the election wasn't free and fair. They can, but then this court must tell them there is a process set out in the constitutional scheme together with statutes which regulate how one comes to complain about what you regard as an unfair and a not free election. And this court would be able to, in that way, respect both the regularity requirement of the Constitution together with, frankly, the very important statutory scheme that has already been set in place. Now, this court may think that there's a better way to do it, but that's not open to it. This is the way that the Constitution and the law have chosen to deal with it, ACJ. Nobody has challenged that particular process. There's a fourth.
I'm sorry. You're still on the floor.
Yeah, he's
sorry,
still
sorry.
Sorry,
yeah.
Justice Madlanga. I assumed that there might be questions on this, but if I might just finish the first point.
Well, I still have a question on your second one, but I wanted you to finish the fourth one.
Thank you. The fourth answer is this. ACJ, you pose, with respect, a good question, but it's an entirely abstract one. And we say it would be very dangerous to set a bracing precedent in this case, as I've said, an urgent case, no benefit of any high courts or the SCA having given their views. Very, very important principle that you would be establishing and potentially opening that Pandora's box. We would say it would be very dangerous for the court to say anything about this type of preemptive power on the basis of the ACJ's abstract law point. It's not necessary to decide that law point preemptively. And we say with respect, it's not necessary to decide that because of a well-established principle in this court, and that's the principle of avoidance. This court doesn't go to big and what would be, in this case, fundamental constitutional structure questions, unless it's got all the necessary armory in place for it to do so. And here, very fortunately, ACJ, you don't need to get there at all, because on the facts in this case, the Commission doesn't make out a case at all for impossibility. The Commission's relief in this matter, we say preemptively coming to you in the way that they have, can be rejected purely on the basis that, as we will show next, even if this court had the power So even if you hypothesized your question and hypothesized that there could be that answer, you, ACJ, and the rest of the justices would, with respect, be very careful about trying to write any form of judgment that sets out what that power would look like or how it might be used. Much better would be for you to say, even if we had that power, that's for another day. The test for suspending or amending the Constitution is not met in this case. And I want to then briefly, and I'll answer any questions obviously on that. I'd want to briefly, if I may, move to why we say the test is not met.
Yes, you see, the question arose simply because I understood the DA as well as the MEC for the Western Cape, and I think there are other parties and some amici who seem to argue that the court doesn't have the power to make the kind of order that the IEC has asked for. Now, there may be arguments about whether the order that the IEC is asking for is a postponement of the elections, or whether it's an order simply that gives an interpretation or that declares what the law is, namely whether there can be elections can be held outside of the 90 days. And if this court makes such a declaratory order, then the relevant functionary can then move the date to outside the 90 days. There can be all kinds of argument about that. But the question simply arose because this argument that the effect of the order being sought by the IEC would be to amend the Constitution was an argument that I was looking at, and I'm testing it to say, but what does the court normally do? What powers does it normally have when it deals with electoral disputes? You know, that's why I started when I asked Mr. Jamie by looking at a situation where the court is approached after the election has been held. Then after he had answered that question, I said, well, let's then come to a situation where the court is approached before the election is held. And I didn't say this to him, but I can mention because I've now remembered it, that the provisions of the Constitution, which give the court the power, what he considered it can do if it is approached after the election, are the same constitutional provisions that would be relied on to say what are its powers, as I see it. It's the same section. So on the face of it, it appears to me that the concession he made was properly made. So, but I was raising it with same question with you because it seemed that you were arguing the same point he was arguing before I raised the issue. And obviously, if you have a different argument, I'm interested in hearing it. So the question was simply to say, if I'm going to uphold, if you ask me to uphold the argument that says this court doesn't have the power to grant this kind of order, I want to test that submission against what the court normally has. But obviously, if that argument is not there, then I don't have to look at it. If you say, look, we are simply saying on the facts, even if you do have that power, don't use it on the facts of this case. That's one argument that's separate from saying the court has no power.
Thank you, ACJ. No, I think I understand. And so certainly our argument is both. So we say that this court, even if it had the power, shouldn't exercise it. But as you yourself have just said to me, ACJ, ordinarily, the way that it happens that parties challenge the election outcome is after the fact. And that's not only because they're then better placed because they know the evidence and they can see what's unfolded and they can build a proper case, but it's also because that's the scheme, is that the Constitution, together with the statutes that work interlinked with it, allow for that to happen after the election has happened. And we say that there's a perfectly good understanding for why that's been permitted by statute. It's because there's a regularity principle that is inherent in that, which is that the election should have been held. The election should have been held. So that's why these are ordinarily after the fact challenges. And therefore, we would say that you would be very careful as a court in allowing a preemptive challenge to the outcome of elections, purely on the basis that somebody can come afterwards. But for as I say, not only for factual reasons, but also because unlike for the after the fact challenge, which is catered for in legislation, which is permitted under the constitutional scheme, there is no form of express, and we would say definitely not implied, power for a court to entertain a preemptive strike in relation to an election, because the Constitution on 159 doesn't say the elections must be held within the particular period, unless the IEC can convince through a court the justices at Braamfontein that it's all fruitless and wasteless expenditure and it's an impossibility. It doesn't say that for them.
You see, Section 172 Section 172.1 says, when deciding a constitutional matter within its power. So it's got to be a constitutional matter within its power, that is the court. A court, and then under B, may make any order that is just and equitable, including, then they've got those orders there. So I understand this to mean the court can't make a just and equitable order in a matter that doesn't fall within its power, okay? But as once the matter falls within its power, then the court may make a just and equitable order. Now here, I'm not sure that I understand why. Are you frozen? Is Mr. Du Plessis frozen?
I think I'm still here, sorry.
Oh, okay, I'm sorry. Okay, I don't understand, I would not understand why anybody would say a matter where a party comes to court before the elections are held and ask the court to make an order in effect that says that election that is planned for that day will not be free and fair because of the following reasons. I therefore ask the court to make that declaratory order. I wouldn't understand why anybody would say the court would not be competent to make that order. I wouldn't understand why anybody would say that would not be a matter that falls within the power of this court. And then if the court was satisfied on the evidence in regard to that specific election, why it would not be able to make that declaratory order. And if it can make such a declaratory order in an appropriate case, my next question would be, would the declaratory order be enough? Would that be effective relief? You know, Mr. Du Plessis, the jurisprudence of this court is clear that where rights have been infringed, the court should grant effective relief. What effective relief could the court grant other than relief that enables people to vote, or a relief that enables the election to be run so that people can vote who were denied a fair and free election? And if this happens to be close to the expiry of the 90 days, it might have to be outside the 90 days for the relief to be effective. So that's the thinking, and I'm giving you a chance to indicate to me why that thinking is wrong.
Well, I thought I'd tried already, but ACJ.
Well, if you thought you tried, I'll understand. But I'm just wanted to make sure that you understand what my thinking is.
I think I do understand. Thank you, CJ. And I think firstly, to answer the question, well, through the lens of effective relief needs to be given. Assume for a moment the court could take that case 5 days before the election because there's been a confirmation that there won't be free and fair elections for whatever reason. Effective relief, which does give a right, or effect to a right rather, would be in the form of, you can't come and ask us to do anything about this, because there is a process that has already been set in place through the legislature, which sets powers and competences and rights for parties to go and make their claims about whether this is free or fair. It's not for us to do so, but we in any event as the court don't need to do so, because there is where your rights lie. So that's the one question. And effective relief would then be for the court to say, this is not our job. You shouldn't be approaching us. The statutory scheme exists for you to go and make those claims. So that would be the one answer. As I've said, the court—
Please remind me, Mr. Duplessis, I'm sorry, please remind me, what would that entail other than going to court? Those processes.
Well, I think we've set them. Sorry, I think we've, well, firstly, you would be able to go and challenge. In terms of Section 25 of the Structures Act, you'd be able to go to court and you would be able to claim that the election wasn't free and fair. So that exists. And the Structures Act sets that power or that right availing to you because of an understanding of the constitutional scheme, which specifically insists that there's a regularity that is in place. Every 5 years, the elections must be there. And ACJ, I don't have the time, but we've set it out.
No. The answer you
in our heads of argument,
is enough when you say it includes going to court. But am I right to say what your answer then means that where the court, even where the court is satisfied that this election that is coming up in 5 days' time is not going to be constitutional, it's not going to be free and fair, if it is approached by an entity such as the IEC, the court must simply say, no, go ahead, run the election. We know it's not going to be free and fair. We know it's not going to be constitutional, but go in and run it. There will be fruitless and wasteful expenditure, but let people come to us after.
No, ACJ, that's why I was saying in my answers to you, if it is convinced that it can't hold the election in a free or fair fashion, then it won't hold the election. And then it will have to—
What if it says, look, we think it's not free and fair, but we want to be sure, we want a declarator by the court. We don't want people accusing us of breaching our constitutional obligations. We want the court to declare that in this situation that prevails, we don't have an obligation to run this election on this day because it will not be a discharge of our constitutional obligations under these circumstances. If we are given a chance to do it on another day, we will be able to discharge our constitutional obligations. But on this day, because of these reasons, it will not be possible to have a constitutionally compliant election. So we should not go ahead and do it.
I think there are two answers. The one is, ACJ, that it's the one I've given, that one can allow the election to pass and you can go and confirm why you were right in believing that you didn't need to spend money and it wasn't going to be safe or fair or free by virtue of the processes that exist. They're there in the statutory scheme. I have to say that might sound absolutist. You might think that that's unwieldy. I might think it's unwieldy, but that's the law. And that's the constitutional scheme. The other approach may be something along the lines of, and I haven't thought it through properly, so Justice Rogers will I know forgive me for not having thought it through carefully, but the question he raised with Mr. Budlander, a variation of something along those lines might be an opportunity for the parliamentary process to be engaged very, very quickly, and for the Electoral Commission owing its obligations to report to Parliament, to go and say, we come to you, this is our problem, let's debate how to deal with it. But that it is something that should be put in the court's hands, we say, on this abstract basis, we say is deeply problematic. But I've given the best answers I can, ACJ.
No, that's fine. I haven't forgotten that Justice Madlanga had a question, so you can say what you need to say, and then Justice Madlanga will ask his question.
I was going to finish off this point and move on. So, but I think Justice Madlanga wants to ask me on this.
Justice Madlanga, go ahead, please.
Please,
yeah.
Thank you, Acting Chief Justice. Mr. Tracy, you emphasize the regularity of the elections in a way that suggests that those foundational rights, the A, B, C, D, are sort of standalone and not preceded by something. Let me read what precedes them. The Republic of South Africa is one sovereign, democratic, please underline democratic state founded on the following values. Then your one about regularity comes in under that as well. I emphasize that democratic advisedly. I do so because if you say that the IEC must just not fold its arms and not hold elections at all, because I think that's the one response when you said there are two answers, or even go ahead with a sham election, which will then be challenged under Section 25. I mean, assuming that there were to be no challenge at all, what of that part of these founding provisions that say that South Africa is a democratic state? Wouldn't that be a sham democracy at all?
No, because built in, Justice Madlanga, and it's a difficult question, and I repeat what I said earlier, this is difficult because we really are speaking about an extreme abstraction 5 days before the election. But let me answer it as best I can through the democratic lens. Because, as you know, Justice Madlanga, the term democracy in our constitution has a variegated number of features to it. And one of the features of it, of course, is that we're a constitutional democracy. So only the people, through Parliament, can determine that the Republic's foundational text is inadequate. So it's consistent with democracy for courts to declare legislation inconsistent with constitution because the people have granted the courts that power. But we say the people have not granted the courts the power to contradict clear constitutional commands. So that would be a democratic answer. But it highlights, just with respect, how this is a contested area. And I suppose the point is we're having a somewhat of a philosophical jurisprudential debate, and I welcome it. And I'm suggesting that the answers are not neat ones. And I'm going to finish with respect, if I may, on this point.
It's hypothetical. It's not hypothetical because you do not know what we will hold on the evidence. You do not know.
No, that is so, Justice Madlanga, that is so. But let me say that this case is the paragon example, we say, of where the court should be particularly careful about constructing any jurisprudential principle that effectively has this amending notion built into it, for the reasons I've given. And so if there's a way for the court to avoid answering that question, whether it's on the principle of avoidance as a constitutional principle itself, whether it's on this court's case law, and there is case law, I can't remember off the top of my head now, but this court and its researchers will find it, and we'll happily give it to you afterwards. There's case law that says that this court has said, even when it believes that it's got a constitutional power to do something, it won't grant a remedy because there's a problem with granting that remedy, or because this court decides that it jurisdictionally doesn't want to take such a case at this particular time. Whichever way one looks at it, we say this is the paragon example of a case where you'd be very careful as a court of first and final instance with no benefit of any time or previous jurisprudence from below to write any form of all-embracing constitutional power that allows you to do so. So to the extent that the court wants to avoid that, then the best way, perhaps, is immediately to get to the facts. And if I may then get to the facts, because I know my time,
just one last question.
Your time is long gone.
I'm sorry.
One last question, please, Mr. Du Plessis. And I raise this with no alacrity at all. I think I'm more attracted to the question that the acting Chief Justice has been raising than to what I'm going to raise. You remember what I said about the Manitoba language rights case? I would like you to just comment on that. I'm not suggesting that it was a question of impossibility. No, impossibility arose as a result of the court's pronouncement of invalidity. it then became impossible as a result of the declaration to correct the constitutional defect within a time. And then the question was, what happens to the rule of law? And then they suspended, even though they have nothing like Section 172. But why I see that case as analogous is they have their Section 52, their supremacy clause in Canada. And despite that, so the supremacy clause then stated that they must declare the law invalid. But they were able to still keep the law in force without an equivalent of 172. So effectively, they did something unconstitutional unless you say, but they have these underlying unwritten constitutional principles, which include the rule of law. So here's the analogy then for me. If they could do that, because I've just made a reference to democracy here in our founding values, it's there as well. If they could do that in Canada, why is it that we cannot do something similar here? Something which on the face of it appears to go against the Constitution. But if the court will be doing it to vindicate democracy itself, why is it that that a court cannot do that? As I say, I'm not raising it with alacrity at all.
I'm happy you're not raising it with alacrity, Justice Madlaga, because I must be honest, the last time I read the Canadian jurisprudence was some time ago. But as I recall, there is at least this difference, and that is that in Manitoba language rights, I think there'd already been a constitutional violation. It wasn't a preemptive decision as we are dealing with here. It wasn't an effort to try and use 172.
No, I've stepped off. I've stepped off the preemptive and so on. I'm just now focusing on the idea of impossibility, making it possible for us to do something that is not consonant with Section 159. That is why I preface my response by first saying I'm more attracted to what the acting Chief Justice says. That was in the context of the preemptive. Now I'm trying to step off that and raise a broader question of impossibility, but trying to infuse constitutional principle into it rather than merely relying on it as a common law principle.
Yes, I understand, Justice Madlaga. I think we've got, in our heads, and again, my time is sufficiently short for me to be able to hopefully respectfully say, we've dealt with the impossibility problems and the difficulties why we say that doctrine can't be used. So I'm going to leave it at that. And I know that various of the amici are going to be dealing with that in greater detail. So the most we would say is that on this score, we would be very nervous of importing Canadian jurisprudence into this particular case, where there are already at least established South African cases and South African examples of when the impossibility doctrine can be used in a manner which we think might be perhaps more helpful to the court. That being said, if I might then turn, Justices, very briefly, I know my time has been taken up.
Well, I was going to say, I wonder whether you'll still leave anything to Mr. Bishop or whether you'll just finalize.
Justices, let me just say then very briefly, if I might, before I hand to Mr. Bishop, that we say that of course the test has not been met for in any way suspending the Constitution. And I think we might be the only party that has suggested the test that the court should adopt if it's wanting to go this road, which would be the clearest of cases. And we've referenced this court's case law for the court, and in particular, this court's recent decision in Biadika, where it said that it would only be the clearest of cases that this court would allow itself to depart from an accepted standard of our law. And there the court used very important words. It said that it would only do so where the evidence was substantially incontestable. And we say this is certainly not the clearest of cases. We've set it out in our written submissions, ACJ. I know that my time has run out. We commend those to you. If I might then hand over to Mr. Bishop.
Okay, thank you. Thank you, Mr. du Plessis. Mr. Bishop, Mr. du Plessis, I think, had was going to give you originally 7 minutes. I think I'm going to give you 5 minutes.
I thought I had about minus 20 minutes at this point, but I'll do my best, Acting Chief Justice.
Okay, all right.
The only issue I need to deal with is this question of registration and whether it's possible to have a registration weekend before October 27. And we say it is possible. My learned friend, Mr. Budlander, said that our relief will provide the worst of all worlds. Quite the contrary, it'll be the best of all worlds, because we will have regular elections, we will have safe elections, and we'll have free and fair elections. It may not be perfect. It may not be the way the IEC would do it in a perfect world. It may not comply with every party's demands and wishes for how they would like the election to go, but it will be free and it will be fair and it will be regular. So I want to start with just quickly four general propositions. The first is that we accept, and everybody seems to accept, that if you don't have the registration weekend, the election will not be free and fair. And it's not just a registration weekend in the abstract, it's a fact that the IEC promised a registration weekend and then didn't hold it. So people, it's not like they said, we're not going to hold one and gave people other ways to register. People were waiting for the weekend to register, and then that opportunity was taken away. The second one is we say, and this also seems to be conceded by the Commission, that there are two easy legal ways around the problem. The one is to suspend the operation of Section 61A, and the other is to declare the proclamation by the minister invalid. Nobody says that those aren't available to these courts. We've specifically prayed for them in our notice of motion for exactly the relief that we seek. So the only objections that the Commission raises are logistical difficulties, and I will get to those. The third proposition is that free and fair doesn't mean perfect. I think Acting Chief Justice said it's not an absolute concept. So what we're talking about, and this court said it in Cum, is free and fair in the context, looking at all the circumstances. It's not a list of strict requirements. If you don't have X number of days between the closing of the voters' roll and the inspection of the voters' roll, then the election is not free and fair. It must be 7 days, otherwise it's the end of it. Not at all. If you look back at our history and what happened in 1994, there was no common voters' roll. People waited for days to vote. IFP stickers were added onto the bottom of the ballot a week before. People were trying to hack into the computers that were counting the votes. In some areas, more than 800% of the people who lived in the area were recorded as voting. Despite that, it was accepted as a free and fair election. Why? Because the parties accepted the results. And that's why, to come back to a point made by my learned friend, the statutory scheme requires objections by candidates of registered parties to the results. Even if there may have been irregularities, if all the people who participated in the election accept it's free and fair, then it is free and fair. And that's why you wait for the objections. Does anybody object? Or do we think, well, it didn't go perfectly, but we're all happy with the result? And what the Commission is asking this court to do here is to short circuit that whole process. So the final point I want to make is that election timetables are malleable. The statute specifically allows the Commission to change the timetable in order to ensure that an election is free and fair. And the whole point of that is because it may be necessary. Things change. But where there's a will, there's a way. And that leads me to my second point. I want to refer this court to 4 of its previous precedents, which show exactly how when you've got a commission that wants to hold an election, it can hold an election. We are now 9.5 weeks away from an election. There are cases where this court has intervened less than a week before an election to get parties on the ballot, to get voters registered, to allow special votes to happen. So the first 2 cases are August and Nicro. I'm sure the court is aware of them, where the court allowed prisoners to register to vote. And in August, it was less than 9 weeks before the election when the decision was handed down. And this is what Justice Sachs says. He says the Commission will, paragraph 40 of August. The Commission will, in order to comply with the terms of this order, need to make arrangements for a special period of registration of prisoners. I have no doubt that practical solutions will be found for what are practical problems. That's the same thing we're confronting here. Exactly the same thing happened in Nicro, 6 weeks before an election. All prisoners had to be registered, and the Commission made it happen. In Richter, even more difficult. 6 weeks before the election, this court decided that all people who were all registered voters living outside the country were entitled to a special vote. Told the Commission you must give them 15 days, they must apply for a special vote, and they must be allowed to vote overseas 6 weeks before an election. In African Christian Democratic Party, less than a week before the election, this court held that the exclusion of the party from the Cape Metro Council was unlawful because of the question of whether they paid the fee. And they asked the commission, please tell us, is it possible for you to hold this election if we find that they were incorrectly excluded? And this is what the commission said, I think it's at paragraph 11. Although it would create significant difficulties for the commission and would place the elections at risk, such an order would not render the holding of the elections impossible. And the court said, go and do it, make it happen. And the commission made it happen. So I draw 3 lessons from these cases. In none of the cases was postponement ever even raised as an option. Second, in all the cases, the commission expressed its willingness to do its job and did its job. It held the election. And third, even though there are imperfections, none of this is perfect. None of this is the way you would design an election. To say, well, we'll only allow foreign voters to register 6 weeks before, or we'll only register prisoners 8 weeks before. You would never design it like that. But it still is free and fair.
Okay. Your 5 minutes is up.
You want Justice Zondo, I'm happy to
2 minutes more.
Yes,
okay.
I just want to deal with the specific sort of logistical difficulties that the commission has raised. The first one they deal with is the difficulty of inspection. And I can deal with this. The problem is whether there'll be enough time after the voters roll, after new registration weekend. The voter roll then has to be open for inspection and objection by political parties and then certified, and whether there will be enough time. We set out in detail in our affidavit at paragraphs 129 to 131 why even using the periods that the commission requires in its current timetable, there is enough time. There's enough time even if...
Sorry, Mr. Bishop, can I just ask, I read that, but that timetable doesn't set out the further processes of printing the segments and getting all of that material to 24,000 voting stations.
That's true, Justice Rogers, but the commission doesn't explain why it can't do that in the time available. It says, well, we will have to print it and we will have to distribute it. It doesn't tell this court how long it will take to print it. Its current timeline is 3 days for printing. And so even if you hold the registration weekend on the 18th and 19th of September, which is their plan that they say they're going to do anyway for the February election, they still have 10 days to print and to distribute. And they don't explain to this court why they can't do that. They say they can't, but they don't explain why. They don't give any details at all. The second difficulty is the candidate lists. And so the current deadline to get your candidate on the list is the 23rd of August, and all the parties have complained about that. And that there's 2 problems. The one problem is that to be on the candidate list, you have to be a registered voter in the area where you want to stand as a candidate. And people didn't register because they were waiting for the weekend, and so now they can't be candidates. And the other one is the problem of time. Again, we say that there's more enough time. The commission sets out a variety of things that have to happen in paragraph 111 of its head, but none of those have statutory timelines. All of them, if you look at the sections that they refer to in the footnotes in paragraph 111, they all say at a time determined by the election timetable. So fix the timetable, make it happen. These processes can even happen in parallel. For example, you could say we were going to have a registration weekend on the 18th and 19th, but if you want to be a candidate, you must register by an earlier date. And you can register online, you can register at a municipal office. And so these are the kind of practical things where if you want to make it happen, you will make a plan. The last submission, Chief Justice Zondo, which is an important one, which my learned friends raised, is whether it will be safe to have the registration weekend and whether it'll be possible given we are at alert level 3. The first answer to that is the commission intends to hold the registration weekend. It tells this court it must deliver judgment, or it asks the court, says, please deliver judgment by a certain date so that it can hold its registration weekend on the 18th and 19th of September. Now, it must be safe and it must be lawful for it to do it then. Otherwise, it wouldn't have told this court that's what it intends to do. And we say, even if you hold it on that weekend, the election can happen. But they never explain why, if you hold it a week or 2 weeks earlier, suddenly it would be unsafe, or suddenly it would now be lawful when on the 18th and 19th it would be unlawful. And if there is something in the alert level 3 regulations that prohibits the registration weekend, we don't think there is, because a queue is not a gathering, and you can limit the number of people inside a building. then ask the minister to amend it, to allow for the registration weekend. Solve the problem. Don't come and tell this court it's impossible. All you need to do is make a plan. The final objection was about budget, but that seemed to be abandoned by my learned friend, so I don't need to deal with it.
Yeah.
Those are my submissions. Thank you for indulging me, Acting Chief Justice.
Thank you, Mr. Bishop. Thank you. I will now allow counsel for CASAC, that is Ms. Leroux.
Thank you, ACJ, and may it please the court.
Thank you.
Justices, I intend to very quickly try to address you on 4 topics. The first is, what is at stake here in this case, and why does regularity matter? The second is, what are the mechanics of what you're being asked to do, and what are the consequences that we as an amicus would caution you to be aware of? The third is, let's take a closer look at impossibility and what it would require if you were to read it into the Constitution. And number 4 is to highlight some of the risks we observe in the remedy and in the discussion on remedy as it's developed during the course of the day. So we know that the IEC under Chapter 9, under Section 190, is required to manage elections and ensure that they're free and fair. And it's to ensure a peaceful transition of power in a constitutional democracy. And we submit that what you're being asked to do weakens both aspects, the Constitution and the democracy, because you're asking councillors to stay in office beyond the constitutional term, and you're asking voters to wait until what could be even longer than February on some of the arguments made today, and particularly in light of the supervisory jurisdiction that you've been asked to exercise. You're asking voters to wait far beyond the 1st of November to replace councillors that aren't doing service delivery, that are corrupt. And you're also denying voters the right to endorse councillors that are doing their job and ensuring that service delivery happens in their local municipality. So when the Constitution talks about regular elections for accountability, responsiveness, and openness, we mustn't forget the rights of the voters here, because we've heard a lot about the internal convenience and processes of political parties. And we've heard a lot about the challenges that the Commission will face to do its job. But what about the rights of the electorate, which is what this is actually all about and what it should actually be all about? Because we've honestly heard very little about how the Commission plans to keep those voters safe when they come, whether it's to register, to campaign, to be canvassed, or to vote. We hear very little about their plans to accommodate the pandemic. We hear about hopes for greater vaccination, and we hear about, trying to do the best we can to speculate about where we end up. But the court is not here to be a deadlock breaking mechanism because Parliament won't reach 75%. It's not here to give permission slips to skip deadlines. It's not here to pick up the pen and, we do submit, rewrite the Constitution in effect. That's Parliament's job, and the elections are the Commission's job. And the court, however tempting it is to try to save the Commission from this predicament, it is not the court's job to assist and try to do it all. The Commission must play its part. Parliament should have been asked to play its part. And we could say, oh, but what's a few months between constitutional friends? But the point is, the court is being asked to gerrymander constitutional obligations. And we submit, for a questionable set of facts, you should not just submit to an incantation that you have 3 impossible and irreconcilable requirements for an election. You would need to scrutinize each one of those to see if they really satisfy the requirements of the impossibility doctrine, assuming you can even resort to it. And I'll address you on that in due course. All of this speculation and incantation of impossibility is all the worse if we look at a couple of the facts. Voter turnout in the 2016 local government elections in pre-pandemic times was just over 15 million voters. Every month, Sassa manages to pay out grants to 18 million South Africans. Every month, pensioners, the disabled, and other vulnerable members of our society gather in queues, wear their masks, socially distance, and access their social security, social grant payments. What's the difference between a Sassa queue and a registration queue, a campaign queue, or ultimately a voter queue? We don't see in the data that every month there's a surge in cases because of Sassa payouts. We don't even see that there was a surge in cases when the Commission successfully ran pandemic by-elections last year. So the Commission hasn't shown us why it can't do its job in these pandemic circumstances. And all of this debate about impossibility calls to mind the well-known statement by our first democratically elected president, Nelson Mandela, who said, "It's always impossible until it's done." And we would submit that it's that spirit that should be informing the Commission and the debate before the court. If I move on to the second topic, which is the mechanics and the consequences of the mechanics of what you're being asked to do, I would highlight three aspects to that CASAC is concerned about at the level of constitutional principle. Let's not worry about the label of amendment, suspension, or exactly what the relief in the notice of motion is trying to achieve. Let's look at the effect here. It will be to remake Section 159. On the Commission's case, it'll be because you read in impossibility, and then you find that there was in fact impossibility here. But the court will be remaking the contents of the Constitution. And we've submitted in our heads and are joined by other parties in making this submission that this upends the usual and required hierarchy. The Constitution is supreme, and the common law gets developed in order to be congruent with it. Here we would be doing the opposite. We would be using a common law doctrine, and I insist that it's a common law doctrine because I will address you on the JSC case as well. But you will be using the common law to adjust the Constitution. The second principle that is of concern here as a consequence of what you're being asked to do is that the effect of reading in that common law doctrine, we submit, is to weaken the Constitution. So rather than in line with, for example, the jurisprudence in Mighty Solution, where you determine what the position is, think about, consider the reasons for that position, work out how it offends the spirit, purport, object of the Bill of Rights, and why you need to develop the common law, and then look at how it would need to be developed and take into account the wider consequences of what you would be doing. In all of those areas here, we submit you would be weakening the Constitution, not making it more congruent with what the original drafters contemplated. And the way you get there is through impossibility. So whether we're talking about some declaration and suspension, whether we're talking about a formal amendment that should have gone to Parliament, whether we're having the debate about where your power arises from, we would urge you to consider the effect of what you're doing by using the common law in this fashion and superimposing it to weaken the Constitution. And the third point on this is just the precedent point. You've heard from more than one of my learned friends that this would be a disastrous precedent because today it's the Commission with a difficult election, but tomorrow it will be another organ of state or body coming to escape its constitutional obligations, and we endorse all of those submissions. But it would also be an unprecedented step that the court takes. And that's because, as Justices Majid and Matlanga have already put to my learned friend for the Commission, the SCA in the JSC Cape Bar Council case did not rely on impossibility when it was considering the constitutional obligation with respect to the composition of the JSE, it is arbiter. And all of the international examples, no one has been able to bring you a precedent from elsewhere where it's a court that will postpone the election because of COVID rather than a legislature or the executive. So we often lead the world in constitutional jurisprudence, but we would urge you not to be the one outlier who heads down this road. If I can then move on to my third topic.
Yeah, your 10 minutes is up, but of course you still have another 10 minutes. That is the 10 minutes without interruption that is up. You may proceed, but before you proceed, if I'm correct in understanding you to be saying that the IEC should have gone to Parliament for an amendment, what would that amendment say that they would be asking Parliament to make?
ACJ, they would have to craft something that would achieve the 75% supermajority that we submitted it deserves. And it would have to, we submit, be something along the lines that, 159 is subject to either an exception for this particular election, that's one way they could do it, to say 2021, or it would have to, if they wanted to change it to accommodate this doctrine of impossibility that's relied on, they would have to frame it in that way, and they would have to identify the elements and the factors for consideration, which is what I'll address the court on when I get to the requirements for impossibility. So it depends on what they were doing. If they wanted to just try to escape it for this election, it would have to be an amendment for this election. If they wanted to, if they could persuade 75% of our MPs that we should add impossibility into 159, they would have to specify how impossibility should be grafted on. And they would have to, persuade several of the parties to join together and endorse that. And we know from their papers that they say, oh, we know we wouldn't get that support. So here we are. And it goes back to my opening remarks about this court is being placed in a most unenviable position by the Commission, because it didn't table the report of Justice Moseneke to Parliament and say, please help us. How can we do this? How can we adjust this? They've come to this court and asked it to pick up the pen and rewrite the Constitution.
Does this court have competence to interdict an election that will be unconstitutional?
ACJ, it would, because it would be able to, it would be satisfied on the requirements of an interdict. And that's why my third topic on what are these requirements for impossibility? If you were going to entertain this and write a judgment that said, because of impossibility, Section 159 is suspended, amended, adjusted in order to accommodate impossible conditions, then we would need to set out what are those requirements for impossibility. So when if a litigant could persuade you on an interdict basis that there's the clear right, the obvious the apprehension of harm, and you would have absolutely clear evidence that in 5 days' time this election cannot happen, or if we went back into a hard lockdown where no one could leave their home to register, campaign, or vote, that would be a hard impossibility finding that may sustain the type of relief that the Commission is asking you for. But if you're going to entertain this doctrine of impossibility, we submit you need to think very carefully and list in any judgment what its requirements are. And that's the third topic that I'll get onto right now.
Yeah, you see, you will have noticed my question that I raised with Mr. Trengov in the morning about the issue of impossibility. I'm reluctant to use that terminology as such. I'm focusing on simply saying, if the court is satisfied that an election that is going to take place tomorrow or in 3 days' time or in 5 days' time will lack one or more essential features of an election that is free and fair, and therefore will not meet the requirements of the Constitution. You have already said, I think the court would have power in an appropriate case to grant an interdict to say such an election should not go ahead. So my question is, if it's 2 days or so before the expiry of 90 days, would the court not have the power to say to the IEC, don't run this election 2 days before the expiry of 90 days because it's clearly going to be unconstitutional, but you will have to run it in a month's time after you have made sure that these absent essential features will be there. We know they are absent for this one, but you need to get time so that you can make sure that they are present. You say it doesn't have power to do, it would not have power to do that, to make sure that the people who have been promised the right to vote, who have and who are expected to vote 2 days before the expiry of the 90 days period, are not permanently denied the right to vote during that time, but they can get a chance to vote in a free and fair election, even if it's after the expiry of 90 days. I was saying it can't do that.
ACJ, the power that the court would be looking to exercise would have to be, as the Commission asks it to, found in Section 172. Mm-hmm. And you would have to be finding essentially a deviation from the constitutional requirements, mm-hmm. that you then decide to suspend, order, various things happen in order to close that gap, mm-hmm. and ensure compliance. Mm-hmm. The difficulty here is twofold. And I would say primarily it's the Commission hasn't made out a case to you for, mm-hmm. For that deviation, that we submit they can still perform their job in time for October. But
okay, I'm sorry. I think we are making progress. I'm quite, for present purposes, I just wanted to know whether in principle and as a matter of law, you are saying there is no such power, or you accept that as a matter of law, there is such power, but you are saying this particular case doesn't provide justification for exercising such power. That's what I wanted to establish.
ACJ, I'm adopting a third position,
yeah,
which is to say, if you have the power, yeah. It's in Section 172.
Okay.
And in Section 172, you would have to wrestle with the absolute nature of 159, mm-hmm. and then using the mechanism that the Commission urges you to adopt of impossibility, you would have to satisfy yourself that the requirements for impossibility have been met. Mm-hmm. And we yes. would say to you, that is a very dangerous thing to do for 3 reasons. 1, because you're using a common law doctrine to renovate the Constitution, and the hierarchy goes the other way. Number 2, you're weakening the Constitution. And number 3, it sets a dangerous precedent. So when you are considering, number 4, there's no other precedent that they've provided to you to say this is a way to go. So we would say that you would then go back to the beginning and say to yourself, if it has that consequence and it has those risks and those dangers, it can't be the power in 172.
Okay.
So that would be the exercise we would submit the court would need to go through. I have to find it in 172. The Commission tells me that I must get there through importing a common law doctrine into 159. There are the 4 dangers to doing that. That doesn't advance the Constitution, it weakens it. Therefore, that can't be how I develop our constitutional law. upending hierarchies, weakening bad precedents, and unprecedented. So that can't be what 172 demands of me. What in fact vindicates the Constitution is a judgment that says to the Commission, we've gone through this exercise, we've seen the legal points and the constitutional principles for why we don't want to adopt this approach, and in any event, you haven't made out impossibility on the facts here, which again, I'm conscious of time, and now I'm
okay, all right.
But I did want to address impossibility and some of the other risks.
I'll give you another 5 minutes. We finished 20 minutes, but we asked you questions. I'll give you 5 minutes, and maybe colleagues might have some questions. But before we take the tea break, let me give you another 5 minutes.
Thank you, ACJ. So on impossibility, if we are going to drag this from the common law into 159, there are 4 things that we know about impossibility. Number 1, you demonstrate objective impossibility. You don't just claim it and hope that repetition will somehow provide evidence. You provide evidence. Number 2 is that we know from all of the case law, in whichever context, impossibility means impossibility. It doesn't mean difficult, costly, onerous, time-consuming, challenging. It means impossible. It means the house I rented to you has burnt down. You want to jail me for contempt of court because I didn't come to court on a summons in Johannesburg when I'm in detention in Cape Town. It means that, it really is impossible, not difficult, inconvenient, costly, and burdensome, which at most is what the commission we submit has given you here. We know the third point, the elements that, for example, the SCA in Snow Crystal put before us. And we've addressed these in our heads and applied them to the case here. But remember, it's nature of the contact, relation of the parties, circumstances of the case, nature of the impossibility invoked in the particular circumstances of the case, not if self-created and not if it's due to any of your own fault. And we applied in our heads the facts that the commission relies on here to all of that. And that this narrow, limited, demanding standard of impossibility, we submit this case shows you why it would be inappropriate to gut 159 on the back of what the commission shows you. So it's difficult to keep voters safe in a pandemic. First of all, we know the commission can do it because it did it in the by-elections. But we know, and we haven't heard anything about why masks, social distancing, ventilation, possibly extended voting hours cannot be a solution. Have it over 3 days and people go on a particular day depending on the first letter of their surname. The commission in its papers said, oh, but that all has cost implications and we can't even afford PPE. But Mr. Trengrove this morning conceded that budget can't be impossibility. So they haven't otherwise shown you in all of those requirements of this onerous doctrine why the election is extinguished, right? That's what they have to show. The thing is not possible to deliver. And I've made the submissions about why we say that can't happen. So let's take registration weekend because it enjoys quite a lot of attention. We know 40 million eligible voters, 25 million unregistered, 15 million are registered. We know, and it's founding affidavit, page 50, paragraph 98.5.6. In a good weekend of registration, they managed to add 600,000 new voters. Now, I'm not by any means saying it's not important to register everybody who's eligible, but we wouldn't say that 600,000 unregistered voters from not having a registration weekend negates, extinguishes, destroys the election. So we would say these are the kind of things that can be tolerated. And then finally, in 1 minute, the risks in the remedy here are not only the weakening of the Constitution, upending a hierarchy, weakening the Constitution and bad precedent on speculative evidence. You're actually being asked with your supervisory jurisdiction, which exists whether you do primary relief or alternative relief. You're actually being asked to do the commission's job. Because this morning, you were told that you will get reports, and at some point you may say enough is enough, run this election. And at some point you will say apparently to the commission, do your job and run the election. But you will then be doing the Section 190 job. You will be managing the elections. You will be deciding when they are free and fair. You will decide.
And when somebody wants to challenge it afterwards, what happens?
Then they challenge it afterwards. And if a particular ward fell short, it gets rerun. That is what would vindicate the Constitution here. That is what would ensure that this court doesn't, however tempting it is to solve this problem, doesn't start doing the job of the commission or of Parliament.
I thought I was mentioning something that you might find to be supportive of your argument. If in effect we will be advising the commission on its preparations for the elections, and then it holds the elections in accordance with our advice. What happens if an aggrieved party afterwards wants to say this election was not free and fair, and then the commission says, but we listened to the advice of the court?
ACJ, with respect, I'm indebted to you for adding to the problematic consequences of adopting what you're being invited to adopt. And so I would urge the court instead to uphold the Constitution and demand that difficult, costly, onerous, challenging, problematic, but constitutionally required things be done by those parties that must do them, and that we have an election in October. Thank you, ACJ.
Thank you. I think there are no questions from my colleagues. Otherwise, I would have, somebody would have said something. Okay, I think let's take the tea break. We were going to take it at 4 o'clock. It's 10 past now. Let's take it. It will be a 15 minutes tea break. We will resume at 25 past 4. The court adjourns.
Court will adjourn until 4:15. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin video and sound when the hearing recommences at 25 past 4. You may use the same link to rejoin the hearing if you exit.
Jeremy. Yeah, we can talk. Yeah, hi, Jeremy. I'd understood that I was to be
Sorry.
4 and 5.
Judges are in, Anton.
I understand. That's right.
Are all the justices in? There is no. Yeah, okay.
CCT, I'm not sure if Justice Theron is connected as yet.
I'm sorry, I was on mute. All the judges are online, Acting Chief Justice.
Okay, all right. No, thank you. Okay, let us resume. I will now give Mr. Katz an opportunity. He appears for both ATM and OSAM, and he will have 30 minutes. But of course, as I've indicated,
what do you make of the fact that they basically told me to shut this down? Sorry. I mean,
hello? Mr. Katz, I'm giving you now a chance. Of course, a lot of points have been debated between us and counsel who have come before you, and some of the points might not need to be repeated, but this is your opportunity. Thank you. Are you going to make use of 10 minutes without interruption, or are you ready to be interrupted?
May I make use of 5 minutes, Acting Chief Justice?
5 minutes, okay, okay, all right. Okay, go ahead.
And I will try not to repeat arguments, although there will be some overlap, because the points that I will repeat will feed into my broad argument as a whole. Let me say both my clients submit that the relief sought by the IEC should be dismissed. And we do ask for costs, as an intervening party would. We'd be entitled to, along the lines of the Mashlope case. Now, let me indicate to the court that I intend to address the court in 3 big chapters. And each chapter will have subheadings. The first chapter I'll deal with a range of high-level propositions which the court we submit should engage with before even considering whether to give the IEC any relief, even were this court to take the view that it has the power to do so. The second chapter, I'll turn to our heads of argument and explain what we would submit would be a difference in approach to us compared to the IEC, and it's an issue of distinction that we make different to those of the other parties opposing. And that relates to, for example, the question of a state of emergency and where that might fit in the big picture of the particular case. And then the third chapter will be a very short chapter indicating why, on the facts of this case, the high-level propositions that I make in my first big chapter call for the IEC case to be dismissed. So the third chapter will be a loop back to the first chapter. As part of the first chapter, I make the following high-level propositions, and there are 4 of them. The first is the context of this case. And the context of this case has a number of features which indicate not necessarily a red light, because I know the absolutist position is a red light, but certainly a very sharp amber light flashing before this court's eyes. It's certainly not a green light, but a sharp flashing one. Let me explain what those features are. There are 6 of them. The first is this is an application for direct access. Unusual and rare. 2, it's urgent. 3, importantly, it's based on contested evidence, where this court is sitting as a court of first and last instance on the basis of contested evidence, not only by those parties who oppose, but even by the applicant itself, which presents a report of Moseneke, former Justice Moseneke, where there was evidence before him, where I should just read from paragraph 52 of our founding papers, where he said, that was the evidence of Professor Karim. If you look at these scenarios, October is probably a safer bet than going with December or March. That was evidence before Moseneke. The 4th proposition in this first item of the big chapter is that this case is being...
Mr. Katz, I'm sure you mean to say Justice Moseneke, not Moseneke.
Well, Justice Majid, it's an important question that you raised. Because...
No, I'm asking something else. I'm saying you keep on referring to Moseneke. Surely you mean Justice Moseneke.
I'm answering the question. No, Justice Majid, I mean Moseneke inquiry. Perhaps I should have said, because when he gave the report to this court, he didn't give it in his capacity as a justice of this court. Perhaps I should say retired Justice Moseneke. I'll respect the office, and I have a very deep and very important understanding that Justice Moseneke is a very important person in my life on a range of levels, Justice Moseneke. But as far as his report is concerned, the fact that he was a justice should play no role in this court's consideration of the issue. The 4th proposition on this first chapter is that this court is determining the matter without Parliament being a party or Parliament playing any role in this case or in the lead up to the relief sought at all. The 5th proposition on this first chapter is that what is being sought are serious constitutional issues. They are radical. And when I say they are radical, They're radical in this sense, and I want to emphasize this proposition. When a court strikes down legislation, that is radical. But it's now become commonplace. But what happens in what's being asked for here is not for that, what I'm going to call relief sought on a temporal basis, but this is final in effect. So in other words, when a court strikes down legislation and gives a just and equitable remedy pursuant to the declaration, Parliament is always free to reenact the legislation in a way that satisfies what this court indicates was the problem with the legislation. And it's not final in effect, any reading in. That point was made first by this court in National Coalition for Gay and Lesbian Equality versus the Minister of Home Affairs. Here, the Constitution demands that an election be held by the 1st of November. Were this court to grant that relief, that would be final forever. No party, the Parliament, the IEC, no person could ever undo that radical intervention. The sixth proposition that I make is that the pandemic, which has been around since March 2020, has been dealt with by way of a state of national disaster under legislation, the Disaster Management Act. And it has continued for the last 18 months. I think the first declaration was for 3 months, and then it had been extended for month by month thereafter, without Parliament playing any role whatsoever in the violation and infringement of the rights contained in the Bill of Rights, including perhaps rights which are non-derogable in the state of emergency. So that's the first proposition. The context of this case is to be considered with those 6 propositions in mind. And I turn to the second leg of my first chapter. And the first leg is this, that there was a debate.
I just mentioned, Mr. Katz, that the 5 minutes you said you wanted to have is up, but you can continue.
Thank you, Chief. Thank you, Acting Chief. The first proposition in my second chapter, in my first chapter, but the second point in my first chapter is this, that there was a debate about in comparing, Mr. Trengrove started this morning by saying there were these 3 constitutional requirements for an election. 1, regular, free and fair, and safety is the 3rd. And he was wondering why the regularity seemed to trump the other 2 when it came to those opposing. And my answer is very simple, and there's a good answer for it. 159 is absolute in its terms. There must be an election by the 1st of November, whereas the freeness, fairness, and safety are all on a spectrum. And there's no gold standard. There's no absolute guillotine, which says that this election is free and fair, that is not. And this is practiced all over the world. Freeness and fairness is context dependent. And in a pandemic, it may be very different to in a non-pandemic situation. That's the second that's the first proposition. The second proposition is throughout the day, I've heard of this notion of the election on the 27th of October. But the reality is that there will be many elections. So when it comes to provincial and national elections, there is 1 national election and 9 provincial elections. There are 10 separate elections. And it may well be that in province X, there was a lack of freeness and fairness, whereas in the other 8 provinces, it was fair. That doesn't mean to say the entire national and 9 elections then fall. It would be fact dependent upon the particular situation in that particular province. And similarly, when it comes to local government elections, there isn't 1 local government election. There are many for every single ward in this country. So we would submit that that is a factor to be taken into account in determining this question of the impossibility of holding a free and fair and safe election throughout the country. There may be certain parts of the country, there may be, which a challenge thereafter may succeed in respect of it not being free and fair. But to say today that every single election in this country in respect of every single municipality will not be free and fair and safe for the reasons that have been advanced by the IEC, we would say ought not to find favor with this court. The next proposition that we make is this. I've mentioned the role of Parliament, and the court knows, and it's a heavy burden on the court to read legislation down. In other words, wherever a court has the obligation to consider a challenge to legislation, a court will read the legislation, if reasonably possible, and I'll talk about Hyundai, in a manner that saves the legislation. Why shouldn't that same proposition, let's call it a reading down proposition, apply to that which the IEC asks for? Read, if you can, reasonably, the possibility of an election going forward being free, fair, and safe, and avoiding the violation of the guillotine. So that if this court has to think, well, the IEC have put up strong evidence as to why it's not free, and I turn to the acting Chief Justice's examples 2 days before an election, a party comes. What a court will do in those circumstances is do whatever it can to save the election, save the legislation in the challenge to the legislation case, rather than, let's call it striking down the legislation or coming to, in this case, the analogy is coming to a conclusion that the election on the evidence would not be free and fair and safe. So it's a reading down by analogy argument. And we would submit that if one takes that analogy, it's very hard to come to the conclusion that the only reasonable possibility on the facts, contested as they are, I've read Professor Karim's argument, evidence, medical evidence, that October is probably a safer bet than going with December or March. We submit that the constitutional courts, the jurisprudence of this court is save rather than strike down. So that's how we would articulate the case. And I want to turn to where we add what we would call certain distinctions to the others. And all the arguments that I've already made, all they do is they support that which our learned friends opposing have already argued, in the sense that I've added certain nuances to it. In paragraph 4 of our heads of argument, we say at the heart of this application lies the important question for the democratic project. And the two questions arise. In what circumstances, if any, may a local government election be postponed? That's the first question. In what circumstances, and when I use the word postponed, it's not just a postponement, it's a postponement beyond the 5 years plus 90 days. In other words, in what circumstances may a local government election be held outside the 5 years plus 90 days? And the second question, which is also fundamental to the case, is who has the power to decide that? That first question. What are the circumstances? Do the circumstances, as articulated by whoever has the power to decide, arise in the particular case? And which is the particular body? Is it the IEC? Is it the minister? Is it Parliament? Or is it the court? And we answer, that's in paragraph 4 of our heads of argument. And we argue that the Constitution in paragraph 6 is not silent on this issue. And we submit that the Constitution itself provides the answer, even in so-called impossible circumstances.
Thanks.
So I turn to that. In paragraph,
I'm sorry, Mr. Katz, there was some voice that came through, but I think it's gone away. Continue.
Thank you, Acting Chief Justice. So the first is, so turning to paragraph 9 on our heads of argument, which is in chapter 2 of the heads, it says, when may an election be postponed? Reading 159 through its history. The history of 159 has not been dealt with by any of the parties. The scheme of the Constitution and the structure of government. As far as the history is concerned, I'll make the simple proposition that prior to 1998, there was no window of 90 days And the 90 days we submit is provided for in order for the types of exceptions to the 5-year rule to be played out. So it's not as if a municipal council has 5 years plus 90 days. It doesn't. It has 5 years. But in exceptional circumstances, the drafters of the constitutional amendment in 1998 decided that there would be certain circumstances where the 5-year period may not be sufficient in exceptional circumstances for an election to occur before the term of municipal councils has ended. So it amended the provisions of 159 by Act 65 of 1998 to say that the election must be held within 90 days of the date that council was dissolved. It's an amendment, and we submit that history should point to the kinds of amber lights that flash when this court considers the request that we now 5 years plus 90 days, as if this not, so it really is a 5 years plus 90 days council. It's not, it's a 5-year council. The second proposition so that's the first answer on that aspect. The second answer is this question, which I know will have us all, including myself, I'm old enough to remember, 1986 state of emergency. And we all sort of put up if I had hair, my hair would stand on my back when I hear state of emergency. And the point is this: a state of emergency allows for Parliament, without a supermajority, to make laws, and I understand that there can be some debate, and I'll explain to the debate, make laws which derogate, and the legislation doesn't have to pass through Section 36. It can make laws which deal with the state of emergency in a manner that protects the life of the nation, etc. The declaration would be necessary. And there are various important safeguards when it comes to the state of emergency. And any legislation giving effect to that state of emergency, importantly, would need to be strictly necessary to the state of emergency, number one. And number two, it could be challenged in Parliament in the normal course. Section 37 provides all the kinds of protections that would and could exist, including Parliament's role, even in a state of emergency. Here, none of that exists. None of those protections exist in this lower level of an exception to the constitutional project. A state of emergency is one of those exceptions to the regular kind of situation that we find ourselves in. State of disaster is also an exception to the regular rule. In a state of disaster, we've had to stay at home. We haven't been allowed out. Tonight, there's a curfew at 10 o'clock tonight. That's the exception, not the rule. There is no parliamentary oversight to that curfew rule. And what we submit is this, that to the extent that there is to be an avoidance of the guillotine of the 90 days, the 1st of November, where is Parliament in all of this? When we know even in the most radical scenario, which is a state of emergency, where even our rights under Section 19 can be derogated from without the need for Section 36 justification. Parliament has to oversee that. Courts will check on that. But here, we don't have any of that. So as far as my second chapter is concerned, we submit all these features suggest that the direct access urgent contested evidence application, raising for the first time a what I would call temporal radical solution to a constitutional problem. When I say non-temporal, striking down the legislation is temporal, because Parliament can always fix. Here, after the 1st of November, it's too late. We suggest that the court must have its amber light role very heavily flashing all the time. And I turn to the facts. I just need to read that Professor Karim again. October is a safer bet than other. And I look at my client's founding papers. When I listen to the parties supporting, I wonder the relevance of whether a particular party has had its branches ready or its candidate list ready. And I look at my client, my first client, the fifth intervening applicant. In paragraph 15, the ATM says it has candidates in every ward in the country ready to lead. The relief sought by the Commission has a direct and substantial effect on each of our ATM's candidates who put themselves forward for election. My client's rights, my client's preparedness, readiness for the election would be seriously compromised on the evidence, uncontested. So it goes, and I don't want to make too much of it, but the proposition is that that's what's sought. Sorry, that's what the gravamen of the evidence by a postponement in the particular circumstances. So we would submit as a factual matter all of the kinds of things that the court has heard from Mr. Jamie, Mr. Duplessis, Mr. Bishop, and Ms. LaRue all suggest that the amber lights that are flashed flip over to be a red light for the kinds of relief that are sought in this case. And we ask that the application be dismissed.
Mr. Katz, just there could be municipalities which have collapsed. And the only hope of the residents there is that October the 27th might come as a relief. And some of these might be under administration. Doesn't that add to the list of the evidential problems that might be encountered?
As we understand the constitutional protection for those residents in respect of whom municipalities have collapsed is section 139 of the Constitution, where administration is either imposed, and in particular, that's 139.1 A and B, I think, and 139.1C, which is a particularly radical intervention where the province, the MEC, dissolves the municipality and a by-election would take place within a certain period if the minister and the NCOP approve the dissolution of the municipality. Again, I highlight, and sorry, Justice Saletsi, even in those 139.1 A and B provisions, there is the requirement that the minister and the NCOP approve in the various periods, and I know there's some debate amongst the cases about how that would work. The minister, I think, is 30 days, the NCOP is 180 days. It's not quick. I think there's one case which says that they both have to not approve before the intervention falls away, and the other cases say it's not. The proposition that I'm making, Justice Tlaletsi, is this. Even in those, again, unfortunate municipalities, there are protections which are set out in the Constitution, and there's no need for purposes of the debate for the election to be held after the 1st of November in order to, for example, add extra protection to those unfortunate municipalities. In fact, we would submit that that's a good reason for the election to go ahead before the 1st of November because of what is seen. And there's no evidence, if I understand it correctly, there's limited evidence. I know that my client says in paragraph 13, my client's ATM success cannot be separated from the fact that South Africans are desperate for change, particularly at local government level where corruption is rampant and service delivery poor. And there is evidence of that kind through the papers. But to answer your lordship, to answer Justice Tlaletsi, we would submit that to the extent that there are these collapsed municipalities, that's another good reason for the election to go ahead before the 1st of November.
Thank you.
I think there are no further questions from my colleagues. I think you had said you were done, Mr. Katz.
I have nothing to add.
Yes, okay. Thank you very much, Mr. Katz. I will now give the opportunity to Mr. Gauntlet, who appears for freedom under law. Mr. Gauntlet, are you there?
I think he's muted.
I'm sorry, Acting Chief Justice. I not unmuted myself. Acting Chief Justice, there is the very good adage in Afrikaans about agter kom ook in die kraal. I'm almost there. I shall seek to make just these points.
Yes, and do you wish to have the 10 minutes of no interruption, or you are
yes,
happy
I
to
invoke that fundamental human right. It'll make me quick.
Okay, all right.
Thank you, Mr.
Go ahead. Okay.
There are these striking things about the application overall. This is evidently the first time that the court, or any court, but obviously this court, is faced with not just an organ of state, but a Chapter 9 institution coming to it to contend that it's impossible for it to comply with its constitutional obligation. Secondly, to ask as a consequence that it be relieved of, at least in part, discharged of its constitutional obligation. And thirdly, as a last astonishing aspect, effectively to pass control of the election, which is vested in it as a specialist Chapter 9 institution, to the court. One just has to think by brief analogy what the effect would be if the court were faced in analogous circumstances by applications by other Chapter 9 institutions. It's in itself deeply troubling. We submit that there are three answers to the application. Necessarily what I say overlaps, but I shall try to put it as incisively as I can. The first is the factual. There is a factual premise for the application. The factual premise is that it is impossible for a free, fair, and safe election to be held as scheduled. The second is the legal premise. And I want to stress here something that Mr. du Plessis had said earlier, and correctly, that of course, if the factual liftoff doesn't exist, then we are arguing and discussing very, very difficult and interesting constitutional problems up in the air. But the second premise is the legal one, and that is that this court has the power to dispense with the time limit in Section 159. And the third, of course, is the issue of remedy. May I start with the last and be very short about it? And it is this. As you know from our affidavit and our heads of argument, the position for freedom under law is that it contends that the application, it submits that the application should be dismissed, that it does entail a serious departure from constitutional principle, and it should be dismissed for that reason. However, we agree, I believe, and see the force of what has been said by others, that as regards the contended problem of registration, there is no actual issue that the court could, under equitable relief, deal with Section 61A, not in the way which seemed to have been hinted at by the Helen Suzman Foundation and the papers it filed. I know it hasn't been admitted as an amicus, but it's in that sense, the point is before it, that it contended for the unconstitutionality of Section 61A. The short point is that by way of fire engine relief, the court, we submit equitably and justly, would in the circumstances of this matter be able to push out that guillotine of 2 August, as I recall, for voter registration. And for the rest, as has been indicated by my predecessors in argument, the power effectively lies in the hands of the Electoral Commission to manage and manage properly. And Mr. Bishop was in this regard, with respect, particularly compelling. So I turn then, having approached it backwards from the issue of relief, to go back to the issue of the factual. May we submit that the threads are drawn together by something that the acting Chief Justice said. It's the old issue really of, in law, context is everything. And the context here is this international pandemic. The point about it is as to what is possible, impossible in the sense of complying with Section 159 has to be adjudged in that context. As would happen if there were a hurricane or floods or anything else, a court afterwards or a court now, and I'll deal with the acting Chief Justice and Judge Madlanga's concern about facing what was called possibly hypothetically a sham election or an election which is deeply flawed visibly now. But a court would always say that we live in the real world and we have to deal with this not as if this is a Swiss canton in a time of ease and prosperity, but in a time of health and economic crisis in this country. So let's not hypothesize about the facts. The crucial aspect in that regard is how wrong with respect the IFP is when it was seeking to characterize this as some sort of transient event. It was referred to as a once-in-a-lifetime event. Well, we all know it is a grim, enduring event with no prospect of immediate relief. As Justice Rogers was noting, it is not as if a vaccination confers immunity, herd or individual. All it does is reduce risk. We're facing the most terrible plague. And the reality has to be that life goes on. And just as this court functions, as one of my colleagues says, and we function in challenging circumstances where counsel can't find the mute button and is unable to sit with juniors and be assisted, and all those sort of circumstances, we just have to get on with it. It's not desirable, but we can't make perfection the enemy of the good. We can't say because we can't have a perfect hearing or we can't have a perfect election, ergo, it is then impossible to do the kinds of things which we are all doing. And as it's been said, Professor Karim torpedoes, effectively, we submit the factual case. We ask you in conclusion on this point to note the interesting shift in oral argument on behalf of the IEC to contending for relative impossibility. Now, this is where the argument comes apart, we submit at the seams, because they're talking about impossibility in relation to Section 159. They're saying, yes, of course they can hold the election because, and we needn't go to the sometimes embarrassing ways in which the facts have come before court, but the fact that they've said that they can do it. What they're saying, though, actually, and I hope I'm not to confuse matters, is that they're not correctly saying that it's relative impossibility. They are saying that it's absolute impossibility, quoad as regards the requirements of free, fair, and safe, together with the time limit imposed by Section 159. They're saying that just can't happen. And we are saying that on the facts, that's not shown, and is not cognizably shown now. I'll come later, as I've said, to the ACJ's point and Justice Madlanga's concern about what is it when you stare down the barrel at a sham. But we say on these facts, it's not there. That brings me to the, and may I just say, the point has been made, but it bears reiteration that in Zansi, the court already, the Siskai, the Zansi case, lay down the principle of avoidance, which is not the same as the other principle laid down in the first Zuma case. It is simply that if the court does not have to grapple in circumstances we would add of an urgent application with major constitutional arguments, well, then it would reach its decision in any event by saying, these were the asserted facts before us, but it all fell apart if one looks at it. May I turn to this, my second, which is actually then my third point, since I took remedy out of sequence, and it's the question of the legal aspect of the case. Acting Chief Justice, the problem we submit with the IEC's argument is this. We think there may have been some confusion, with great respect, on the part of our learned friend, Mr. Jamie, and there was a debate between him and Justice Madlanga about what was being said to trump what. We didn't understand our learned friends for the commission to be saying that fundamental rights trumped section 159 or being contended in reverse. What we understood them to be saying, that internally in section 159, how could we say that the term provision, the 5 years, that trumped the requirements of free, fair, and safe? Let us be clear, we don't say that. We say, first of all, we rather thought that the verb trump had fallen on bad days and that nobody would be wanting to use it. But what we're saying is that inside one section 5.9, in that difficult way, which is so in so many provisions, you have to simultaneously keep in play free, fair, safe, and the consideration of the term. You can't, it's not a buffet presented where anybody's able to say, well, actually, we think that it's safe, so we can ignore all the others, or we can ignore this. All four, free and fair, really go together. Safe and the term come into play. So the question then is, and this is the interesting point of debate being raised by the acting Chief Justice particularly and Justice Madlanga, is this question of the degree of fundamentalism or absolutism you were asking of my colleagues in relation to section 159 and of ourselves. Our submission is this. It says, it is what it says on the tin. It is the prescribed time limit. And why that is so is that there should be no capacity to depart or gerrymander from it. It doesn't mean, and as I say, I keep saying I'll come to this, it doesn't mean that if it's 5 years, then like some kamikaze pilot, you would run an election and unstoppably run an election which was not going to be free and fair and safe. But it does mean this, that in the framework of the Constitution, as Mr. Katz has just pointed out, there is the fire engine in the form of the state of emergency. If there were to be those circumstances where the court said, yes, we know in words of one syllable, it says 5 years, but this just can't be. Well, in those circumstances, the way through it would be for those who are in control of the executive and have a finer finger on the pulse of the country. They would be able to say, this is the emergency such that it triggers that. Now, Acting Chief Justice and Justice Madlanga, on this point, we submit that that is the answer. We do remind you, as we referenced in the heads of argument, that on the lower level of regulations and statutes, even statutes giving effect to the Constitution, this court in the UDM case and in the Eisenberg case said in very powerful terms that it was a judgment of the full court collectively in UDM and of Chaskelson, CJ.
I'm sorry, Mr. Gauntlet. The 10 minutes is up. It's up 2 minutes ago. So just so that colleagues know, they can interrupt you now. Continue.
Thank you, Acting Chief Justice. And obviously they are by law entitled to do it retrospectively if it was 2 minutes. In the UDM case, we reference paragraph 31 where this court in very nuanced and concerned terms lays down these principles, that the importance of the legislature and democracy and the deference to which it is entitled from the other branches of government, it would not be in the interests of justice for a court to interfere with its will unless it's absolutely necessary to avoid irreparable harm, and then only in the least intrusive manner possible. May I lay out these positions arising from that before you? We submit the short answer is that when the Constitution is in very specific terms, it says what it says, and the way to deal with its absolutism, which lies in the text, is then for circumstances which would justify the very, very drastic step of effectively suspending the Constitution, which would lie through the legislature, not by ad hoc decision of the court. But if that were not to be right, and there were still to be, as both Acting Chief Justice and Justice Madlanga were probing, the kind of situation where in advance one can see like a train smash about to happen. Is there a power in the court in those circumstances to avert or to alleviate that kind of disaster? It may be that the answer lies in a similar, but raised, because we're now talking about the Constitution, maybe a foothold in the Eisenberg and UDM approach, which is to say, in extraordinary circumstances where it's absolutely necessary to avoid irreparable harm. But then that goes back to the earlier argument, which I needn't repeat. And that is, the case hasn't been pitched at that level. You've been told in an incremental way about cost and inconvenience and difficulty and the like. But what we know is life will not be measurably safer that this court can adjudge in February or March when Professor Karim and others think otherwise. So we submit that we are concerned, as the court will be, about it finding itself writing a judgment where it is drawn into speculation about future possibilities, etc. We would respectfully ask as an amicus that the way through this is to say this is brought on an urgent basis. This is said to be the crisis. The country has a crisis. These are its dimensions. This is the context. And in these circumstances, this is the case which is made out. It is not necessary for us to decide whether the only recourse out of the strictness, as it were, of 159 is the state of emergency route, or whether there is some ultimate residual capacity in the court. That case is not raised before us. I would say, in my own square answer to the Acting Chief Justice and to Justice Madlanga, we for ourselves would accept that if this court were faced with a situation where a sham, to use Justice Madlanga's words, or absolute abortive exercise were about to play out, that this court might, in those circumstances, source a power to deal with it. But as the Acting Chief Justice reminded us, Section 1721 starts that the court may, in relation to anything within its power, or the words the Acting Chief Justice,
any constitutional matter within its power,
as the court pleases. It doesn't mean that it can reach up, rather like attempts, as Justice Turon particularly remembers in Bideka, to reach into a free-floating notion of fairness, for instance, and use that in the context of constitution of contractual law. So we submit that those are the answers. May I, on one important point, and here I think I am concluding, excuse me, may I pick up on an important question by Judge Chiki, and that was this issue of the fact that the Electoral Commission had voiced through its heads of argument its concern that how going to Parliament to deal with the situation was really a worse choice, one to be avoided. Well, Acting Chief Justice, it is with respect to misplaced piety The case the Electoral Commission brought to court in its founding affidavit was rather different. What it said in its founding affidavit was this, that effectively it had done the numbers. And if it went to Parliament, this was not going to work. So instead it came to you. In the replying affidavit, after only because a whole lot of parties and amici had intervened and said, but why are you doing this? Why are you not going to Parliament? In the replying affidavit, it makes a virtue of necessity and wraps itself in the flag and says that one of the reasons why, it says in paragraphs 148 to 150, that it thought it would be inappropriate to go to Parliament. It's not what it said. It wasn't going to be its case if it had come here alone, because the rest of us simply left it to the Electoral Commission and left it to you. It took a correcting of that for the Electoral Commission to say, well, actually, they agree it's not great for Parliament to be amending the Constitution. What is far worse, Chief Justice, and this really comes from something Justice Turon raised, that for us, we submit it has echoes of the constitutional crisis in the 1950s, when there were those recurrent attempts to get round a constitutional problem by presenting it differently. In other words, there's a bicameral requirement, and then there was the attempt to set up the High Court of Parliament, and then there was the final effort, which was to pack the court. Crucial thing was substance over form. What has the Electoral Commission done here? Its founding affidavit tells you it saw that it was going to lose where it had to go. So it sought to circumnavigate that, to step around it. And that, with respect, can't be allowed. So the strategy of the Electoral Commission, no doubt well intended, but as it says, it was a deliberate, and these are its words in 148, the decision was taken after careful consideration, not by oversight. It cold-bloodedly decided not to go to Parliament because it could see what was going to happen, and instead has come to you to ask you, in effect, if not to amend, we even play with the words, but to give them a dispensation. Chief Justice, Acting Chief Justice, we ask for those reasons that the application not be acceded to, but that some relief be afforded to otherwise prejudiced voters by raising the guillotine which would have fallen on them for voter registration to enable the process to go forward. And as in the ways explained by my two predecessors, Mr. Katz and Ms. LaRue, that it will be able to face down the spectre which it has presented to you to make judicial flesh creep of millions of people voting. As they did in '94, they've done in other elections, and as was said, every month, people collect their grants in that way. Again, I end with what I started. It's not good, but it's not perfect, rather, but it's as good as it can get in the circumstances. It's certainly not impossible. And once our learned friends this morning were forced back to talking about relative impossibility, they destroyed their argument conceptually, because they have to say it's impossible to comply with 159, and they've destroyed it factually. Thank you, Justices.
Thank you, Mr. Gauntlet.
ACJ, may I raise just one aspect with Mr. Gauntlet, please?
Yes,
Mr. Gauntlet, again on the principle of avoidance of less being more, if we find that in the Constitution we do not have the power to afford the applicants either the main or alternative relief that they pray, exactly because of the issues that we've already expounded greatly upon about our limited powers and Section 159 being specially entrenched and so on, then I suppose it's kind of question. We don't get to the more difficult, or not more difficult, but to the challenging, interesting but challenging question of, can we import a doctrine, common law doctrine of impossibility into the Constitution and so on?
Absolutely. As a forensically greedy amicus, we're here to assist, but to test the law. Of course, we would like very much the ultimate Marbury v. Madison judgment from the court. but one has to be realistic. We are in these circumstances. The election, we say, needs to go ahead without delay, and we're conscious of what it would do to the court on what has been in the end rather thrown together argument necessarily. I'm referring only to my colleagues, but that we've done our best. But we submit that the very prudent approach which Justice Chaskelson was articulating in far lesser circumstances, which is effectively in UDM and Eisenberg, that, you know, the court isn't here to answer thesis or multiple choice questions. And if it doubts, and this is what we would ask for, because we would not want others to read into any judgment of the court, some kind of mandate to come back in other circumstances. But for the court, in principle, to doubt that this happens, but it could leave undecided whether there is some circumstance where it must move swiftly to meet utter calamity and sham.
Thank you. Thank you, SJ.
Thank you, Justice Majid. Thank you, Mr. Gauntlet.
Thank you.
Thank you. I think there are no further questions from my colleagues. Then I'll give the next opportunity to Mr. Oppenheimer, who appears for the South African Institute of Race Relations.
May it please the court, Acting Chief Justice.
Yeah.
The South African Institute of Race Relations recognizes the values of constitutional supremacy, the rule of law, adult suffrage, and free and fair and regular elections. If this court finds that it does not have the power to grant the relief sought by the Commission, then it should dismiss its application for postponement. However, if the court finds that it does have the power, then it should exercise its supervisory powers to ensure that elections are held within the soonest possible time, while ensuring that those elections are free, fair, and safe. Given that the COVID-19 waves are unpredictable and occur in different intensities in different parts of the country at different times, it would be much easier for the Commission to split up the work of running elections by establishing timetables in respect of each province depending on the wave. This would empower the Commission to run elections in provinces that have lower active cases while waiting for waves in other provinces to subside. Furthermore, if the Commission can start running the first set of elections before the 1st of November, this would mean that it would be complying in part or in whole with Section 1592 of the Constitution. As Archbishop Tutu has said, the way to eat an elephant is one bite at a time, and what we propose is a method to make it easier for the Commission to comply with its constitutional obligations. The nature of municipal elections is very different from national elections, in that the election results in municipal councils, local councils, and district councils are discrete. They have no cumulative effect, meaning that the election outcomes in one municipality are independent of outcomes in different municipalities. This is different from a national election where the public are voting for members of parliament who will then ultimately vote for one president. Here, the elections are quite discrete. And furthermore, the Commission already appears to plan its elections on a provincial basis. If we look through their submission to the Moseneke inquiry, it's evident that their planning is done on a province-by-province basis, how many electoral offers they set out, how many radio stations they're going to run ads in. Therefore, the first respondent, being the COGTA Minister, should be authorized to proclaim election dates for all municipal councils on separate occasions so that the election can proceed on a staggered basis in each province, and the Commission should be ordered to conduct the election on the same basis. Justice Moseneke in his report states that the local government elections in effect involve 4,725 separate elections, and that the holding of a general election involves probably the single largest mobilization of citizens in the Republic on a particular day. But the Commission is not able to predict with any certainty the trajectory of the virus, and recognize that this uncertainty also poses challenges to the potential climate within which elections will take place. Professor Karim points out that the durations of waves tend to be about 74 days, and that the trough periods between tend to be about 90 days. Dr. Abdullah states that the COVID waves run at different times and at different intensities in different provinces. The country or parts of it will remain at different stages of a wave for the foreseeable future. At no point does the trough of all provinces align with a national average, and this is even more evident in the death rates. My heads of argument at page 7 have some graphs which illustrate this. So instead of seeing one national wave, the provinces are split up, and this comes from the applicant's papers. We can see, for example, in the recent third wave, that in Gauteng, the numbers had soared far beyond those of other provinces, while now they've come down quite dramatically, while those in the Western Cape have accelerated. We see similar things for the amount of deaths and for the hospitalization rates as well. So the Department of Health shows that the impact in different provinces varies at different times and intensity. So I have a graph at page 8. On the left, it shows that the hospitalizations in the Eastern Cape, Gauteng, KwaZulu-Natal, and the Western Cape number in the thousands. The left axis goes up to 7,000 hospitalizations. But the lower burden provinces, being the remaining provinces, that number's in the hundreds. So the situation is not the same throughout the country at the same time. It very much depends on the particular province. There is then a heat map, which I include, which shows how at different provinces at different times, the pandemic can be more severe. So keeping this in mind is quite important. The Commission themselves say that the Minister of Health stated publicly that although COVID-19 cases were down in Gauteng, South Africa is still in its third wave. He explained the position was like a relay race. As cases go down in one province, they take over in another. And the ANC state that all of the medical experts that made submissions to the Moseneko inquiry agree that it is not possible to predict what the pandemic will look like in October in South Africa, let alone the provinces and districts. The waves of infections differ from one province to another. Within provinces and districts, the waves happen at different times. The same happens with regards to the rollout of vaccines, that different provinces have been more successful than others in terms of vaccine rollout. So we know that by the 10th of August, Gauteng had administered over 1.7 million vaccines, while the Northern Cape had administered less than 150,000. There's also evidence in the papers which shows how this goes per capita, so not just raw numbers, but the percentages. Now, the Commission raised 3 separate concerns, which I submit can all be surmounted. Firstly, they make mention of Section 24(2) of the Municipal Structures Act, which states that whenever necessary, the Minister, after consulting the Electoral Commission, must by notice in the Government Gazette call and set a date for an election of all municipal councils, which must be held within 90 days of the date of the expiry of the term of municipal councils. The Commission claims that the section does not facilitate a staggered election or the holding of elections on varied dates. Legislation states clearly that a date must be set for elections to take place in each municipal council. However, the legislation does not explicitly state that each of those elections must occur on the same date. Therefore, it would be reasonable to interpret the legislation as allowing staggered elections to take place on separate dates. Secondly, the legislation is explicit that these elections are to take place within the 90 days of the expiry of the term of municipal councils. Now, for the Commission's application to succeed, this court needs to find a way of overcoming this legislative hurdle. And if necessary, this court could use the same means to overcome the alleged hurdle of all municipal councils having to take place on the same date. It should also be noted that the IFP and CASAC suggest spreading the election out over 3 days, which would reduce the COVID risks. The Commission claims that it would need to alert the public about staggered election dates, and this would be difficult. They admit that it would not be impossible, and they say that it could be expensive. But it is clear from the Commission's planning of the elections that it runs radio campaigns on a provincial basis. It would be rather simple to tailor its message about the forthcoming elections to the particular province that it's running its campaign in. The minor inconvenience of this approach must be compared to the genuine possibility of gearing the whole country up for one election date, and then having to retract that date because there has been a surge of COVID in some part of the country, making a nationwide simultaneous election unsafe. The Commission then claimed that the usual practice has been to declare public holidays on election day, and that a staggered election would be disruptive to normal business activities because more days would need to be declared. But there are 3 simple solutions to this problem. First, instead of declaring a single national public holiday, multiple provincial public holidays could be declared on the proposed election days. So while some provinces are busy voting, those in other provinces would continue working. Second, it may be possible to cluster some provinces together so the elections for those provinces are held on the same day. This would limit the number of public holidays that need to be declared. And third, voting could take place on weekends, so there'd be no need to declare public holidays. It should also be noted that when municipal elections were held in South Africa in 95 and 96, the elections were held on the 1st of November 1995 in most of the country, but delayed to the 29th of May 1996 and the 26th of June 1996 for the Western Cape and KwaZulu-Natal respectively, because there was a dispute about demarcation lines. So if it is possible to do this at the dawn of our democracy, then it is possible to do it in the time of the pandemic. There is also the chilling concern that this court will be faced with further requests for a postponement. Now, the Commission has asked for February, the ANC for April, and the IFP for the 26th of May. In Zondi, this court has held that it has the power to vary the period of suspension of a declaration of invalidity if it is just and equitable to do so based on new circumstances that may arrive. And the DA state that it is likely and at least possible that the Commission will be back in front of this court in December or January asking for it to again postpone the elections because there is a surge of new cases or a new variant or failures in the vaccine rollout. Mr. Trengrove has suggested that we would reach 70% vaccination by February because this is what is hoped for by the Department of Health. But throughout the vaccine rollout, there have been innumerate delays. And so that is a genuine possibility.
Your 10 minutes is up. That is 10 minutes of your address without interruption. You still do have 10 minutes if you have points that are not a repetition.
Yes.
Yes,
Freedom and the law state that in the matters of Calm and Machlope, the Commission had asked for extensions after this court had set out deadlines for compliance, and the Moseneke report warns of the dangers of postponing the elections for too lengthy a time. The report says that many stakeholders in their submissions drew attention to the governance devastation to be found within the ranks of most municipalities in our country. They rightly pressed that the current municipal council should not be given one more day in office if citizens are to be spared more bouts of unaccountable government, inept and dishonest financial accounting, and downright failures to observe the law that governs municipalities. The consequence of this has been repeated service delivery protests in the face of dysfunction and totally inept municipal councils. Some have argued that deferment may encourage or initiate a slippery slope that may undermine the democratic project. We think this is from the Moseneke report, we think this argument has considerable force. Only the most compelling of reasons should justify the deferment of a term of election set in supreme law and other law of this country. For that reason, our recommendation is the elections be deferred only once and to the earliest possible date to be determined as the safest and shortest time which in local government elections may be held without excessive loss of life. Starting elections on a staggered basis would send a signal to citizens that the elections will be completed and they will not be faced with an indefinite series of election postponements. One can think of it like this, is that the IEC has set itself this very, very difficult task of not trying to kill two birds with one stone, but 9 birds with one stone, waiting for those birds to be perfectly located so that there are no COVID waves when it runs its election. We're saying that we can make it easier by giving the IEC more stones. In other words, if it gets more chances to run elections throughout the provinces while it's safe to do so, it makes it much easier to complete the process. Furthermore, this is not a problem that has to carry over for elections in the future. They can be held on the same simultaneous day going forward, either if they're spread out over a period of 90 days, which would then mean that 1592 can be invoked, or that legislation could be introduced to dissolve those councils so that the next municipal election cycle happens within 5 days.
Mr. Oppenheimer,
yes.
The staggered basis, would that not have a cost implication? And in practical terms, how would it work?
Well, just as McClintock had submitted, I can't foresee any cost implications in particular, and the IEC don't raise that there would be any. We must bear in mind that these elections really are separate elections. In other words, they are going to be held throughout the country separately. All this is just a matter of splitting them up. What could have additional cost implications would be if you have a splitting up for each one. So in other words, the IFP and CASAC say that you could have 3 days for the same election. That would mean hiring more electoral officers and whatnot. But in this case, not, because it would be the electoral officers that are based in the particular province that would be hired for that day, and that would cost Rand X, and it would cost the same amount whether it was held simultaneously or split up. And also we know that this kind of splitting up of the elections has already occurred. We know, for example, that by-elections are held on a staggered basis. In other words, it becomes necessary at some points in time to hold elections in certain parts of the countries because there's a need for a by-election. So we already have a system which doesn't require simultaneous elections all the time. This court in Sabia has set out what the test is for supervisory interdicts. And it says that successful supervision requires that detailed information be placed at the disposal of a court. And this is the kind of information that the Electoral Commission could provide on its capacity to split the election up. Furthermore, that supervision entails a careful analysis and evaluation of the details provided, that it cannot succeed without the full cooperation of others in the process, and that courts should exercise flexibility in the supervisory process. Now, what is being suggested by South African Institute of Race Relations is creative in some ways, but it's not illegal. It is a way of making the task much easier, and it sends a signal to the public that elections matter, and that the Constitution will be hewed to as close as possible, and that we will not be in a situation where there's a continual uncertainty about whether these elections will ever happen, because we know that the virus itself is not predictable, but it's much easier to project the situation of a particular province at a particular time. So if it is within the court's remedial powers to allow the elections to be postponed, then it must ensure that the Commission is held to account through a supervisory process. That process must create an obligation on the Commission to start running elections on a staggered basis, and in a manner that provides certainty to voters and political parties, as well as comfort to voters that they will not be indefinitely denied the opportunity to hold elected officials to account through the ballot box. I would submit that if the court finds that it does have the constitutional power to grant the relief sought by the IEC, that one way of mitigating the damage, the constitutional damage that could be done, is through this staggered process, that it doesn't, there is no evidence before this court that it would be impossible to do it. The concerns raised by the Commission seem to be very minor concerns, and we would submit that they are all very easily surmountable. And they are the kinds of things that can be addressed through that supervisory process. It's important that the IEC, if they do say that it is very difficult to do, that they give reasons for that in a more substantial way during that supervisory process. But we submit that it would make it much easier for the IEC, and we want to lessen the burden. Instead of taking 9 hurdles and piling them on top of each other and trying to do one galactic jump, we say split those hurdles up and jump at them one at a time, which will make it much, much easier.
Yes, are you done?
Yes, I have no further submissions.
Thank you very much, Mr. Oppenheimer. Thank you very much. And then I will now give Mr. Albert Lamy, who appears for a free forum, an opportunity to address us. Mr. Lamy.
Thank you for the opportunity, Acting Chief Justice and Justice of the Court. Coincidentally, there's an overlap between submissions made, especially in the written submissions of the various amici, and they have, we respectfully submit, made also compelling argument already on certain key aspects, which we submit you need to consider. Yes. I'm not going to repeat that, it would be repetitive, but there are some aspects which perhaps require amplification. And if I would start off, and we dealt with that in our written submissions, is the spirit and purpose of section 19D. My learned friend, Ms. Leroux, touched upon this in order to urge the court to look at this from the perspective of the rights of voters. And I submit she is perfectly correct in that submission. Because section 61D deals with all those values, in D, the universal adult suffrage, a national common voters roll, regular elections, and a multi-party system of democratic government Why? To ensure accountability and responsiveness. And that is the reason and the purpose why we have limited periods of 5 years of municipal councils, and why the Constitution provides for an extension of that term to the maximum period of 90 days. That's the rationale, that's the purpose. Now, that I submit we must accept with that purpose in mind. Our Constitution has actually catered for what we are experiencing practically on a daily basis on municipal governance level. And that relates to the dysfunctional state of affairs of municipal government right through the country. So what we're saying is, in no other time, and this is what we submit the court respectfully should weigh up, no other time than before has the situation cried for an election so that the voters can exercise their right in order to keep councillors accountable and vote them out. Now, but it goes further, our submission goes further than just the state of affairs. But may I just interrupt myself? On this aspect of the importance of the regular elections, may I just remind the court of what was said by the majority of this court in Moshope, in paragraph 127, when the court was faced with the situation to craft an equitable, a just and equitable remedy, where there was an unlawful aspect about the elections, without the court having to find that it was necessarily not free and fair, but it was unlawful. The court was extremely conscious of the fact, as pronounced in paragraph 127, where the court said the following: that said, the Constitution does not provide for the extension of this term of 5 years. Every constitutionally permissible solution must thus be explored to avert a looming constitutional crisis that could result from the unconstitutional elongation of terms of office. In other words, this court said that our just and equitable remedy that we consider in our discretion in this case should avoid an elongation of the terms. That was how strong this court viewed that term. And that is perfectly, I respectfully submit, in line with the spirit and the connection with the foundational value in section 1D of the Constitution. We have the benefit also in the meantime, Acting Chief Justice and Justice of the Court, of a majority judgment, which we refer to in paragraph 3.5 of our heads of argument, in the matter of Premier for the province of Gauteng and others versus Democratic Alliance and others. And we quote, and I'm not going to repeat that on page 5, but here, upon the dissolution of a council where the powers of a provincial executive was invoked in terms of section 1391C of the Constitution, the issue was whether the administrator, where the provincial executive interfered with another sphere of government, a local government in the city of Tshwane, whether that 90-day period could be extended. And the court said no, and the court, it's the full court, I beg your pardon, it's the Supreme Court of Appeal, but that the Supreme Court of Appeal endorsed the judgment of the full court in the court I quote. And the court there also referred to Moshope as far as that period is concerned. But as far as the state of affairs of the local government is concerned, where my client, the Fifth Amicu Afri Forum, is, as we said in the affidavit for the application of the Amiskura, experience this on grassroots level, the state of affairs, because they've got branches all over the country. And we say the following is that, bear in mind that with this dysfunctional state, there is a range of constitutional obligations that are not fulfilled by municipalities, they in themselves infringe fundamental rights as a result of that is concerned. One can postulate infringements of the right of dignity inter alia with regard to poor sewage systems, etc. It can be, one doesn't need to be set out a factual basis for that. I think it is, and it has been alluded to before, the Moseneke inquiry, which found that to be a very compelling reason or a compelling consideration. But we go further, and this is as to contemplate the effect on local governance by virtue of the statutes that regulate local governments and executive and legislative powers by municipal councils. And we don't see with any of the parties before the court, with the greatest of respect, that this has been, especially the parties that propagate a postponement of the election up to February or even further. And we say, consider, for example, Section 25 of the Municipal Systems Act, where there it is prescribed that after the start of its elected term, a municipal council must adopt an inclusive and strategic development plan. And we go on in the heads of argument, and I'm not going to repeat it, to say, how important is that? It is one of the most important planning, strategic, or one of the most important documents that the municipal council must adopt after its election. It guides and informs, as we say in paragraph 3.13, all planning and development. So what we're saying is, where we have already way up these in the factual scenario, deplorable state of affairs in local government, you are asked by the IEC to postpone this into the next year, effectively. How is it going to impact on compliance with that legislation? Because we also demonstrate with other provisions here that it has a domino effect. If you don't timelessly adopt your strategic plan, and bear in mind that you need to comply with public participation requirements before you adopt it, it's have an impact on your budgetary process of a municipality. And we all know, in terms of the Constitution and in the legislation, by 1 July next year, the budget must be adopted. Otherwise, there's, in terms of Section 139(4) of the Constitutional obligation on the provincial executive to step in when that budget is not timelessly adopted. So whether this court has to weigh up a just and equitable remedy in its discretion, whether it considers Section 1D or 159 or the possibility, what we're saying is consider these aspects which are, we submit, key. If I may step on to the concept of free and fair elections, and that has also been touched upon. And it interlinks with
Mr. Rami, the 10 minutes is over. That is the 10 minutes of no interruption. So you can still continue, but you can be interrupted anytime now.
As it pleases you, Acting Chief Justice.
Yes.
May I proceed to the next topic?
Yes, proceed.
Mr. Tringove, I understand, and I don't want to do any injustice to his argument. As I understand his submission is, we don't submit the impossibility aspect in the context of the concept in contract law of impossibility. But what we're saying in our heads is that if that is what it amounts to, consider that concept. And it's an absolute one. We have as a resource Christie the law, the well-known work of Christie, the law of contract in South Africa. And if we look at the page in that work, the 6th edition, whether you talk about supervening impossibility or whether you talk about initial impossibility, it boils down to the same test. There's no room for relativity here. If we consider the evidence in this case about the medical evidence, for example, it boils down to a relative weighing up of benefits and risks. That doesn't fit into the impossibility doctrine, I submit. But even if you say, well, it's not reasonably possible for the IEC to expect to ensure and manage free and fair elections because of logistical difficulties that we have, we say, what is the test that the IEC has applied for what is the value judgment that it itself exercised in order to express that view? And that's not clear. And we submit it is for the court ultimately to independently exercise that value judgment. It must be an objective value judgment. But what we say is it appears that the value judgment has been exercised by the IEC as if they have to manage and ensure an election in normal times. And we say, well, it would not be reasonable to expect, and that's the other side of the coin of the argument of Mr. Tengo, is that we cannot reasonably expect the IEC to ensure a free and fair election in normal time, in abnormal times. In other words, the concept of free and fair, exercising a value judgment, as Mr. Gauntlet has also pointed out, has to be exercised in the context of the pandemic. For example, a practical. If you had normally, it would be ideal to have a registration weekend. What's the reason for that? Because voters are encouraged to register. It's not that the law, as we look at the Municipal Electoral Act or the Electoral Act, requires a voter registration weekend. But it's common sense that it's ideal. But circumstances overtake you, and you cannot have that, a voter registration weekend. Does it render that element, the election, necessarily not free and fair, if we apply a value judgment in the context of the pandemic? And that is what the other arguments, and that is where we support also the argument, is you cannot expect the perfect in imperfect conditions. And that is how we submit the value judgment should be exercised. And we say that is a vital flaw in paragraph 3.6 of the Commission's approach as it would appear. And that touches upon the impossibility argument I submit. And we've referred further to come in the heads of argument. I'm not going to repeat that. We've set out the key elements. Another point that was raised was the inability of the political parties to mass rallying during this pandemic. Well, again, we're sitting with a situation where normal rights are necessarily restricted by virtue of the application of the Disaster Management Act. Rights have been infringed across the life in South Africa. Obviously, it will impact, and there will be restrictions upon electioneering, because it's not perfect. We don't have a normal year. And therefore, we submit that necessarily would also not render the elections not free and fair in this context. We deal with also in the heads of argument as to up to June what the Commission has said to the Moseneke inquiry about their state of readiness, what measures they have implemented, especially as far as COVID protocols are concerned. They tell us, the Chief Electoral Officer, in a long-page document and in a PowerPoint presentation, that they've learned also lessons from the by-elections that they had where they already applied the COVID protocols. So that how they're going to improve this. In other words, the IEC itself are taking proactive steps, and they tell us what proactive steps they take in order to mitigate this risk as far as the elections are concerned. The table was turned around.
You have 1 minute.
As it pleases
1
you.
minute left on your 20 minutes.
As it pleases you, Acting Chief Justice. The commission was on path. The table was turned around when the report comes out after the Moseneke inquiry. And we say what the pillar was of that. And that was the state of vaccination. That was the key thing. And we say, but even that state of vaccination is not asserted, because the expert evidence said, apart from it's no secure remedy necessarily, there's a protection as far as serious illness is concerned and death. But it was also qualified to say that presupposes that we don't have new variants that would affect the efficacy of the current vaccines. So even there's an element of uncertainty. In a nutshell, we have also analysed in the submissions the Commission's own version with reference to Annex FA 12 as far as the state of registrations are concerned. It is not as if a registration week is the be and end all of registration. The registration process is long in process. It is just a special measure to encourage it further. It cannot be so decisive. But we don't oppose the submissions of the political parties that say, well, there is actually an alternative. As it pleases you, Acting Chief Justice, those are our submissions, and we, in a nutshell, at the end conclude that this court should simply not grant the relief. It should just dismiss the application of the ISC, as it pleases you.
Thank you very much, Mr. Lemon. I don't know why there seems to be an echo now. Oh, it looks like it's gone. We have two more, and then two more to address us, and thereafter it will be Mr. Chengov in reply. We didn't talk about any break after 4, but I see that we are going to complete about 2 hours since the last break. Maybe we should either have a break now of 10 minutes, or we can take one and then take the break after that. My colleagues, do you have something to say about that?
A 10-minute break now, ACJ, would be appreciated.
Okay, all right. Okay, let's take a 10 minutes break now, and then when we come back, I'll give a chance to Mr. Philip Mechanic, and thereafter to Mr. Ngandwe, and thereafter we'll have Mr. Chengov in reply. So we'll take let's say it's a break up to 6:10. The court adjourns.
Court will adjourn until 6:10. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 6:10. Should you exit, you may use the same link to join the hearing.
Is everybody back?
Justice Madondo's video is not yet on, Acting Chief Justice.
Okay.
There he is.
Oh, is everybody there? Okay, all right. Thank you. Let's resume. Mr. Philip Mechanic, I hope I am pronouncing your surname correctly, but please do correct me if I have not pronounced it correctly. I will now give you a chance to address us. You also have 20 minutes, except that we wouldn't like a repetition of points that have been dealt with, but subject to that, you also have 20 minutes like other amici.
Well, thank you, Acting Chief Justice. I have been working on my oral submission as I've gone along to exactly meet those requirements.
Yes, thank you very much.
Good, and unfortunately my voice is just playing up right now. Anyway, my papers go to other issues like whether the normal voter registration process is constitutional, but I'm not going to go into any of that because I'm sure you've read it.
Yes.
And my focus is on trying to address issues that have come up in oral argument
Yes.
that either I disagree or I want to try to add. So first of all, I concur with the EFF view that our constitution should be read as a living document. Hence, the terrain in which it operates is relevant. So we have one of the best constitutions in the world because it recognizes the need to address restitution for an unjust past. So in simple terms, you could say it recognizes that Black lives matter and poor lives matter. But the lived reality of the poor is very different. In my founding affidavit, paragraphs 15 to 18, pages 4 to 5, I present facts on the dysfunctional state of municipalities, specifically focusing on my own here in Makana, which has actually been subject of a High Court order to dissolve it under Section 139(1)(c) of the Constitution, now under appeal. So we suffer a litany of failures that are all too familiar around the country: water at best every second day, a filthy environment, RDP houses not built or crumbling, sewage flowing through people's homes, stern but unaddressed Auditor General reports. So the poor are entitled to feel disappointed with their hopes being dashed after 27 years. Structural racism and inequality are as entrenched as ever. But the problem is not with the Constitution. It is with the failure to implement its promise. And the solution to that is not to tear up the Constitution, it's to tear up the government. And you do that in a constitutional democracy through elections. So even if there is a constitutional basis for delaying the elections, and I'm skipping all that argument because that's been thoroughly dealt with, I question two aspects of the case for doing so: the epidemiology and the presumption that electioneering is the only political activity I covered in my founding affidavit, and the Commission didn't address that in their response. In my founding affidavit, paragraphs 36 to 38, page 8, I add evidence that recent research on the level of vaccination needed to counter the Delta variant is much higher than the government is aiming for. And the other factor, which I think is adequately dealt with by Professor Karim in the Justice Moseneke report, is the possibility of immune escape. And that is really one of the areas of biggest uncertainty. If you want an example of what immune escape is, you may recall how our very first batch of vaccines, the AstraZenecas, arrived here to great fanfare and then were sent away because they happened to perform very poorly against the beta variant, which is what we were dealing with at the time. Now, I'm not an expert in this field, but I am a scientist, so I do need to know how to read the expert opinions. And the experts are uncertain, not because they don't know what they're talking about, but precisely because they do. What this reflects is the uncertainty of the trajectory of the pandemic from here on, and the further away in time, the greater that uncertainty. So they can predict October with some degree of uncertainty, but if you move further on, January, February, March next year, it gets more and more difficult. And one of the difficulties is this issue of immune escape. It's something that's very unpredictable. And I can explain that if necessary, but I do think it's a pity with this sort of proceedings, you can't directly take evidence from the experts because they could do that better than I can. The other big issue where the experts agree is the real big risk with electioneering is large crowds. There's no dispute about that. As long as the pandemic is on, we have to worry about that. So the thing which is not answered in my founding affidavit, paragraphs 19 to 24, pages 5 to 6, is the non-election political space. Just the fact that elections are not on doesn't mean to say that there's no political campaigning. We all know how bad the July 2021 unrest was, mainly affecting KwaZulu-Natal and Gauteng. And that's exactly the sort of activity that the experts warn could be a super spreader event. And I haven't seen definite evidence on this as yet, but if you look at the infection curves in Gauteng and particularly KwaZulu-Natal, they reflect a dip around the period of the unrest when testing stalled and a sharp increase afterwards, particularly in KwaZulu-Natal. And this happened in a very wide geographic region. So the Commission has not countered my view that the Electoral Code of Conduct could be used as a tool to sanction campaigns that violate COVID-19 safety. And I also contest the view that wealthy parties are the most inconvenienced by delay. The smallest parties that have intervened are the ones that are among those that are opposing. I notice in the Forum for Service Deliveries heads that argue financial inconvenience if the elections are delayed. And I'm here without counsel, not because I believe I have better legal knowledge than my learned colleagues. That's obviously an absurdity. I'm here without representation because my small movement couldn't afford to pay for lawyers. So if you look at the political landscape broadly, there's enormous reason for anger because of the numerous failings of government, some of which I outlined earlier. And angry protest is very likely in these circumstances, as is other forms of political activity that occur between elections. So at least in the context of the election, you have a mechanism to enforce compliance to safety regulations. So I argue that it's a mistake to see the problem as a strict binary. We either have elections or we have no political activity. So turn now to remedies. As I listened to all the other parties, the biggest area of dispute, aside from actually shifting the date, appears to be the feasibility of an October-based timeline that includes the registration weekend. The DA claims this is possible, the Commission claims it is not, and there are various other parties that have argued detail of that. Now, I don't have the technical and legal expertise to take these arguments apart. Possibly the court does. So the real question to me is whether the Commission is submitting obstacles that are removable without constitutional injury. In other words, are these obstacles things that require more funding? The existing legal framework impedes carrying out these processes. And under Section 172, this court is competent to remove any obstacles of that kind. If there's more funding needed, if a temporary change in the law needs to be ordered or whatever. So if obviously the court is able to work this out, that's not a problem. On the other hand, I can, if it would please the court, offer up a solution. But let me get through some of my other points first. The EFF prays to vary the COVID measures to fit their processes, to avoid legal challenges. Unfortunately, the virus is not susceptible to legal challenges. And I would argue instead, if parties are running into this sort of issue, they should vary their own processes. And if they can't do it through their normal internal democracy, they should apply to the courts for an order that will preempt legal challenges. But that's for them to decide. So the IFP proposes opening more voting stations, but a longer time to vote is a simpler way of reducing the amount of queuing. We've already had a proposal, I think, from SIRR to extend the voting days. A very simple way of doing that would be to simply have no excuse special voting. Special voting, I believe, goes over 3 days. Simply take away the requirement to apply and allow anyone who wants to vote early. Several of the parties represented in this matter are represented in Parliament. There's nothing to stop them setting in motion the process for a constitutional amendment that would have a temporary effect of delaying elections as a backstop in case all other measures fail. And that amendment could simply never proceed to a vote if it was not necessary. But there's nothing to stop them from putting it in motion. So getting back to the major issue and contention of being able to fit in the registration weekend. Well, one possibility, if the court would like to have further information, yes?
The 10 minutes of your address without interruption is up, so you may be interrupted any time from now on.
Excellent. I have very little to add, but please feel free to interrupt as you're right. Anyway, so one possibility here would be to get the disagreeing parties on this particular issue to meet and cobble together a settlement. You know, come back to the court with a list of things that need to be overturned that are regulatory issues or financial issues or whatever. The other issue is if parties are not able to nominate by the 23rd of August, allowing others to go past that deadline may disadvantage those who have met the deadline. On the other hand, I can see the argument that reopening registrations should also mean nominations shouldn't be closed. So one possibility then is to put an immediate stay on nominations, which then could be revisited once you make an actual order. And so if you could get the parties who disagree on this issue to meet to come up with a checklist of actual requirements that the court could meet that are within its competence, that's one possible solution. I'm just offering this for consideration. And the final point I want to make is that on the SABC news site on the 19th of August, it reports that the ANC is on track to submit its election candidate list to the IEC. Now, I don't have a perfect memory, but I seem to recall the counsel for the ANC saying in court that they were not able to meet the deadline. And they definitely do say in the heads, paragraph 46, page 19, this process simply cannot be done in the 2 weeks which the Commission has provided for in the current circumstances. Right, so that's it from me. So any questions, I'll be very happy to take.
Thank you. It doesn't look like there are any questions from my colleagues. Thank you very much, Mr. Mechanic. Thank you very much. And now I will give the opportunity to Mr. Ngandwe, who represents the Forum for Service Delivery.
The courts.
Yes,
Acting Chief Justice and Justices of this Honorable Court, I will graciously accept the 10 minutes without questioning, it being made an appearance before this Honorable Court.
Okay. All right, yes, proceed.
Acting Chief Justice, a lot has been said. It's late in the day. I do not intend to be long, even though in my culture, saying that the last one to eat or to speak is king. I'm not going to assume the position of a king. Justice, I wish to address you on 3 main issues. The first one being the position of the Forum for Service Delivery, what its attitude is in this matter. And its attitude is simple, that this Honorable Court should not allow the postponement of municipal election. That is the attitude of the Forum for Service Delivery. Secondly, I would like to then address you on the issue before you, the question that is posed before you, precisely what you are required to do. From then onwards, I'll venture to deal with some of the issues on the merits or substantive issues where I need not repeat some of what has already been canvassed. And lastly, I will deal with the issue of the cost. You would have realized that written submissions, we at length and thoroughly discuss the issue of costs. Acting Chief Justice, let me then venture to deal with the position and attitude of the Forum for Service Delivery. I earlier indicated the Forum for Service Delivery is opposed vehemently to the postponement of the elections for the simple reason that that will be unlawful, unconstitutional, and invalid. Further to that, I want to now venture to deal with the question before you, what this honorable court is asked to do. My simplest of interpretation and characterization of what you are required to do is this, that the Constitutional Court of the Republic of South Africa is asked to commit a violation of the Constitution of the Republic of South Africa. Not only is this Constitutional Court asked to act at variance to the Constitution, it is further asked, as if that is not enough, it is further asked by the applicants to take the hand of the applicant while the applicant is in this journey of violating the Constitution and acting unlawfully. Take the hand of the applicant and supervise the applicant while violating the Constitution. Why do I say so? What is asked of this Constitutional Court is at variance with Section 1 of the Constitution of the Republic of South Africa. That is the founding values of the Republic of South Africa. That is the supremacy of the Constitution, common voters' roll, etc. Secondly, what is asked of this Constitutional Court is at variance and in direct assault of Section 2 of the Constitution, that is the supremacy of the Constitution. This Constitution enjoins all and sundry, including this court, to ensure that the people are afforded the right to political franchise under Section 19. What the applicant is saying is either limit this right, either suspend this right, or amend the Constitution. But an amendment of the Constitution, we all know, in terms of the Constitution, falls squarely within the province of the National Assembly. The Constitutional Court is asked to usurp the powers of the National Assembly. That is glaringly wrong. That is as clear as daylight. There is no canon of interpretation that can lead to a different conclusion. It's clear as a pole towering and protruding above the water. Nothing else can be said about the situation. This court is asked to commit an act of violation of the Constitution. Not only is this court called upon to violate the sections I cited, throughout the day, Section 159 has been cited. You are asked to violate the section, including Section 24 of the Structures Act, which read together give an injunction of when municipal elections should take place. The applicant has known since 2016, the last municipal elections, that this year, somewhere in this year, municipal elections should take place. What did they do? They did not do anything. The applicant has known since March 2020 about the COVID pandemic, when the President of the Republic, Mr. Ramaphosa, put the country under lockdown 5. The applicants knew that it could well be that even this year, we will have a problem of COVID and restrictions, but elections should happen nonetheless. The applicants have failed in this manner, Justice. The applicants have failed to make a plan. It is clear we have 5 levels under COVID: the 1st, 2nd, 3rd, 4th, and 5th lockdown level. Now, what was simply required as a rudimentary responsibility of the applicant was, under each level, anticipate that this day of elections may come under any of the 5 levels. They failed to put plans in place under each level so that by the time we get there, we have anticipated the situation and we can still allow elections to go on. As simple as that. No rocket science. Now, the applicant has also failed to consult the relevant bodies to municipal elections. What do I mean by that? Under paragraph 18 and page 18 of the applicant's founding affidavit, they say they consulted the National Party Liaison Committee, and the National Party Liaison Committee has unanimously said, well, we will not be ready for elections should they happen this year. That is not entirely the relevant body. We are talking about municipal elections in this matter, and the Forum for Service Delivery is one party in these proceedings with a sui generis, a special interest in that the Forum for Service Delivery has participation and representation only at municipal councils. They don't have representation at provincial level and national level.
Your 10 minutes of address without interruption is up. You may be interrupted any time from now, but you still have 10 minutes.
As the court pleases. Now, I'm touching on the very importance of the sui generis of the position of Forum for Service Delivery. They only have representation at municipal council level, meaning the consultation that took place at national level, they were not involved. Their voice was never heard. The first time that the Forum for Service Delivery is heard is today, Acting Chief Justice. And that is the lacuna, that is the problem. The applicant has failed to actually consult adequately and at the relevant level. Chairperson, if you agree with me that my characterization of what you are requested to do is correct, then that's the end of my submissions. In fact, not only is it the end of my submissions, it's the end of this case. If you agree with me that indeed the relief that is sought is such that it puts you in a precarious position where you have to commit an illegality. End of the matter. However, if I am wrong in my characterization of the situation, then I venture to deal with some of the merits I would not want to repeat. The mainstay of the applicants, the mainstay of the argument is this. The argument on impossibility, 1. Secondly, the voter registration weekend. Justice Theron eruditely pointed out the wrong and the contradiction in the applicant's submissions. And she correctly pointed them to paragraph 229 of their founding affidavit, which contradicts the claim of impossibility. Acting Chief Justice, I want to introduce a similarly contradictory and mutually destructive averment in the affidavit, in their founding affidavit, again at paragraph 17. At the bottom of paragraph 17, and I will read verbatim, it said that is number line from the top on page 18. It reads thus: however, for reasons I will explain by 30th August 2021, or at least the 10th September 2021, it will no longer be possible to implement both timetables, and the Commission will have no option but to proceed with the local election in October 2021, despite its constitutional shortcomings. They are saying the election is possible, even though they will have shortcomings. There lies then the lacuna in their argument. The argument collapses here right now. Now, they are talking about impossibility. At the same time, they must be aware that the Constitution, the Electoral Act, and any other law do not require or request a perfect election. Their argument is that if they have this election now, this election will not be free and fair. The argument of the Forum for Service Delivery is this: in any event, this election has never been free and fair, at least for the purposes of the Forum for Service Delivery. Why do they say so? Now, Justice, I venture to deal with the last part of my oral submissions, that is the cost. I deal with the cost simultaneously as I deal with the question why the Forum for Service Delivery contends that in any event, for their part, these elections have never been free and fair. Hence, the acknowledgement of the imperfection of these elections anyway. We pray for legal costs, including the cost for 3 counsel, as I introduced them earlier. This is the reason why the Forum for Service Delivery is not funded by the state, whereas it is a fully registered political party. Why is it not funded? The problem lies with the Constitution. Section 236 of the Constitution is unfairly discriminatory against parties that have no participation at national level and at provincial level. Why do I say so? This provision says legislation should be promulgated in order to promote multi-party democracy by funding of political parties participating at national level and at provincial level. And it leaves out parties participating at municipal council level. This is the reason why our clients are men of straw.
Mr. Ngad, do you need any constitutional argument to get your costs if you are successful?
I did not get that.
Do you need a constitutional argument to get your costs if you are successful?
I do not need, we do not need a constitutional argument.
So
it is merely to augment the argument.
Okay.
Thank you.
Yes. Did you say that the issue of cost was the last point you wanted to address?
It was the last point, but I must add that, added to Section 236 of the Constitution, then that act was promulgated, which is the Public Funding of Represented Political Parties Act 103 of 1997, which then puts in action this unfairly discriminatory provision of the Constitution. I want to deal quickly with the last part, which is the voter registration, which is used as a ration deterrent for this application. that there has not been enough voters registered to vote. My humble submission is this. There is a wrong assumption that is made that merely because citizens are choosing not to register to vote, they should be cajoled and coerced to vote. No. My humble submission is that the decision not to vote in itself is a vote. It may well be a vote of no confidence on the political enterprise of the country. Why should this be used as a Russian deterrent to postpone elections? That is wrong. Of course, there may be other citizens who have not registered because of COVID restrictions, but there should not be a wrongful assumption that is wholesale. Acting Chief Justice, that will be all. The forum.
Thank you very much, Mr. Andre. Thank you very much. Thank you very much.
As the court pleases.
Yes. Mr. Trengov, are you ready to address us in reply?
I am, Acting Chief Justice.
In the morning, I said we would give you 30 minutes, but you are free to use less than that.
Thank you very much for that freedom. We are also keen to finish as soon as possible. My learned friend Badlander will again help me do the reply, but we promised to finish within the time allowed.
Yes, okay.
Can I just start with this? We submit with the greatest of respect that none of the opponents of the application have addressed the real issue in the case. What they do is that they focus on the requirement of regular elections, and particularly the requirement in section 159. And they say that it is clear, and it is absolute, and it is not subject to limitation. And they are dead right. That's absolutely so. But they then fixate on that section alone. Ms. Leroux points to its absolute nature. My learned friend, Mr. Du Plessis, calls himself a proud absolutist. They are all correct. That section is absolute, unqualified, and clear. So that to make that point is not to address the real problem in the case. The real problem in the case is that there is another absolute right, and that's the absolute right to free and fair elections. As Justice Madlanga pointed out, it is implied in section 1 in the requirement of a democracy. It is guaranteed in section 19 as a fundamental human right. And it is entrenched in section 191B, where it is, as in section 159, it is equally unqualified and absolute and not subject to limitation. So to say that section 159 is absolute, unqualified, and clear is not to address the question. The question is, what do you do when there are these two fundamental rights, both of them clear, unqualified, and not subject to limitation, and you can't satisfy both? What do you then do? Well, the absolutists say 159 is absolute and therefore you must comply. But that doesn't address the problem. Why comply with the one and not the other? How do you choose between them? What is there in their nature to suggest that the one should prevail and the other not? My learned friend, Mr. Bishop, said, well, all that is required of free and fair elections is that you do your best. But that, with respect, is not so. Combs' judgment makes that absolutely clear, that the Constitution requires free and fair elections which have a range of qualities, and it is more than just to do your best. And we accept in this case that there is a debate as to whether free and fair elections are possible or not. That is a factual debate, and that is an issue you have to consider, as Justice Moseneke did. But if you conclude that an election on the 27th of October will not be free and fair, what do you then do? what does one do if you can't satisfy both constitutional requirements? Both are clear and absolute. My learned friend, Mr. Gauntlet, speaks of a relative impossibility. There's nothing relative about it. The Commission can organize elections by the 27th of October, so it can meet the deadline, but they won't be free and fair. It can organize free and fair elections, but it can't do so by the deadline. So what it absolutely cannot do is to satisfy both constitutional requirements. And that is the issue on the case. That is the issue our learned friends did not address. They tell you how important 159 is, how absolute it is, and they are quite right. But they don't tell you what the Constitution requires you to do when you can't meet both requirements. And we submit with the greatest of respect that the question then is, what does the Constitution require when there are these two conflicting requirements, both equally important and equally absolute and equally clear, and you can't meet them? We submit with respect that the Constitution must then be given a sensible interpretation, which we submit inevitably must be that if you can't comply absolutely with both requirements, then you must comply as closely as possible with both of them. And what is the obvious way of obeying that injunction, of complying with both of them? If you can't do it absolutely, then as closely as possible. Now, we submit that the obvious solution then is to have a free and fair election as soon as possible. It is true that it won't meet both requirements because that's impossible, but a free and fair election as soon as possible, we submit, is the obvious and proper and rational interpretation of what the Constitution requires of us in these circumstances.
Sorry, Mr. Tringo, may I just ask, because I didn't have a chance to raise this with you in your chief argument. Framed as a question of impossibility, that doesn't really seem to answer the case, because if your facts are right, it's impossible to have free and fair elections before the 1st of November. But what we do know is that it is objectively impossible, and that's a very clear case of impossibility, to have constitutionally valid elections after 1 November because of regularity in section 159. So it's not, one can't properly say that we must invoke impossibility as a reason not to comply, because on any version, on your approach, there's impossibility. Is that correct?
There is inevitably a breach of one or the other of the two constitutional requirements, yes.
So, for example, a court, there's this notion of a prospective declaration to say they won't be constitutionally valid if held before the 1st of November because they won't be free and fair. One could equally say that the fact that a court could make that declaration doesn't allow the court to make a declaration that they will be constitutionally valid after the 1st of November, because then it's confronted with another ground of unconstitutionality.
Justice Rogers, certainly yes, but let me just make quite clear that you assume that each of those requirements is absolute, and if you can't comply with both, then that the Constitution doesn't permit of any solution to the conundrum. And we submit with respect, if you ask yourself, what does the Constitution require of the Electoral Commission if it can't comply with both? Then
why does the Constitution have to provide an answer in its current terms? If the Constitution was framed on the assumption that all of those compliance could be met, why should we look for an implied answer in the Constitution?
Well, because you must ask yourself, what does the Constitution require of us when?
Well, if the Constitution makes provision for amendment, what circumstances may arise which the Constitution are not apt to deal with? Your approach effectively treats constitutional amendment as nugatory or unnecessary because every situation, not already contemplated can be dealt with by some judicial implication. But why should that be so?
Well, because we submit with respect that the Constitution should be interpreted and understood as an integrated document which does not contradict itself. And when in rare circumstances a contradiction arises, then one must ask yourself, what is the constitutional answer to this conundrum? And let me say on that suggestion that the Constitution would require a constitutional amendment. There is nothing in the Constitution to suggest that the Constitution ever imposes an obligation on anybody to seek an amendment of the Constitution. But in the circumstances of this case, it would be particularly invidious to make such a suggestion, because you would go to the majority party and say, please amend the Constitution, because this election, I can't hold a constitutionally compliant election, and leave it to the the majority party. Remember, it has a veto on any amendment. It might not be able to make the amendment on its own, but it certainly has a veto on it. Why would it be constitutionally desirable and appropriate to say to the Electoral Commission, you shouldn't come to court and ask the court to find an answer in the Constitution. You should go and ask the majority party, who may decline your request for political reasons, as politicians do. And even if they don't, even if they accede to the request, what a precedent does one set that the majority party can entrench itself by amendment of the Constitution and so extend the term of office of those in power. So we submit with respect that the constitutional amendment is not a constitutionally mandated and certainly not a constitutionally required solution. But let me then just add to that. Oh, there are two riders that I should add to that. Both my learned friend, Mr. Du Plessis, and Justice Tron understood paragraph 82 of our reply to say that we seek a constitutional amendment. But that, with respect, is not correct. And that is apparent if one reads paragraph 82 with paragraph 81. Let me start with 81. It says, various parties or amici suggest that the appropriate solution is for Parliament to resolve the problem of the October 2021 local government elections. Indeed, some go as far as to criticize the Commission for not having done so. And then it comes to paragraph 82. I emphasize that any suggestion of a parliamentary solution should not overlook the fact that what is actually being proposed is a constitutional amendment. That means being proposed by those who say that we should have gone to Parliament. The second rider is this, Justice Rogers. The Commission, on the advice of Justice Moseneke, we submit correctly, did not seek out that solution. What is quite clear is that it is no longer a solution. It is no longer possible to solve the problem by going to Parliament. The Democratic Party agrees with it, and it's obvious. There is no longer time to amend the Constitution and so achieve a constitutional elections in good time. So that even if you were to hold that the appropriate solution was a constitutional amendment, then the fact is that the Commission did not pursue that solution. You may then criticize it for not pursuing the solution which you hold to be the appropriate one, but it doesn't solve our problem, because we still sit today in a situation where we are unable to hold constitutionally compliant elections by the 1st of November. My learned friend, Mr. Lamy, makes an argument which says, well, elections will at least help to improve the dysfunctional municipalities. And it is an understandable argument. It's an argument that says, well, an imperfect election is at least better than nothing. But we submit with respect that that is not so. Firstly, an undemocratic and unconstitutional election is not a solution to anything. Secondly, if you, in a misguided attempt, try to solve the problems at local government by an undemocratic and unconstitutional election, then those elections will be overturned and you'll be worse off tomorrow than you are today. So that understandable approach is, with respect, not one that is constitutionally permissible or wise. Lastly, on the issue of impossibility, it is an issue of fact, and there is a lot of debate before the court on the question of impossibility. But we submit with respect that no convincing evidence has been adduced to counteract the Commission's evidence on 3 issues. Firstly, that proper voter registration before the 1st of November is impossible. It means that you're going to disenfranchise lots of people. Somebody said, well, it'll only be 600,000 people. Not so. The rights of voters is at least to have an opportunity to register. And if you don't make this opportunity available to them, then the rights of all 15 million people are violated. Secondly, the nomination process. All the parties agreed that there isn't sufficient time for the nomination process to be completed. And if I may refer you in this regard, the facts are that in order to have an election on the 27th of October, the Commission tells us that according to their timeline, the nominations have to be completed by the 23rd and 27th of August. That's Monday and Friday. The ANC and others say that that's impossible. All the parties said on the 2nd of August that that's impossible. And may I refer in this regard, just give you 2 references to the record without going there again. We deal with it in our heads of argument from on page 29 in paragraph 111. And then importantly, there's an important supplement in the supplementary reply to the EFF at page 882 in paragraph 8. And that is a factual debate. I'm not going to engage in the debate again, but we submit with respect that nobody has adduced any persuasive evidence to contradict the Commission's evidence that it is impossible to hold free and fair elections by the 1st of November. Those are my submissions, and I leave the rest to my learned friend, Mr. Butlander.
Thank you, Mr. Trengov. Mr. Butlander.
Acting Chief Justice, for the second time in less than a year, I'm arguing in this court at 7 o'clock with the aid of lights. But anyway, it's I have the last shift, and I promise to be brief and to the point.
Yes.
Acting Chief Justice, my learned friend, Mr. Trengov, has explained quite rightly with respect how on the evidence it is impossible to hold a constitutionally compliant election in October. I want to assume that despite that, the court is not with us on the doctrine of impossibility for whatever reason, for doctrinal reasons, for blame reasons, for whatever reason. And I want to explain why we've had no answer with respect as to why the alternative relief should not be granted. And I will focus, therefore, on the alternative relief, and I will assume that the court is not going to go down the doctrine of impossibility route for purposes of this argument. When we're there, that means there are 3 questions. The first question is, does the blame game matter for purposes of 172? The second question is, must a declaration of invalidity be made under section 172(1)(a)? And the third question is, what is the just and equitable relief under 172(1)(b)? Could I deal with each of those in turn? So the first point is that there has been a lot of criticism of the IEC by our learned friends. Our learned friend, Mr. Jamie, at length criticized the Commission for not having approached Parliament. my learned friend, Mr. Trengove, has explained why that criticism is unjustified and made reference to the Justice Moseneke's report, where he himself raised this concern about whether an amendment was appropriate. That is paragraph 253 at page 220. But for present purposes, and let me say one thing. There's criticism that the Commission didn't go to Parliament because of its also practical concerns about whether an amendment would be passed. But with respect, we're living in the real world here. The Commission is facing an unprecedented dilemma or crisis. It can't go to Parliament in the hope that something miraculous will happen against all the odds when it knows that enough parties will not back it. It needs a real solution to a real and unprecedented crisis. So the Commission's stance was justified, but for present purposes, let me assume that it wasn't. Let me assume that the Commission got it completely wrong, that the criticisms are warranted, and that it should have gone to Parliament. The practical reality is that we are here now. There is no constitutional amendment, and it's too late because, as the DA recognizes, our learned friends of the DA recognize, Section 74, 3 and 7 simply preclude it being done in time. So the question then is this: we're too late. There's a problem. Impossibility. Does the blame game matter? And the answer is obviously not, because Section 172 of the Constitution and the granting of just and equitable relief has never been about who is at fault. Parliament passes laws which are unconstitutional, sometimes through to ineptness, sometimes through to negligence, sometimes through to good faith. They get struck down and they all get treated just the same. Let's find a just and equitable solution. The president makes decisions to exit SADC tribunals, to abolish international criminal courts, to do all sorts of things, sometimes for good reason, sometimes for bad. And the question is the same. What is the just and equitable relief? The blame game is, with respect, irrelevant to the alternative relief. I accept it's relevant to the doctrine of impossibility, but it is utterly irrelevant to the question of the alternative relief under 172. And if you needed any more convincing of that, one need only look at Mhlope. In Mhlope, this court held that the Commission had got it completely wrong as a matter of law. Everyone, that was this court's unanimous finding, but that didn't deprive the need or prevent the need for a just and equitable remedy. On the contrary, it enhanced the need for a just and equitable remedy. So question one, is the blame game relevant to 172 relief? The answer is no. And none of our learned friends explained, despite spending hours on criticizing the Commission, how it could be relevant to 172. So now we come to the second question. Must a declaration of invalidity be made under 172 1A? Now, various of our learned friends, particularly our learned friend, Mr. Jamie, started by saying that there was no power to make a declaration. The court could not make a declaration in advance of the elections. It had to wait till afterwards. Or it had to wait, the suggestion was sometimes it had to wait for the Commission to breach. So what the Commission should do, was the argument, is it should refuse to hold the elections, wait until after November, and then come back to it. With respect, those arguments are plainly wrong, and they are plainly wrong for two reasons. And that's why that's the second absolutist contention, but it's the one that's plainly wrong. That's why during the course of debates with the acting Chief Justice, virtually every person retreated from that position. They had to, because it was wrong for two reasons. The first reason that it's wrong is that it's doctrinally wrong. This court is not required to wait for a violation to intervene and to grant appropriate and just and equitable relief. On the contrary, the cases say that this court sometimes has a duty to intervene in advance of a violation. And that must be right, because one's entitled to approach a court where the rights in the Bill of Rights are threatened. That's Section 38. One's entitled to approach a court in all sorts of circumstances. So doctrinally, it's just dead wrong. And that's the reason it was retreated from. And you just have to ask the question, what would happen if a week before the national elections, it turned out that the DA had been left off all the ballot papers and it was too late? Would one have to wait for the whole election to be run, the DA to get 0 votes, and then to come and challenge? Of course not. So doctrinally, it's wrong. But the second reason it's wrong is practically it's wrong, because in this case, if you accept the proposition that the impossibility, if you accept the proposition that the doctrine of impossibility doesn't apply, then the reason that we are going to have a breach of the Constitution is because the IEC made certain decisions, good, bad, indifferent, good faith or bad faith. It's because the IEC made decisions to cancel a registration weekend. It's because the minister made decisions to call the election in circumstances where there was not time for the nomination of candidates. There's a series of decisions that have already been taken prior to the launch of these proceedings. So if you need pre-existing conduct or pre-existing decisions, you've got them with respect. And so there's no need to have lengthy debates about the doctrine. It's obvious with respect that this court has the power to do so, and that's why our learned friends had to retreat. So the only remaining question on this score about whether a declaration should be made is, well, will it breach the Constitution to have an election in which at least 600,000 people are precluded from having an opportunity to register? And our learned friend for Cassac says, well, we wouldn't say that having 600,000 eligible voters unregistered negates or extinguishes free and fair election. With respect, I found that a remarkable proposition. We're talking about evidence that shows that ordinarily 600,000 voters register each time, sometimes more. So it's 600,000 likely registrants who cannot vote because there is no registration weekend. That is self-evidently, I would have thought, a breach of the right to free and fair elections. Our learned friend for AfriForum takes the same position. He says, well, it's ideal, but it's not necessary for freeness or fairness. With great respect, I don't understand the proposition. So that alone produces a breach. But of course, we know it goes further. We know it goes to the nomination of candidates problem that my learned friend addressed. We know it goes to the campaigning problem. We know it goes to the problem of people having to choose between their lives and their votes. We submit, leave aside the blame game, leave aside everything else. Once you are satisfied, and we submit you must be, that there is it's not possible to get constitutionally compliant elections in October, then there has to be a declaration of invalidity under section 172(1)(a). And we know what this court's jurisprudence says. It says, when it's faced with a breach of the Constitution, it must declare the conduct inconsistent with the Constitution. That's what 172(1)(a) says. So that then leads us to the third proposition. And the third question is, well, what is the just and equitable relief? Having decided and declared that there is a breach of the Constitution under 172(1)(a), because you can't hold free and fair elections in October, whatever the reason, whatever the fault. Having decided that, what is the just and equitable remedy? And the only coherent remedy that you've been presented with, which actually solves the problem, is the one that the Commission has offered you, which is the usual order, a declaration of invalidity, coupled with a suspension, coupled with a period within which to remedy the unconstitutionality. And that's all that it is. It's a declaration of invalidity, coupled with a suspension, for a limited period, in order to do what? In order to remedy the unconstitutionality. And so our learned friends say, well, it's a postponement, or it's an abridgment, or it's a breach. It's nothing of the sort. It is doing exactly what this court does frequently, which is it finds unconstitutional law or conduct. It declares it invalid, it suspends it, and it directs that it be fixed within a limited period. So what that means with respect, Acting Chief Justice, is that you only have in our submission one remedy, and our learned friends haven't provided an alternative or a reasonable alternative. They all scramble with respect to find alternatives. The DA says, well, you can deal with the registration weekend. The EFF speaks about the candidate nomination, but none of these solutions actually solve the problems that you're facing. And in fact, what they do, as I argued in chief, and no one really took issue with it in detail, is that they make the Commission's task considerably more onerous and impossible. The Commission is facing the first ever national election in the face of a COVID pandemic. The pressure on it is enormous. And into the midst of that, you are going to throw, if you would grant those other forms of relief, an obstacle which in ordinary times, non-COVID times, where COVID had never been heard of, would be extraordinarily difficult to deal with. Our learned friend, Mr. Bishop, says, well, have a look at August. I went and looked at August. August was about 141,000 prisoners who needed the right to vote. We are dealing here with millions of South Africans. We are dealing here with a situation where the evidence is that in a registration weekend, there are 3.5 million voters who interact with the commission at 23,151 voting stations. That you will find at page 691 to 692, paragraph 77.2 to 77.3. To compare that proposition, 3.5 million voters engaging with the commission over one weekend at 23,151 voting stations, and then propose you can publish the voters' roll the next day after that weekend. That's the proposition from the DA. You do the registration weekend, Saturday, Sunday, you publish on the Monday, when the commission's own timetable normally allows a month or two for it to get it ready. It is, with respect, a recipe for disaster. And the reason that matters is not because of the commission's convenience or because the commission wants an easy ride. The reason that matters is because it prevents the very measures which the commission has put in place to deal with this court's criticisms in Mhlope and Kham to make sure that the voters' roll is dealt with properly and that we have free and fair elections. And so with respect, the other solutions that have been offered are no solution. So could I take a step back and conclude? The three questions: does the blame game matter to 172? It doesn't. We know it doesn't. The second question: must a declaration of invalidity be made? It has to be made, because if absent the impossibility defense, there is plainly a violation, and my learned friends were driven to concede that there could be a declaration in appropriate circumstances. And then the only question is, what is the just and equitable order? And you have not actually been presented with a viable alternative to that which the commission has presented. So for all of those reasons, we do persist in seeking the primary relief, alternatively the alternative relief, and we submit that that is the relief that should be granted.
Thank you very much, Mr. Butlander. I don't think there are any questions from my colleagues. Thank you very much. It's been a long day, so we will call it a day. Judgment is reserved. Obviously, the court appreciates that the judgment should be handed down as soon as possible. We will do our best to make sure that we do not delay the handing down of the judgment for one day longer than would be absolutely necessary. Judgment is reserved and the court adjourns.
I please the court.
Thank you.
Today's proceedings have concluded. The host will now terminate the meeting.